consumers, protect fair
Where do you get
competition.
that authority?
Congress charged us with that in the FTC Act and subsequent legislative amendments.
Is that new?
Excuse me?
That authority new?
That authority stems back to 1914 and then subsequent amendments in the following decades.
We talked a little bit earlier about litigation fees, enforcement costs. Let me ask you, are you a profit center or are you an agency in charge of protecting consumers, enforcing the law, and going after individuals that may prey on our consumers or taxpayers?
We're a government agency that is using every dollar we have to protect the American people from illegal business practices.
Thank you. Let's talk about Main Street, people who sent us here to Washington. I get scam calls every day, robocalls. Seniors get robocalls every day. Veterans get robocalls every day. How are you working with the FCC to stop these calls from happening?
So we in the FCC have overlapping jurisdiction, as you noted. One thing that we're doing, in addition to going after some of the robocallers themselves, is identifying what are some of the upstream factors that are allowing these calls to proliferate. Sometimes these calls are originating from other countries in ways that can make it difficult for us to go directly after them. This is why we look at VoIP providers and other upstream
Madam
service
Chair,
providers.
a number of years ago, I had a situation in my district. We had to get Interpol involved. Calls originating from Mexico. One of the local telephone companies were providing the calling information, and it was a huge, huge mess. International, very much a difficult challenge. What can we in Congress do to help you rein in these predatory calls?
There are certainly legislative updates that we're happy to recommend to you and your team. I would say generally, given that the FCC also has authority over the telecom carriers themselves, directly taking action at that layer could also probably have a very big impact.
You know, at the end of those scam calls, you have victims, people that get hurt really bad and struggle to get that money back. What is your agency doing to help consumers get their money back?
We're bringing lawsuits where we can. Unfortunately, a couple of years ago, we suffered a big setback in court where the court said that 13B of the FTC Act, which has been a core provision that we use to go into court and get back money for people who have been scammed out of money, the court said we can no longer use that authority. That was a big setback. Since then, we've been activating other legislative authorities to make sure we're trying to get money back where we can, but there's no doubt that billions of dollars evaporated after that court decision and people are losing out as a result.
So do you need legislative help from Congress to do your job, protect consumers in this area of junk fees?
Absolutely. Legislation in particular enabling the FTC to go into court under Section 13B and get money back so that lawbreakers are not profiting from their lawbreaking, that would be essential.
I think that's important. Lawbreakers need to know there's somebody there, a police officer waiting to make sure that they follow the law. And too many times, my locals get ripped off. They call the local PD. They don't know what to do. They call the local state agency. They don't know what to do. And I hope that you and your agencies can continue to be effective in making sure that consumers on Main Street are protected. Our seniors especially, that sometimes are embarrassed to call me and tell me I just got ripped off, that don't have the energy or the wherewithal to defend themselves. These are the people we need to be protecting. I asked you if you were a profit center. I know you're not, but nonetheless, I encourage you to continue to do a good job, because my constituents, American taxpayers, are relying on your agency and doing a good job. Thank you very much. And Mr. Chair, I yield.
Gentleman yields back. The gentleman from Virginia is recognized.
Thank you. Madam Chair, you implemented the use of omnibus resolutions in antitrust investigations. These resolutions, in effect, give the chair of the FTC sole control over FTC investigations. The chair could direct staff to investigate a transaction, sign all subpoenas without a commission vote, which was previously necessary in investigations of almost all mergers and business conduct. Former commissioners Phillips and Wilson resigned over much of this type of action from you, said that this paragraph eliminated the only layer of commission oversight. Wouldn't you agree that the use of omnibus resolutions in this matter undermines the bipartisan nature of the commission model? And are you trying to turn the commission into your own personal empire?
Congressman, omnibus resolutions have long been used at the FTC before I joined. It's fairly standard for there to be omnibus resolutions on the consumer protection side, again, long before I joined. Changes we made brought the consumer protection side in symmetry with the competition side in order to empower our staff to act nimbly.
Okay, let's talk about that, because the staff has been leaving in droves. A report by Bloomberg found that 71 senior attorneys left the agency in the 2-year period between 2021 and 2022, the highest number of departures in the category for a comparable 2-year period since 2000. Coincidentally, the Progressive Change Campaign happens to have a list of 400 recommended names for positions in the FTC in the Biden administration. Has anyone, including Adam Green of the Progressive Change Campaign, communicated with you to hire any of these individuals?
No.
Okay. And have you hired any of these individuals?
No, I don't know what list you're talking about,
Okay.
to be honest.
Let's move on to this committee and your responsiveness or lack thereof to this committee. Following up on what the chairman asked, in March, your director of the Office of Congressional Relations testified before my subcommittee on responsiveness and accountability to oversight regarding your refusal to produce documents related to this committee's oversight of the FTC's harassment of Elon Musk following his acquisition of Twitter. It's well known that the FTC frequently seeks extensive information from the parties that it investigates. When those parties fail to produce what's required for the FTC to conduct its investigation, the FTC seeks sanctions. In the FTC's response to this committee's inquiry, most of what it has provided is already publicly available or otherwise incomplete. I find it inconceivable that the FTC would tolerate such a production from parties under its investigation. So what should this committee do and take from the FTC's paltry production to date on this matter?
Congressman, our team has been enormously responsive. We've been working day after day to accommodate this committee's requests. We've offered and provided numerous non-public briefings, including on the matter that you mentioned. It is true when we have an ongoing law enforcement investigation, there are additional considerations we have to take into account to make sure we're not compromising law enforcement or chilling any of the free speech of the third parties that communicate with us.
Does that include communication through non-governmental email accounts? Because in the limited materials that you provided, we can see that your staff communicated using Gmail accounts. In other instances, employees from other agencies were using the employee's email account attached to that separate agency. So you were talking about how you're committed to using government communications methods. I don't know if you're aware that your staff is not, but what steps have you taken to secure responsive material from sources outside the FTC?
Congressman, whenever anybody onboards onto the FTC, we provide extensive training to make sure everybody knows only to use authorized devices. If sometimes inadvertently there is a message that props up somewhere else, you're supposed to forward it to your FTC email, and I imagine that's why it was actually captured in those productions.
Okay, you asked Congress for a historic budget increase of $160 million or 37%, citing staffing shortages, which you're largely responsible for, and insufficient resources. Did you announce a joint effort within the DOJ Antitrust Division with the FTC to send staff to Europe to assist with implementation of their Digital Markets Act?
Congressman, we have a really fantastic Office of International Affairs that I inherited. It was launched in 2007 during the Bush administration. As part of our international efforts, we're routinely sending detailees.
Do you know how much that costs?
Excuse me?
How much does it cost to send staffers to Europe?
I don't know off the top of my head, but we're happy to provide that information if it would be helpful to you.
Okay, well, due to the rank partisanship that's come up in your agency, the fact that you all are ignoring congressional requests for information and the wastefulness that we've seen, I know that the Appropriations Committee is marking up your budget as we speak, and they are seeking a 25% reduction in funding for the FTC today. Actually, the Appropriations Committee is going to be passing that government funding bill. So actions have consequences, Madam Chair, and you're about to see what consequences your actions have had. I yield back.
Gentleman yields back. The gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman. Chairwoman
Oh, I'm
Khan.
sorry.
Oh.
I was told.
Sorry,
I
Mary
was just told that too and forgot. The gentlelady from the other side of the country is recognized from the state of Washington.
Thank you, Mr. Chairman. Chair Khan,
As head of the Federal Trade Commission, I would just like to thank you for the FTC's investigations and enforcement actions that protect small businesses and hardworking Americans and promote competition. You have done what few before you have dared to do. Few before you have had the courage to take on big corporations who use their endless lobbying money to hurt Americans with more fees, less transparency, and higher costs. You're taking on big tech and the monopoly powers that allow them to use our data and snuff out small business competitors. That was something that yesterday I got a lot of bipartisan praise for in taking on Director Wray at the FBI around privacy. You're doing the same thing, and there should be more people like Representative Ken Buck talking about that on this committee, talking about the efforts that you are making to finally put teeth into protecting consumers, and I am grateful to you. In fact, I think it's precisely because of your success, your courage, and your integrity that you are receiving all these baseless attacks on your character. So just for the record, here are the facts. It was FTC ethics official L'Oreal Pankey who owned stocks in Meta when she recommended that Chair Khan recuse herself from investigating Meta, Facebook's parent company. In contrast, Chairwoman Khan owns no stocks in big tech, not one penny, and a federal judge ruled that her stances do not constitute a conflict of interest. So I want to thank you to your integrity and your commitment to mission, which is precisely why the President appointed you to head the FTC. Now, I want to spend my time talking about your accomplishments, the FTC's accomplishments under your leadership. 1 in 5 workers are affected by non-compete clauses, which essentially means that employers restrict or ban workers in their employment contracts from freely switching jobs, just for the average person who's out there listening. The FTC is currently working on banning these non-compete clauses. Can you explain in plain language why your agency proposed this rule to ban non-compete clauses?
I'm happy to, Congresswoman. I would be remiss if I didn't know you mentioned our ethics officer. From working with her, I know our ethics officer to be a dedicated career professional who serves the agency with nothing but its best interests at heart. I understand in that instance she sought guidance from the Office of Government Ethics and acted consistently with it. On non-competes, so these are clauses that lock in workers and prohibit them from being able to seek an alternative job with a competitor for a period of time, and oftentimes geography limits. We've seen from our work that these clauses suppress worker wages to the tune of $300 billion, and they also make it difficult for startups and entrepreneurs and new businesses to enter and compete, and that's why we've proposed this rule.
And what types of workers are going to benefit from the implementation of that rule?
At the proposal stage, it would be everybody. We've heard from gardeners, journalists, healthcare workers, fast food workers, engineers, scientists. I mean, these non-compete clauses have really proliferated across markets and across our economy in ways that are now hurting everybody.
So let me turn to your work on junk fees. There are a few issues today that unite members of Congress more on the Hill, and I'm proud to say that junk fees attract the ire of both Democrats and Republicans because, as your agency notes, they are, quote, surprise charges that inflate costs while adding little to no value. So tell us how widespread these junk fees are and give us some examples of what you're talking about and how they harm consumers.
Yeah, I mean, I'm sure everybody can relate to this in their day-to-day lives. These are mystery fees that show up, be it a resort fee charge on your hotel bill or an unwanted or unnecessary charge that shows up somewhere else. One of the areas where we've heard most about these junk fees is in the auto context. Buying a car is one of the most significant financial investments that people make, and unfortunately, we've heard that all too often consumers are saddled with charges for unnecessary or unwanted or redundant fees. We're moving forward there. We also brought a lawsuit last year against Vonage for also including some of these junk fees when people tried to cancel their subscriptions. So that's just some of the work. We currently sought comment on whether we should do more work on junk fees, including through potentially proposing a rule. We're reviewing those comments and determining how to move forward.
And the FTC's got a long history of dealing with junk fees, is that correct?
That's right.
Can you talk about that?
So again, in the auto context in particular, I mean, we've gotten hundreds of thousands of complaints about this. We've brought dozens of lawsuits addressing junk fees that consumers are saddled with when trying to buy a car. But it's really, market-wide that we've seen these charges emerge and that we're looking to be actively addressing.
Well, I want to thank you for your work and hope that we talk more about some of the shared interests that we have across the aisle. Thank you. I yield back, Mr. Chairman.
Gentlelady yields back. Gentleman from Florida is recognized.
How timely. You are a brilliant woman with a tremendous ability to impact how consumers are going to interface with the digital world for a long time to come. And I want to get to those areas of agreement, but there is some ugliness we got to deal with. Now, you guys putting in the names of reporters in a correspondence to Twitter was solely predicated based on anonymous news sources, right?
It was based on reporting that
Right, and we would agree that anonymous reporting is not a sufficient predicate to target, to send letters about journalists who are your critics, right?
Congressman, yeah, I mean, the goal was third parties, but this is good feedback for us. We want to make sure we're not in any way suggesting that we're interested in, affecting journalists' work. It's really about privacy and security. So I really
appreciate your acknowledgement that that is not the way we ought to do things. As someone who has seen ugly government action emerge out of anonymous reporting, perhaps I'm a little sensitive to that, but I'm glad that you've made that acknowledgement. Let's get on to the important work that you are doing. Millions of Americans have Ring doorbell cameras. And your agency recently put out a correspondence saying, quote, during a 3-month period in 2017, a Ring employee viewed thousands of videos of female users in their bedrooms and bathrooms, including videos of Ring's own employees. There was also at Ring, according to the FTC, an unauthorized tunnel that allowed a Ukraine-based contractor to access consumer videos. An incident where a Ring employee gave information about a customer's to their ex-husband was also something that you uncovered. You also state that bad actors at Ring took advantage of the camera's two-way communication functionality to harass and threaten people who used Ring cameras. There was a case where an 87-year-old woman at an assisted living facility was sexually propositioned through Ring's two-way features. Kids were subject to racial slurs. A hacker got in and threatened a family with physical harm if they did not pay a Bitcoin ransom. And one hacker even communicated through the two-way feature to a customer that they had already killed the customer's mother and, quote, tonight you die. What is going on at Ring?
So as you noted, we recently took enforcement action precisely because of these very serious lapses in data privacy, which endangered Americans in their day-to-day lives. Overall, looking at some of these surveillance devices and how they can be misused and abused is a top area of focus for us because people's privacy is paramount.
Yeah, I thought that when people got Ring, it was to enhance their personal security, not to have their 87-year-old relative in an ALF sexually propositioned, their children to be slurred at, and then to be told that they were going to be killed if they didn't pay Bitcoin ransom. So thank you for that effort. Let's go to another evil company, Kochava. Kochava is one of these data brokers that you're going after, right?
That's right.
And the American people should know that Kochava geolocates where people go to church, and then they sell that data to commercial enterprises, right?
That's right.
That's real creepy, isn't it?
I believe most people would have that reaction, yes.
I got onto the FBI director yesterday for their creepy FISA activity, and now we have Kochava literally selling to people, oh, well, this is a Baptist, this is a Methodist, this is someone who goes to temple. Are you going to get these people and stop them?
So we have a pending lawsuit. We filed it last year. The court dismissed it. They gave us the opportunity to refile. We just refiled an amended complaint. And we think it's urgent to act here because, the types of stigmatization and harms that can stem from being able to track and sell people's sensitive geolocation information is just critical for us to be addressing.
We didn't like it when the FBI was wanting to infiltrate the Catholic churches, and I don't know that I want the data brokers to do the same. And by the way, we've even seen how the FBI is using the data brokers to do an end run around the Fourth Amendment. So I really want to encourage your work in this space, and I hope that your litigation against Kochava is something that creates precedent. And you know what? There's been criticism of some of your losses in court, but we as sophisticated lawyers know sometimes that a motion to dismiss an initial complaint can create a pathway to an amended complaint to achieve relief. And so if the laws are insufficient to stop data brokers from selling information about where my constituents worship, and if the laws are insufficient to stop Ring from these activities, I really hope you'll work with us to change those laws. And all of Mr. Buck's points are really central to this, because if Congress is bought off, if people are just coming here to beat you up over what email account you use or what trip you've been on to Europe, I think it misses these things that are far more central to the life that our constituents lead. Thank you for your work.
I would just say worse than Coach Chavez selling, it's the FBI is probably buying it. That's the scariest part. So
Agree with both.
I appreciate.
Well, let's get a bill, Mr. Chairman, to deal with those data brokers.
We're working with the gentlelady who just went right before you to do just that. That is something that I think this committee can hopefully agree on. And I neglected to mention this earlier, Madam Chair. We've been at this hour and a half. If you need a break at any time, just let us know. If not, we can keep going because we can get up and leave, but you can't. So you let us know if you need a break. With that, if you're willing to keep going, we'll go to the gentlelady from Pennsylvania for 5 minutes.
Thank you. Chairwoman Khan, I want to start by thanking you and the FTC for your work to protect American businesses and workers and consumers on issues ranging from privacy concerns to deceptive business practices to unwanted telemarketing and robocalls. To fraud and financial exploitation that targets seniors, service members, veterans, and those in recovery from opioid disorder. Those are all really important issues, and we hear from our constituents regularly about all of that. You don't have an easy job. It's not made any easier when bogus claims are levied against you in congressional hearings. Every day, some of our colleagues seem to be trying to prove the legal maxim that if you don't have the law on your side, argue the facts, and if you don't have the facts either, just argue. So we appreciate your patience in responding to a lot of fact-free questions. I want to focus my questions on hospital consolidation and the growing problem of private equity firms buying up hospitals and healthcare groups. In the Philadelphia region in recent years, we've had 2 major hospitals purchased by private equity firms, after which those firms mismanaged the healthcare functions of the hospitals, stripping them of their assets, and then either closing the hospitals or putting them up for sale. This was Hahnemann Hospital in 2020, which was closed in the middle of the COVID pandemic after a private equity-backed real estate developer bought it. That left a gaping hole in our frontline healthcare system in one of the poorest cities in the country. And then currently, the Crozier Health System is teetering on the verge of bankruptcy while hemorrhaging talented staff and medical practices after a private equity owner stripped the system of assets, undermined its relationships with medical staff, and has reduced access to medical care, particularly maternity care, emergency services, and behavioral health care. The impact on our local healthcare system has been so extreme, we've seen local Republican politicians calling for government intervention in this private equity firm's hospital business to prevent it from closing or bankrupting the system and its constituent parts. We're also seeing this troubling national trend in which private equity firms have embarked on a buying spree to scoop up smaller healthcare groups. And there was a revealing report from the Petra Center at UC Berkeley and the Washington Center for Equitable Growth detailing the trend of private equity firms buying up multiple doctor groups in a city and then using that consolidation to raise prices. So we're really concerned about this trend that's reducing access to healthcare and then raising prices. So what is the FTC's response to the call for more regulatory scrutiny over these transactions, and how can it increase oversight and enforcement activities to ensure that we preserve market competitiveness in our healthcare system?
This is such an important issue, Congresswoman, and we at the FTC, our team has done a fantastic job really addressing hospital consolidation, in particular in local markets. We've had a whole set of successes really spanning hospitals trying to merge in ways that would have hurt patients. Our staff was able to block that transaction and the parties walked away. I think you're absolutely right, though, that today we're seeing different types of strategies, including the incursion of private equity. I recently met with some emergency medicine physicians who had come from across the country who were sharing how the incursion of private equity is really harming the quality of healthcare for people in very material ways. So that's something that's on our radar. We're trying to figure out how do we update our tools to be able to address this. We recently issued some proposed updates to what's known as our Hart-Scott-Rodino form. Sounds very technical, but it's basically the information that parties have to provide us when they're looking to make an acquisition. Partly, those changes would give us more insight into some of the type of roll-up strategies that you're mentioning so that we know on day one whether a private equity firm has this history of roll-ups that should put us on high alert. So definitely something that we're looking at closely.
Okay, I've got a couple more questions on that same topic that I'll save for the next round or submit to you, but I did want to yield 30 seconds to Representative Jayapal.
Thank you so much, Representative Scanlon. I just wanted to say quickly, before I ask my question, that I was not trying to attack the ethics of your ethics officer. I was trying to point out the hypocrisy of those on the other side who raise that you have a conflict of interest and don't mention the other issues that might exist there. I just want to go to evil actors because there's one more I really want to talk about, and that is tax preparation companies. For years, Intuit, the maker of TurboTax, flooded consumers with ads promising free tax filing services, only to trick and trap them into paying, which is why taxpayers pay $250 on average each year just for the privilege of filing their taxes. So state attorney generals have won taxpayers money from Intuit, and the FTC has also taken action. Can you just speak about that?
Yeah, absolutely. So last year, the FTC brought a lawsuit against Intuit for those very types of deceptive practices that are laid out in our complaint. That is still pending, but I couldn't agree more that, claims of something being free, but then ultimately it not being so really hurts people.
Gentlelady's time has expired. Gentleman from Louisiana is recognized for 5 minutes.
Thank you, Mr. Chairman. Chair Khan, I'd like to begin with policies related to diversity, equity, and inclusion, DEI, that you've instituted at the FTC during your tenure. Last month, you implemented a so-called equity action plan that calls on the FTC's Bureau of Competition to, quote, update its case selection based on this new criteria. But allowing the Bureau to wade into picking cases based on these amorphous terms like equity is an idea that we believe is fraught with problems. You've also hired staff who have published articles on the topic of, quote, anti-racist antitrust. Can you explain to the committee what that means? What does that term mean?
Congressman, it's not a term that I've used. I can say generally, I know that there is a lot of worry that concentrated economic power hurts everybody, all communities, and that the FTC needs to be mindful to make sure that our work is focused on the harms that is affecting everybody.
Everybody, right? So anti-racism should not play a factor in competition and consumer protection policies at the FTC, right?
Congressman, we bring our lawsuits based on the law at hand. We look closely at where we might
But this is not one of the factors. Anti-racism is not going to be used under your watch, right?
There are instances in which Congress has asked the FTC to look at whether particular communities are being defrauded. In those instances, we follow what Congress has told us to do, but otherwise we just follow the general laws. That's correct.
Okay, a senior staffer at your FTC recently attended an event, gave a speech, and discussed, quote, applying a gender lens to antitrust, in which the senior staffer praised a cross-agency equity team. Are you applying a gender lens in the context of antitrust analysis now?
To be honest, I'm not really sure what that means.
We aren't either. I hope you're not using it. Okay, is there a cross-agency equity team? Was she accurate about that?
We have a lot of cross-agency teams. There are teams that are focused on how you make the FTC a better place to work, including by making sure that certain
types but equity is not in your bailiwick now. You don't have a team dedicated to that, correct?
We have a cross-agency team that's thinking about how to make sure that the FTC is
okay,
a good
she
place
just overspoke. Okay, I got it for time. Don't you think reorienting the FTC from protecting consumers to protecting favorite groups, that idea would run counter to what the FTC's mission is, right? I mean, you said it's to apply to everyone, right?
That's
you shouldn't be injecting these, I guess it's progressive policy initiatives that we're concerned about. The FTC has a really important mission, and we don't want you to get off course. Last year, on a party line vote, FTC also expanded its authority under Section 5 of the FTC Act well beyond what any previous FTC has done over the last 40 years. In November 2022 policy statement, that power was expanded to unfair methods of competition that is described as, quote, conduct that goes beyond competition on the merits, and that, quote, here's the key, even when conduct is not facially unfair, it may violate Section 5. Following that decision, Former Commissioner Christine Wilson stated, this is what she said, quote, "The commission has now created the authority to summarily condemn essentially any business it finds distasteful. That is an extraordinary power. And it's very concerning because unfair is an amorphous and very subjective term by nature. Are you using Section 5 authority to determine what is unfair, even if it's not facially unfair, whatever that means?"
Congressman, we look very closely at the text of the statutes that Congress wrote. The text of the FTC Act instructs us to prohibit unfair methods of competition. We have to take those words seriously. When putting together that policy statement, our team looked closely at decades of case law to try to understand how have courts interpreted what this means, and the policy statement reflects that.
Okay, really quickly, there's an example recently, I believe you're in the process of ending non-compete agreements as an unfair method of competition, and that decision could go into effect next year, is that right?
We got 24,000 comments on the proposal. We're reviewing them and determining how to move forward.
Would you favor a blanket ban on all non-compete agreements? Is that your position?
So the proposal bans the vast majority of non-competes with a few exceptions, one of which is non-competes that are included as part of the sale of a business.
Okay,
So
let me
that's
ask you a
the
question.
current
Have
proposal.
you ever run or worked in a small business?
I personally have not.
Yeah. So do you think it's reasonable for entrepreneurs and small businesses who spent considerable time and money developing practices to better compete against their rivals to find your ban on non-compete agreements unfair?
We'll be eager to hear from them. I know we've gotten a lot of input. The other thing I'll say we hear from small businesses is that non-competes make it difficult for them to compete. Because if they're trying to enter a market and compete with some of the big guys, but the big guys have locked up all the workers through non-competes, that hurts the small businesses. So we really have heard multiple views on this issue.
I'm out of time. Yield back.
Thank you, Mr. Chairman. Beware of that profound enemy of the free enterprise system who pays lip service to free competition but labels every antitrust prosecution as a persecution. Those words are uttered by President Franklin Delano Roosevelt 90 years ago. And I've listened to most of today's hearing, Madam Chair, and of course we're grateful that you're here today. I've listened to many of the criticisms that have been made by my colleagues of your leadership at the FTC on the other side of the aisle, not all my colleagues, but most of them. And the vast majority of these criticisms have nothing to do with your ethics or your integrity or your approach to the job, and everything to do with corporate power and the realities that you have pursued your duties as the chairwoman of the FTC in a way that puts the best interests of the consumers first. And that is a new approach at the FTC. I don't want to belabor the point because I have some substantive questions for you, but I'll ask for unanimous consent later at the conclusion of my remarks and our colloquy here for an article in the Wall Street Journal from June 30th, 2023, the headline of which is "Ethics Official Owned Meta Stock While Recommending FTC Chair Recuse Herself from Meta Case." We've spent a great deal of time hearing my colleagues talk about this particular issue. I will just simply echo the comments made by my colleague from Colorado and my friend, Mr. Buck, who I thought spoke very powerfully on this front. Only in Washington, D.C., can an individual, a regulator, who has no financial interest in the merger before her, be accused of an ethics violation by members of Congress who own financial, or have rather financial interests in the company that has petitioned for that, or is rather proceeded with that particular merger that is under review by the FTC, on the basis of an opinion that was issued that didn't conclude that there would be a per se ethics violation for the commissioner in question to proceed with considering the matter, but nonetheless opined that there would be an appearance of impropriety, and of course that individual having a financial interest in the company that was involved in the merger. And I'm not commenting, I agree with Ms. Jayapal, on the propriety of the decisions made by the ethics individual or the ethics department more broadly. I'm simply opining on the state of affairs in Washington, D.C. Because for years we've had FTC commissioners who had real conflicts of interest. You didn't have any financial interest in Meta, right?
That's correct.
You've never worked for Meta?
That's correct.
The basis, as I understand it, for the objections by many of my colleagues and others is that you have a certain view when it comes to putting consumers first and ensuring that monopolistic power does not reign supreme in our country. And I just think it's unfortunate that some of my colleagues have taken that approach. I will say for my part, I'm grateful for the work that you have done at the department. I also am grateful for the work that your partners, and of course, other antitrust enforcement regulators, the Assistant Attorney General Cantor has done over the course of the last several years. We, as you know, passed a bill on a bipartisan basis last year. It was my bill, the Merger Filing Fee Modernization Act, which I believe is going to strengthen your efforts and your ability and the efforts of your hardworking workforce within the FTC by changing the fee schedule for mergers, actually decreasing the fees for smaller mergers, but increasing the fees proportionally for billion-dollar transactions and giving you the resources that you need to fight for consumers on behalf of the American public. I wonder if you might talk a bit about that particular bill, its implementation, and the impact it will have on agency resources.
Thanks for the question, and thanks for your effort leading that bill. It was a much overdue effort to update the filing fees, and as you noted, make it clear that for larger transactions, there is a higher fee, for smaller transactions, a lower fee. We, in part, rely on those fees to be able to fund our enforcement, and so that's absolutely going to be making a difference.
Well, as I said, I'm grateful for the approach that you all are taking. I was proud to work on that bill with Representative Buck, who has been a champion on these issues, among other colleagues of mine on both sides of the aisle, and I think we look forward to continuing our work with you, Madam Chair, for years to come on this front. With that, I will yield back.
Gentleman yields back. Gentleman from Kentucky is recognized.
I thank the chairman. You know, my constituents aren't contacting me worried about mergers between tech companies or that sort of thing, but one of the things I've been contacted about multiple times is the small independent grocers feel like their monopolistic practices being used against them. And Mr. Correa and I sent a bipartisan letter to you asking for an update because in November 29th, 2021, this is 17 months ago, the FTC ordered 9 large retailers, wholesalers, and consumer goods suppliers to provide detailed information to help you study the causes behind ongoing supply chain disruptions. And I appreciate you being willing to give us a briefing, but can you brief us today? Like, what have you found? And are you going to be able to help these folks who are complaining about they can't get products or there's discriminatory pricing, not based on quantity, but based on other things or different package sizes? What can you tell us here today?
Yeah, this is such an important issue, and we've heard from those independent folks as well, and it's partly what informed our decision to launch this study. We're moving as expeditiously as we can. As you can imagine, sometimes firms don't have an incentive to give us all the information we need as quickly as we need it, but we are moving ahead full speed and happy to be providing you with the non-public briefing to share what we've found so far, and we'll be looking to make our findings public as soon as we can.
I hope that's soon. There's been 17 months since you asked them to give the information. I understand it takes them a while to get it to you, but I would hope we would get that very soon. Another issue that concerns many of us are these so-called pre-consummation warning letters. On August 3rd, 2021, FTC announced that it would send warning letters in connection with transactions it cannot fully investigate within the time provided by the statute before the deal closes. Well, now, why should people trying to do regular business be punished because it's taking you too long to do your job? And how many of these so-called pre-consummation warning letters have been sent by the FTC?
So the statute gives us only 30 days to look at a deal to determine whether we need to investigate it further. As deals have become more complex, that can be a very, very, very tight timeline. We've heard from some businesses that if we don't act within that 30-day period, the takeaway for them is that there are no issues and there are no concerns. So we thought it was important to put business on notice, to provide them clarity and transparency, that if there is a deal that we think raised concerns, but we weren't able to act within the 30 days, that we're putting them on notice about that, again, to make sure that the market has clarity on it.
Commissioner Phillips publicly suggested that within the first 6 months of this practice, over 50 letters were sent, and raised the question of whether any of those investigations actually remained open and whether this approach was simply a tactic to scare business. I'm worried that whether it's a tactic or not, that's the effect that it's having. It's having a chilling effect. And then when you issue one of these letters and then you never tell them whether the case is closed or not, kind of without doing anything, you've stopped transactions that would be helpful to Americans. I want to now yield back the remainder of my time to Chairman Jordan.
I appreciate the gentleman yielding. When the FTC attorney deposing Mr. Roque asked him to confirm that, quote, no one from the FTC directed you to reach a particular conclusion about Twitter's program, he explained to the contrary. There were suggestions of what they would expect the outcome to be. He testified that the FTC communicated to Ernst & Young. Again, Ernst & Young is the independent assessor, the fact finder that the FTC selected and made Twitter pay for, that he communicated to Ernst & Young that, quote, Ernst & Young under all circumstances will be conducting and issuing a report on behalf of the FTC order, and was very adamant about this is absolutely what you will do and this is going to occur and you will produce a report at the end of the day. The FTC was so adamant. Ernst & Young leaders feared that the FTC would take exception if they chose to withdraw from the case. So on the one hand, you're harassing Twitter, and then you're saying the guy we've selected, the entity we've selected, Ernst & Young, the accountant we've selected to be the fact finder, you better find what we want, and if you try to get out of it, we're going to retaliate against you. That is frightening. I mean, we talk about the weaponization of government, this from the same agency that said, tell us all the journalists you're talking to. That's what we're concerned about, Ms. Khan. That's what has to change. You can comment if you want, but I'm reading from the motion filed today in court. And it's amazing to me, you don't even know this guy. You don't even know who this person is, and your lawyers deposed him. He's the guy that you've set up as the fact finder, and you didn't know who he was. Did you sign off on any of those 12 letters sent to Twitter in that 10-week time frame?
Congressman, we're fortunate to have a lot of work underway. A lot of this work is delegated to the frontline staff that are able to move quickly and nimbly to make sure.
Yeah, but you're in front of Congress today. You knew you were going to get questions about this. Yeah, you don't know this. I find amazing.
It sounds like it was a late-breaking development in a filing this morning. It's not something that's on my radar. I'd be reluctant to weigh in on it in this setting without looking more closely at it. Happy to take questions for the record on it and engage later.
Not on your radar that you told, based on the testimony of this guy, that he felt there would be retaliation if Ernst & Young tried to get out of the agreement. Wow.
I yield back.
Wow. Gentleman yields back. Now recognize the gentlelady from Pennsylvania for 5 minutes.
Thank you. And before my 5 minutes, I ask unanimous consent to enter into the record what Mr. Neguse had hoped to enter. Ethics official owned Meta stock while recommending FTC chair recuse herself from Meta case. Thank you. Thank you, Mr. Chairman. Thank you, Chair Khan, for being here, for speaking with us today about the important work that FTC does to safeguard consumers and crack down on companies that would exploit them. I come from a perspective of, as a mother, as a grandmother. I care about exploitation of seniors, of children, of businesses, consumers generally. In your written testimony, you explained that FTC works to protect privacy and data security, fight fraud, including fraud related to opioid recovery, and ensure that domestic manufacturers and small businesses have a chance to compete fairly. Somehow Republicans are using this time in other ways. I apologize, I'm late to the hearing today, but I'm pretty sure I'm glad I missed some of what happened. I was in another hearing with Secretary Kerry on the climate crisis, so forgive me for coming late. I wanted to ask you about the issue around opioid addiction and abuse and what FTC is doing. I know that FTC recently returned $60 million to people suffering from opioid addiction. I know you know as well as I that the crisis, the health crisis, public health crisis in this country around the flood of opioids and opioid addiction is grave. 110,000 people died last year of overdose. That's 300 people a day. Can you tell us about your work, FTC's work, to try to protect consumers? Maybe this case, the $60 million case with Rectic, I don't know how to say that. Can you tell us about your work in that area?
Yeah, happy to. And we were, this is a newer authority that Congress gave us, and I've been pleased that we've been able to quickly put it into action. We brought a set of lawsuits using this authority to make sure that if companies are deceiving potential patients of opioid recovery facilities that we are acting quickly to prevent that deception. We brought a case against a firm called R360 because we found that they were engaging in some of these deceptive practices in ways that were harming opioid recovery patients. We recently brought another action that also noted that deception around tobacco addiction recovery is also illegal under the statutory authority. So we're working hard to make sure if people are being deceived in ways that are illegal under this authority, we're acting and we're getting the money back.
Well, I thank you for that work. I hope you will continue in a robust way. And for full disclosure, I have a son in long-term recovery, 10 years in recovery from opioid addiction. We've lost too many others to this problem, and the deceptive practices are so egregious that it's very upsetting. I wanted to move to, if I have some time, I do, good. Pharmacy benefit managers. They operate behind the scenes. Consumers don't really know what they're all about. They're a middleman in the drug market and determine patients' access to medications as well as the prices consumers pay. In this role, PBMs have the power to raise prices and are part of the reason that consumers pay 20% more than they should for generic drugs. Can you speak to what FTC is doing around the issue of PBMs and disclosure to consumers and cracking down on the price hikes?
You're absolutely right that these firms are oftentimes behind the scenes, so people are not directly interacting with them, but oftentimes their decisions are determining what medicines make it onto what's known as the formulary. And unfortunately, we've heard reports that suggest that, rebates between, the drug manufacturers and the PBMs may be keeping lower cost generics off the formularies. So what that means in practice is there's a lower cost generic out there, but when a patient is going to the pharmacy, they're not actually able to get it. They're having to pay more for the branded drug. And so, we've said in our policy statement, we are very concerned about that and are looking at it.
And yes, and how can we interrupt that? Can FTC have some rulemaking, some effectiveness in interrupting that blockage of information to the consumer?
So we're looking closely at whether, there may be violations of the FTC Act. The Robinson-Patman Act also prohibits certain types of kickbacks, I believe under 2C of the Robinson-Patman Act. So we're really laying out all of our authorities and making sure we're using them to address these issues because, oftentimes we hear from insulin patients about how they haven't been able to afford life-saving medicine potentially because some of these tactics. So we recognize the urgency of this work.
Again, on behalf of consumers and seniors and kids out there, thank you for your work and the work of your entire team. I yield back.
Gentleman from Arizona is recognized.
Thanks, Mr. Chairman. Thank you for being here today. I will say I wrote down something you said. I think I got the quote exactly right. I wrote it down because not only was it, I think, substantively meritorious, but also was alliterative. People's privacy is paramount, close quote. If only the FBI leadership believed and acted that same way, I would be happy. I want to ask you first about the EU's Digital Markets Act. You previously commented and opined in response to Mr. Klein's questioning. He asked you how much spent. I think you said you don't know. I wonder how many employees or personnel are working on the EU Digital Markets Act?
So my understanding is we currently have one employee that's detailed to Brussels. These details are routine. They've gone on for many years. They help improve, coordination among agencies for us to better understand.
Is that employee working to help implement the EU Digital Marketing Act, or are they just observing? What's their role there?
So as a general matter, when we do these details, they're focused on antitrust enforcement, enforcement of the competition laws.
This is in Europe, though. This is the implementation of a new law. So how does that impact antitrust law in the United States of America?
So these laws, as you noted, govern Europe. If the European Commission is working on implementing them, that's work that they're doing. Our work is focused on enforcing the U.S. laws. These types of details across agencies.
Right, but that begs the question, and I'm looking for I'll move on because the 5-minute format is ridiculously absurd. We can't get a full answer or full question. So I'm hoping that maybe you or your team will respond more fulsomely as to why we have someone there, even observing the implementation of an EU law that is not here, unless you're intending to support something like that here. Are you familiar with someone named Rebecca Kelly Slaughter?
Excuse me?
Are you familiar with someone named Rebecca?
Yes, she is my colleague
Yes,
of the
right there.
commission. She's here.
So I have a quote from her. Interesting. Well, glad you're here. She's called for an equity, inclusion, and anti-racist agenda in the antitrust enforcement. Yet, antitrust enforcement typically is focused on the consumer welfare standard, right? So do you agree with Ms. Slaughter, Commissioner Slaughter's call for equity, inclusion, and anti-racist approach to antitrust enforcement?
So let me say, first of all, it's just such a huge privilege to serve on the commission alongside Commissioner Slaughter. She has thought so hard about how do we make sure we're using all of our
That's
tools.
beautiful. We only have 5 minutes.
to protect
Send me a
people.
letter telling me how glad you are, please, but please respond to my question.
So she's thought an enormous amount of these issues, and I won't claim to speak for her. The way I
I'm not
think
asking you to speak for her. I'm asking whether you agree that that is the appropriate approach and when it's a de facto departure from the consumer welfare standard.
So we enforce the laws that Congress charged us with. That includes prohibitions on unfair methods of competition.
So not to interrupt, but to interrupt, you're not answering my question. My question is real specific. Do you support and agree with this new approach, which was what it would be, because it'd be a departure from the consumer welfare standard? Do you agree with Ms. Slaughter's call for equity, inclusion, and anti-racist as a basis to examine antitrust violations?
So again, we examine antitrust violations under the laws that Congress wrote.
Can you name a single law dealing with antitrust that obviates the consumer welfare standard and replaces it with an equity, inclusion, and anti-racist standard? Any statute?
The statutes
Federal
are-
statute.
The statutes are worded broadly. We look closely at the text of them as well as any case law.
Can you give me one that would facilitate obviating the consumer welfare standard and replacing it with the equity, inclusion, and anti-racist standard?
So Congressman, look, you're right, there aren't, cases on these specific questions. I will say when Congress was passing the anti-monopoly laws, they were doing so because they were worried that concentrations of economic power hurt everybody.
That's
And
right.
That's a mandate
That's right.
that we
But
have.
that's from that point of view is how the consumer welfare standard developed and evolved. And now if you were to take the equity, inclusion, anti-racist agenda and use that as your new standard, you would have moved away from statutory and case law and tried to impose a new standard. That's the point I'm trying to make, and that's the point you're not responding to. I would ask that maybe you or Ms. Slaughter even, I don't, whatever, would respond in the future so we have a chance to get to the bottom of that. And I appreciate you being here. Thank you. I yield back.
The gentleman yields back. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I do want to start by commending Congressman Buck and Gates for their comments earlier today. I was pleasantly surprised to hear the affirmative comments they made with respect to the FTC, but also legislation they're working on with Ms. Jayapal that I think is important and critical legislation that could be very useful. I kind of note that we haven't had hearings on legislation like that. We've had a lot of hearings for the weaponization issues and a lot of hearings trying to attack the Biden administration in various ways. But we haven't had any hearings on affirmative legislation that would have an impact on people in these markets. And I'm on the Antitrust Subcommittee, and I think we've had 2 hearings there. We had one Mr. Massey put together that dealt with agriculture issues. I think it was meat packing in small entities, but it wasn't as explicitly an antitrust hearing. It just so happened that the witnesses at the table noted that the big 4 companies that are dominating that industry are the ones that are crushing small farmers and running them out of business and increasing prices. But and I requested at the hearing some sort of approach that would try and address that concern, but Nothing's come back yet. And I would note this too. We've got matters pending, in the United States here before your commission or, Department of Justice. Some have been mentioned today already, the PBMs, Ticketmaster, JetBlue, Kroger-Albertson merger, the Microsoft matter that was handled yesterday. The subcommittee on antitrust has had no hearings on any of those issues whatsoever. So I know this is an oversight hearing with respect to the FTC, but it might make sense if we take a moment and have a little oversight for ourselves on what's going on here on the subcommittee. A few minutes ago, it was raised that about a subpoena that the FTC had issued, and I guess the comment was that it was overbroad. But I did want to raise this as well. The Judiciary Committee on May 25th, 2023, sent a document demand to the Department of Justice that demanded, and I'm quoting, all documents and communications between or among the Department of Justice and the Internal Revenue Service referring or relating to any investigations involving both the Department of Justice and Internal Revenue Service from May 1, 2023 to the present. Now, we'll set aside for a moment, that would include grand jury materials potentially, which of course they can't turn over based on a letter like this, even from Congress. But if we're gonna throw rocks, let's make sure we're not in the glass house, because that is beyond overbroad. And I think it's these, and this isn't, I just picked one out of many, but there's a lot of requests that this committee has sent out to the administration and in some instances to private companies, depending on whether they're on the good side of the Republicans or not. And I think we should be very careful in making sure we're using the power of the committee and the House of Representatives in an appropriate way, just like they're asking the FTC to do. And then I did want to close with this point. That's with respect to the recusal issue. That's been discussed quite a bit. And I think it's been addressed in Judge Boasberg's opinion, I thought made it crystal clear why you didn't need to recuse yourself. And in fact, he said, in judging the motions that had been filed to him, that it wasn't necessary or even appropriate. But at the same time, this committee again is ignoring one of the most obvious issues with respect to recusal and ethics, and that's with respect to the Supreme Court. We had 35 members send a letter to the Speaker and to the committee chair raising the issues, and we've all heard of them. Justice Thomas, and he's got billionaires buying property from his mother and taking him on yacht trips and the like, and Justice Alito had similar sorts of issues. We sent a letter to both the Speaker and the committee chair asking to have hearings, that we should take a look at a code of conduct for the Supreme Court justices, that we should consider whether there should be rules in place with respect to recusal for members of Congress. To the best of my knowledge, there's been no response to this letter. But more importantly, no steps that have been taken to try and address the issues that have been made very obvious by the conduct of Justice Thomas and Justice Alito. And that's just the beginning. So I would move for unanimous consent to have an op-ed from Jesse Wegman. Does Justice Alito hear himself? And then Daniel Boguzlaw, I think, Samuel Alito's wife leased land to an oil and gas firm with the justice while the justice fought the EPA. And then the letter from this dated April 17th to Honorable Kevin McCarthy and Honorable Jim Jordan, and this from 35 plus members of the House. I would ask that all of these be made part of the record.
Objection. Gentleman from California, the gentleman yields back. Gentleman from California is recognized.
Ms. Khan, there's a Wall Street Journal column written by Christine Wilson. She resigned from the FTC because of a range of concerns over how you discharge your duties. But what caught my attention was the censoring of her dissent in the Meta acquisition case. Severe disagreements around here are par for the course. I mean, we go to great lengths every day on this committee to demonstrate that. But we sort out our differences by freely exchanging our views, confident that this process will separate truth from lies, wisdom from folly. A free society depends on people knowing the difference for themselves. Censoring speech is utterly destructive of this process. Can you explain why Commissioner Wilson's dissent criticizing your conduct was censored?
So, Congressman, I couldn't agree more that that type of debate and discussion is critical. Congress designed the FTC as a multi-member commission, and we really enjoy internally those discussions and debates.
Well, obviously not, because her comments were in her dissent were censored. So why was that? How do you explain that?
So the way the commission procedures work is that I was walled off from those decisions. As the majority of the commission explained, they were identifying non-public information relating to staff analysis and material protected by deliberative process that we have longstanding FTC policy adopted during the Reagan administration that says we don't disclose that type of analysis because we don't want to chill.
Well, this was specifically criticisms of you. Did you have any discussions with your colleagues over this?
No, again, I was totally walled off from the proceeding.
So what do you see as the role of government in determining what is misinformation or, for that matter, hate speech?
You know, the FTC is focused on deceptive advertising, so I guess, you know, if a company says something is made in America, but it's actually made in China, that, from our perspective, is fraud and deceptive.
Well, you were discussing Twitter just about an hour ago. Do you see the government having any role in determining what is misinformation or what is hate speech?
We're not involved with that. Again, we're focused on deceptive advertising, like made in USA fraud, and that's really what we're focused on.
Let me ask you, what's your view of capitalism?
Excuse me?
What's your view of capitalism?
You know, the FTC's job is to promote competition.
No, what's your view of capitalism?
Could you explain what you mean by that term?
Good system, bad system, what do you see as its strengths and weaknesses?
So I think open, competitive, robust, resilient markets are critical to America's economic success, and the FTC has the honor of playing a really important role in ensuring that our markets are open and competitive and position America to compete globally.
But of course, the beauty of a capitalist system is the fact that consumers every day vote with every dollar they spend on what the economy will produce and at what prices they're willing to pay. Do you see a role in government in interposing its judgment for theirs?
The role of the FTC is really one of a referee. We believe in open competitive markets, but in order for these markets to deliver good outcomes, we need to make sure that companies are playing by the rules of fair competition. That's the job that Congress gave the FTC, and that's what we do.
Yeah, well, I think you go much farther than that, and I certainly hope that you'll take to heart the economic criticisms that you've heard today. You know, mergers, for example, generally occur when companies determine that it's going to improve their efficiency and productivity and hence their ability to serve their consumers. And that grows the economy and it helps consumers. And I'd urge you to be very careful, and your colleagues, very careful and very humble with your powers, because when your decisions harm the economy, you're also harming your administration. The average consumer might not follow the day-to-day decisions of your commission, but they know how they're doing in their own lives. And I'll yield the balance of my time to the chairman.
I'll wait, but I appreciate the gentleman yielding, but
And then I'll yield back.
Thank you. Gentleman yields back. The gentlelady from North Carolina? Okay, North Carolina is recognized for 5 minutes. Thank you, Tom.
Thank you very much, Mr. Chairman, and thank you, Chair Khan, for joining us today. And also thank you for mentioning your work on PBM reform in your opening statement. This is a very important issue for our healthcare industry and, as you pointed out, for the health of our constituents. This Congress, I've been working with a bipartisan coalition of lawmakers to address abusive and exclusionary pricing practices by pharmacy benefit managers, or PBMs. Access to affordable prescription drugs is a critical issue for all Americans, and I'm hopeful that the FTC will take substantive steps to address the ways in which PBMs take advantage of patients and providers in their pricing strategies. I know that you got a general question from Congresswoman Dean a little bit earlier, But to be much more specific, the FTC has been working on a 6B study since June of 2022. When do you anticipate completing that study, and do you have any interim conclusions or findings that you can share with us today?
Thanks, Congresswoman. As I noted, we recognize very deeply the urgency of this work because it potentially means that patients are not getting access to affordable medicines, and that, as we all know, can have life or death consequences. So we're moving with great haste. We're dependent on the companies to provide us information in a timely way. We're trying to drive that forward as much as we can in general. Historically, some of these studies at the agency have taken 4 years, 5 years. My goal is for us to be able to move more expeditiously. I should also note that if, as a matter of course, during this inquiry, we instead identified practices that we would determine are unlawful, nothing would stop us from being able to focus on some of those law violations and proceed on the enforcement track instead.
Great. And then also the FTC recently expanded the scope of its PBM investigation to include group purchasing organizations, or GPOs, that have opened in recent years. How does the FTC believe that PBMs might be using these GPOs, and what kind of harm could they have in the market for affordable drugs?
So GPOs are another one of these kind of entities that are not visible to consumers but play a really central middleman role in the market. We've sent out these additional requests because we want to make sure that we're getting a full 360 view of what's happening with these practices. I should also note, we've all read stories about major shortages of critical drugs. We've also received letters and input suggesting that the role of the GPOs may also be contributing to some of those shortages of essential medicines. So that's something that's on our radar as well.
Great. And that given that the three large PBMs are currently, currently control 80% of the market, I'm interested in how consolidation within the PBM industry affects patient access and costs. In addition to this PBM consolidation, the largest drug plan sponsors also own their own PBMs. So we're seeing a great deal of vertical integration as well. We know that PBMs set out to pocket costs based on full, undiscounted list price of drugs, so patients don't see a lot of the PBM discounts at the pharmacy counter. And we know that some health plan-owned PBMs require patients to fill prescriptions only at certain pharmacies or providers, which reduces access. How are you seeing this consolidation and vertical integration impacting patients?
Yeah, it's such a great point, and this is one of the issues on which we're routinely hearing from people. We opened a docket to kind of collect input around what people are seeing about PBM practices. We received thousands of public comments, many of them from patients who were concerned that some of these decisions about which medicines the PBMs are putting on the formulary or are not putting on is not being driven by what's best for the patient, but is instead potentially being driven by which is going to give the PBM the highest rebate. So I think that could be an instance where there's a conflict of interest between what's in the PBM's own interest and what's best for patients. So that's something that we've heard a lot about.
And final quick question. Do you see a role for Congress in this area as well, not just what your agency does?
Absolutely. I mean, this is such an urgent problem relating to unaffordable drug prices for Americans that I think it's an all-hands-on-deck moment.
Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. The gentleman from Texas is recognized.
I thank the chairman, Ms. Khan. Thanks for coming here to testify before the committee. Would you commit to me to provide all updates necessary with respect to the Live Golf PGA Tour merger and your all's looking into whatever is occurring with that?
So, Congressman, I believe it's our partners at the Justice Department that are looking at that.
The FTC is also having some look into what's going on there, to what at least the news accounts I see. But I just appreciate any updates from your office about that and the concerns about it. And I'm going to yield the balance of my time to the chairman.
Oh, thank the gentleman for yielding. Ms. Khan, earlier, and I believe the gentleman from Arizona brought this up. You said people's privacy is paramount. I couldn't agree more. And as we talked earlier, I do think there's bipartisan support to deal with that, this sweeping up of data that happens, and scarier yet is FBI purchasing that data. So that is of paramount importance. But I would say the First Amendment's of paramount importance too. Would you agree?
Absolutely.
And then the gentleman from California, Mr. McClintock, asked you, what's disinformation? And you said you don't really have an opinion on that. Is that a fair assessment of your answer?
As part of our job at the FTC, we're focused on deception and fraud and that sort of thing.
Well, you wrote a couple years ago in a law review article, digital businesses such as Twitter disserve their users by facilitating the spread of disinformation. What were you talking about there then? What's disinformation?
I'm happy to take a closer look at the material you're mentioning, but as part of our work at the FTC, we've seen how fraud and scams can sometimes proliferate on these social media websites. We've launched an inquiry to try to understand, why are some of these crypto scams really proliferating on these sites, and what can we be doing?
These are the first two sentences in the introduction of the piece you wrote, again, just a couple years ago. Digital businesses such as Twitter disserve their users by facilitating the spread of disinformation. Who decides what's disinformation?
From the FTC's perspective, it's deception, deception and fraud.
That's fine. You can keep using synonyms, but I want to know who decides that it's deception, who decides that it's fraud, who decides that it's disinformation. In this case, you're talking about social media companies and what gets posted on their platform. Who decides what's disinformation, what isn't?
So, Congressman, again, at the FTC, we're focused on fraud and deception. There is a legal standard about what constitutes fraud. Again, this is about...
But you didn't say fraud or deception, you said disinformation. And my concern is, again, and it's probably the third time I've talked about this, but the sustained attack on Twitter when the ownership there changed and the platform was committed to not taking down speech, not taking down posts, allowing the sharing of information, and not censoring information. And we just had a major decision last week from a court in Louisiana, a federal court in Louisiana, where they said the government was, in fact, pressuring big tech companies to censor, and big tech companies were willing to go along with it. Now we have a change there, and you're going after the one company that's changed how they're doing things. That's what concerns me, particularly in light of the fact that you just wrote about this a few years ago, saying this is what goes on.
Congressman, I'm glad to have the opportunity to clarify some issues here. So we at the FTC have no view on who should or should not own a company. All we care about is that the company is following the law. That's really what our focus is.
We've covered that ground. I want to know about disinformation and who decides what's disinformation. You think the government should decide that?
Congressman, the way I see it is concentrations of economic power, including over speech platforms and communications platform, that it's that concentrated power and the ability to pick who gets heard, who doesn't get heard, to make these types of decisions. That, I think, is concerning to all of us, and the FTC's job is to be promoting...
You know what kind of speech was getting censored? Do you know what the court said last week? Have you read the opinion, by the way?
I have not. It did not concern the FTC.
You know what kind of speech was getting censored? You know what the court said? Conservative speech. Conservative speech was all, the suppression was virtually all conservative. This is not Jim Jordan talking about, this is not Republicans on the Judiciary Committee talking, this is the federal judge who had the facts, 86 pages of facts, and laid out, put the facts and the law together in this opinion, strong opinion, which said it was a conservative speech that was getting censored and labeled as disinformation.
So, Congressman, I fully understand why, given the extreme concentration of power over some of these speech platforms, why people would be afraid and worried about censorship. I couldn't agree more that when you have a handful of people making decisions about what gets seen, what doesn't get seen, who gets heard.
And you think the remedy to that is for government to decide what's disinformation and what's not?
Congressman, at the FTC, our job is to promote competition. More competition means more people making these decisions, and I think that can alleviate some of the concerns about censorship that you're sharing.
Gentleman's time has expired. Chair now recognizes the gentlelady, is Georgia? Or, yes, okay. I didn't know who had walked in first, or how we going? The gentlelady from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. Good afternoon, Chair Khan. It's a pleasure to have you before us today. I have read your testimony. Thank you for your time and your testimony. Ensuring that emerging American businesses have an opportunity to grow and to thrive is essential for our economy. And one of the most of American of practices, so to speak. America is a country that is built on the success of creative and innovative ideas. The determination of grit, of its people is so vital, and the endless opportunities of its society. And for these reasons, we must do all that we can in our power to support competition, as you just mentioned, and fight monopolies which crush American opportunities. A robust antitrust framework supports small businesses by helping to ensure that they are not intimidated into conciliation. It empowers the American people by allowing them freedom of choice in the marketplace. A robust antitrust framework strengthens American workers against monopolistic efforts to lower wages and eliminate their benefits. That is why it's so wonderful to have you here today. Thank you so much for being here at the helm of the FTC. You have actually been a champion of enforcing America's antitrust and competition laws for years, and America's economy is much stronger for it. And in fact, the U.S. has the highest post-pandemic growth of any nation in the G7 and the lowest inflation, with a historic low unemployment rate of 3.7%, and that must be noted here today. As I spoke on earlier, enforcement of antitrust laws helps to promote fair competition across the United States economy while protecting consumers and workers from deceptive and unfair practices. Balancing competition and effective antitrust enforcement are critical to protecting our consumers, our workers, innovation, and economic equity in this country. Over the past 20 years, the U.S. has seen consolidation across all markets, whether it be in a nursing home industry, tech industry, or agriculture industry. Can you please comment on how this is applied in the context of large mergers that affect smaller competitors in the marketplace?
So, Congresswoman, when we see mergers between two large firms, especially if they're competing in the same market, that can make it more difficult for newer entrants to come into the market. We've seen how entry barriers can be raised, and independent firms, small businesses can have a difficult time really competing on a level playing field if the merger is leading to market power that allows the merged firms to get special types of terms or discriminatory benefits that are not available to others.
Thank you. So these past two terms, Congress has actually been examining the role of big tech companies and their exercise of market dominance, which has allowed them to make a profit and to leverage their gatekeeper power over small or new companies and competitors. Can you talk about the steps that you are taking to ensure smaller companies, especially in the tech marketplace, get a fair chance to compete against bigger, more entrenched companies?
So the FTC has been looking closely at digital markets since before I joined the commission. One of the first actions that we took when I joined was refiling the FTC's amended complaint against Facebook, where the FTC is alleging that Facebook's acquisitions of Instagram and WhatsApp were anti-competitive and really helped Facebook maintain its dominance in ways that locked out rivals and really hurt consumers at the end of the day. We're continuing to look closely at mergers and acquisitions to make sure that if we worry that these acquisitions are similarly going to create dominance and allow firms to maintain their monopoly, that we're acting swiftly there.
So under your tenure, FTC has endeavored to restore meaningful antitrust law enforcement over the last 2 years. And in this process, the FTC has made some powerful enemies. Have you not? Yes, you have. I can answer that for you.
A lot of folks, yes.
So isn't the lesson learned here that antitrust agencies should trust vigorous competition and antitrust enforcement to deliver innovation and better services rather than enabling entrenched gatekeepers to continue growing through acquisition in markets?
Absolutely. I think America's history shows that when we promote fair and open competition, that's what best produces innovation and allows us to succeed.
Thank you, and I'm out of time.
Thank you. I recognize the gentleman from Wisconsin for 5 minutes.
Yeah, thank you very much. I'm not going to take 5 minutes. I'm just going to take a real brief time here. We heard some of the same pablum yesterday. I don't have a question for the witness, but we heard some of the same stuff from the FBI yesterday, that, boy, we respect the Constitution and all the rest. And, but nonetheless, they are ending up censoring the American people. And it was so interesting to hear yesterday when the director of the FBI was here, and he said, well, these companies work within the free market. We can't change how they go about operating. But when you have a federal agency, whether it's the FBI or the FTC, that comes calling at your front door, and they say, gosh, maybe you should be doing things a little bit differently, they pay attention. And I would use the example of the man who originated Facebook. He said on a podcast in the last year that in regards to the FBI, when they come calling, you're going to pay attention. And censorship happens from there. And I hope that you are cognizant of that as you go about doing your business. Second thing that I would say is that we talked about, entrenched gatekeepers and stuff like that. The barriers to entry that have been built here in Washington, D.C. over the last few decades are significant. And I would go back to two major bills that are over a decade old now. One being Obamacare, the other one being Dodd-Frank. We see probably the least entrepreneurship that has happened in the healthcare and finance banking industries that we've seen in decades, because the barriers to entry are so high. And I sure hope that you will respect that you, while building these regulations out here, while passing laws as happened over a decade ago in regards to Obamacare and Dodd-Frank, it has harmed the rest of America. It's harmed entrepreneurs. It's harmed Main Street America when they no longer have a bank, with their bank being consolidated into something that's bigger. So you may say that, boy, we're going to go after these big companies. Well, hell, we created them here. And I hope you won't participate in creating additional barriers to entry so that entrepreneurs cannot participate in the free market society that was built in the United States of America over the last nearly 250 years. I'll yield back.
Thank you. A couple questions I had. I just wanted, using a little bit of this time there. The gentleman from Georgia mentioned that he thought you were being treated unfairly, if you remember at the beginning, I guess about an hour and a half ago, and differently because of your ethnicity and because of your color. Do you believe that's true?
Congressman, I'm focused on really
I know you are,
answering
but just...
diligently the questions you all are asking. I won't.
I know, but I'm just curious. Do you believe that's true? Because if you watch the hearing, I was offended by it, to be honest with you. If you watch the hearing yesterday, we gave a gentleman a pretty thorough raking over, asking some difficult questions. And I hope that you know it has nothing to do with ethnicity or color. And I hope you don't feel that way. And I was wondering if you do. It's a yes or no.
Point of order.
Yes.
Oh, Mr. Chair, just wondering whose time we're using right
He
now.
yielded back his time to me.
Okay,
And he had
thank
time left over.
Oh, thank you.
Mr. Tiffany. Yes, go ahead. Just give me a yes or no. Do you think you're being treated fairly?
It sounds like there's a robust debate among the committee about these issues, and I defer to you all.
Well, one of the things I'd love to change is that when we ask people to say yes or no, they would. It's so hard when people come before us. And I just wanted to say one other thing, too, and then we will move on. Robocalls. I know you heard about them today. It's a really big deal. You want to talk about a way that you're affecting people's lives. They are sophisticated, they're scary, people are getting in trouble because of them, and everything from Social Security to buying timeshares. It is a really big problem. I would love to, and I'm going to speak to Mr. Correa, I would love to work with him across the aisle, love to work with whomever to do something about that issue. I have other questions for you later, but at this point I'll recognize the gentlelady from Missouri.
Thank you. St. Louis and I are here today in strong support of the rights of workers, of consumers, small businesses, and the broader public to be free from corporate greed that monopolizes our access to information and treats employees and communities as expendable. Thank you for being here, Chair Khan. I appreciate your service as a staffer on this committee, your groundbreaking scholarship on antitrust law and anti-monopoly issues, and your record of accomplishments as FTC chair. The Commission has an important role to play in protecting our economy from the harms caused by greedy, reckless corporations that put profit and power over people. Look at big tech, big pharma, big oil, and any other concentrated industry. These companies and the profit-obsessed executives behind them have abused their power for too long, and it's time that they be held accountable. So we absolutely need to level the playing field for workers and consumers. The FTC can and is trying to help under your leadership, and I appreciate that because it makes a real difference in communities like mine. For example, in recent years, FTC lawsuits have resulted in more than $33 million provided to more than 178,000 Missourians. In 2020 alone, the FTC provided $8.6 million to people in Missouri, including St. Louis. That's real money for real people harmed by corporate greed. It's food on the table, it's a roof over a head, it's clothing for a child. Another example is the FTC's proposed rule to ban non-compete agreements. Chair Khan, as was brought up earlier, banning non-compete agreements is estimated to raise wages by over $200 billion each year and to close racial and gender wage gaps by up to 9.1%. Is that correct?
Congresswoman, as we laid out in our notice of proposed rulemaking, those are some of the estimated effects, yes.
Thank you. It's a lot of money in the pockets of workers and Black and brown people and women in particular. Can you explain specifically how banning non-compete agreements means workers will get paid more?
So what our staff did is they looked very closely at the empirical evidence that has now surfaced in light of the different state policies that we've seen. And what we've seen is that states that have limited non-competes are able to ensure that workers are moving them around more freely, though unfortunately we still see that all too often companies are still trying to include non-competes. What we've also seen is that being able to switch jobs, being able to move freely between jobs and get better job opportunities is a key mechanism that workers have to use to be able to get higher wages and better employment opportunities. When you freeze workers in place, when you lock them in place through these non-competes, that means that they're not able to go across the street, even though the firm across the street is offering them better wages or better working conditions, and that's bad for workers.
Absolutely. Thank you, and that's a real impact that will save lives. But Republicans don't like this. The party that is in the pocket of white supremacists and wealthy corporations will talk a big game about fighting for everyday people and then show up to Congress and do whatever their corporate donors want them to do. That's what these attacks, that's what this is about. So let me be clear. There is nothing unethical about standing up for workers, consumers, and small businesses. There is nothing unethical about enforcing the law against powerful and destructive companies like Amazon, Meta, and Twitter. There is nothing unethical about putting your principles into practice. But what's unethical is being apologists for the corporate greed that is fleecing our communities. What's unethical is claiming to care about workers and then selling them out. That's the real ethics scandal here, and we need not forget it. The bottom line is that the corporate monopolies are a recipe for social destruction. Any lawmakers who claim to stand for workers and consumers must advocate against dominance by large private companies that care more about profit than people. We need to aggressively enforce our antitrust laws for the purposes Congress intended, and we also need to move beyond the digital economy dominated by billionaire-owned for-profit companies. Chair Khan, you have never tried to hide who you are or what you believe, and I admire you for that. I thank you for your leadership, and I look forward to working with you and your agency on these critical issues. Thank you, and I yield back.
Thank you. I recognize the gentleman from North Carolina, Mr. Bishop.
Thank you, Mr. Chairman. Ms. Khan, is this working? Doesn't sound, yeah, I guess I hear it. Someone pointed out to me that just this morning the FTC, well, it was disclosed the FTC sent a civil investigative demand to OpenAI. Are you familiar with that?
Congressman, this involves non-public information, but if it's been publicly reported, then it may be accurate. But I'm hesitant to share anything non-public in this.
It's on Twitter, and it seems to be asking, among other things, for whether Chat GPT or whatever other products they have would generate statements about persons. Can you explain the gist of that, or what is the regulatory authority of the FTC that civil investigative demands being issued under?
So as a general matter, some of the concerns that we're seeing in this AI space is that ChatGPT and some of these other services are being fed a huge trove of data. Right. There are no checks on what type of data is being inserted into these companies, and we've heard about reports where people's sensitive information is showing up in response to an inquiry from somebody else. We've heard about, libel, defamatory statements, flatly untrue things that are emerging. That's the type of fraud and deception that we're concerned about.
So as a general proposition, and you just said something, you spoke to libel and slander or defamation issues, and I'm going to come to that because that's an issue of state law as I understand it. But is your regulatory reach there defined by, the FTC Act? Is that the basis under which you guys investigate that stuff with a company like OpenAI?
So it's absolutely true that we don't directly address those things. We're focused on, is there substantial injury to people?
Yeah.
Injury can look like all sorts of things.
So and you were speaking earlier in communication with the chairman or your colloquy with the chairman about the Twitter background of releasing private information. Was that also subject to your regulatory reach under the FTC Act because it was somehow deceptive? Or is there some other statutory source that generally puts you guys in charge of, sensitive information about people?
Yes, it's the FTC Act that prohibits unfair or deceptive practices and unfair methods of competition. That's primarily the authority we've used in these instances.
Okay, and that, that's interesting. And just for the people in the public, the operative language of Section 5 that you guys, I think, are using there and in the context of the non-compete rule that you've come out with, it just says, unfair methods of competition in or affecting commerce and unfair or deceptive acts or practices in or affecting commerce are hereby declared unlawful, right? That's the language?
That's right.
Yeah. And so it's not really very detailed. Let me ask you for a minute about the non-compete rule. So you guys have this proposed rule you're seeking comments on, administrative process, then once those comments are reviewed, you guys will decide, the FTC will decide whether to proceed with the final rule. Is that the way it works, basically?
That's correct.
And so in that case, I litigated these kinds of contracts in state law for 30 years and in North Carolina. I know California has a rule that absolutely bans them. They're different renditions of law, some statutory, some made by the courts over time in states all over the country, and there have been for a long, long time. So what your rule would do would displace all of that state contract law in one fell swoop if it were made final, wouldn't it?
It would create a new floor, yes.
It would create a what?
It would, yes, it would be creating a new provision that would be determining that these non-competes are ruled unlawful.
So you would not only, and it would be per se. I know some of the stuff stated in your notice of proposed rulemaking that I've glimpsed said it would be, that you saw these as inherently coercive or the product of unequal bargaining power, but the rule would be per se, except for a very narrow category, and the overwhelming majority would be per se, even if the people involved in those contracts wanted to make them, right?
That's the proposal. We did ask as part of our notice of proposed rulemaking some questions about whether there are adjustments we should make.
And I don't want to get into the minor details because we've only got about 30 seconds left. Let me just ask you this, because if you take that example, or many of the others have been talked about. You spoke a moment ago about being concerned about concentrations of economic power. I get that. Isn't there a basis to be concerned about concentration of legal power, law-making power? So you got 30,000 state judges have made those rules. You got 7,558 state legislators. You got lots of members of Congress. You got multiple chambers in Congress. The fact that you really, as the bare majority on the FTC, could make such a ruling, isn't that something that Congress should be concerned about, how much power you wield?
So we make these determinations pursuant to authority that Congress has given us. When we promulgate rules pursuant to the Administrative Procedure Act, there are a whole set of procedural protections that go into play relating to the comment periods that we have to use to get public input. There are certain standards of review for judicial review. There are so many checks as part of this process, and it's really quite regular for administrative agencies to be engaging in rulemaking.
But you get to say what's unfair, right?
So interestingly, Congress, when passing the FTC Act, was having a debate. They said, should we actually define, should we list out in the statute all the practices that should be unfair? And Congress determined, businesses are so innovative, they'll find ways to do an end run around any of the practices we list. Let's allow the FTC to use their expertise to make sure that as markets are evolving, as business trends are evolving, that they can make sure that their statutory authority is keeping pace. So this was a determination and a decision that Congress made to use that language, and we follow the text of the law.
Thank you, ma'am. I wish I had more time. Yield back.
Recognize the gentlewoman from Vermont.
Thank you, Mr. Chair. Before I begin my line of questioning, I just want to make note of something. Our Republican colleagues have touched a few times today on the words of a third-party auditor who was deposed as part of the Twitter lawsuit. And I think it's really important to point out, for the sake of transparency, that this deposition was filed last night, and here we are talking about it today. I believe in coincidence, I really do, but that's a pretty lucky coincidence that that evidence supposedly providing the Republican accusations today was released in such a timely manner. So I think it's really important to make note of that. Chair Khan, thank you so much for being here. Thank you for being here to the bitter end. I really appreciate your testimony this morning. I'd like to touch on a extremely timely and controversial issue, which is artificial intelligence. And specifically, I'd like your thoughts on generative AI and competition. It's tough to imagine online platforms gaining even more power, but it seems that big tech firms who control their own AI systems and access to cloud data are in a position to do just that. And I find that alarming, as do many of my constituents back in Vermont. So what I'd like to ask you is, how could AI technology lead to an even more consolidated internet landscape with even fewer choices for consumers?
So Congresswoman, let me say first of all, these moments of technological disruption, when you have these game-changing technologies enter the market, these moments oftentimes provide a lot of opportunity for disruption and for displacing some of the existing incumbents and giants. And so there's always a chance that that'll be the effect. I think you're right that with these technologies, we see inputs required here that really favor dominance and favor scale. So, you need huge amounts of compute, you need access to huge amounts of data, the models. Our staff recently published a blog post laying out what some of these competition concerns could be. But I think you're absolutely right that we all need to be very vigilant to make sure that this potentially transformative technology is not further consolidating market power in ways that could really harm competition.
And how would a firm use AI and cloud access to illegally expand their market power? What would that look like?
So, I don't want to engage in hypotheticals, but, the types of, as we lay out in the blog post, traditionally the types of concerns that you might have is if firms with market power are conditioning access to one set of technologies and critical inputs on firms having to also buy other services, those types of tying agreements, and especially when they're having an exclusionary effect, can be concerning under the antitrust laws.
And are you concerned about this issue in relation to the digital markets?
In general, we're very concerned about competition in digital markets, yes.
Okay, and my last time here, I also wanted to touch on another issue, which is dark patterns. Amazon Prime has reached a point where it's practically impossible to avoid. FTC recently took Amazon to task for using a series of digital tricks or dark patterns to enroll people in Prime without their consent or to prevent people from canceling their subscription. And this is something that I hear a lot from my constituents about. Last year, the agency reported that, quote, more and more companies are using digital dark patterns to trick people into buying products and giving away their personal information. How common is it for online companies to use these dark patterns?
Unfortunately, through our work, we've seen that it is too common that we see companies using these tricks. Our staff published a report going into detail about the different types of dark patterns that we see, which in practice end up tricking or manipulating people into making choices that they're not really seeking to make. And so we want to make sure that we're fully grasping how these dark patterns are working. We've been bringing on board a whole set of technologists that are able to kind of dig deep, look under the hood, figure out what's really going on. And so it's going to continue to be an area of focus for us.
And something that you said there really struck me. It is essentially about taking away people's choice. When you're not transparent about the ways in which consumers are being entrapped into signing up for something or not being able to cancel something, that is taking away their ability to vote with their dollars, essentially, which is something we've heard about in this hearing today. What effect does this then have on competition and privacy and innovation, just briefly?
So we want to make sure that companies are competing on honesty. We don't want honest businesses to lose out to firms that are engaging in dark patterns and these types of, deceptive practices. So there's a consumer protection dimension to it, but as you noted, there's also a competition dimension.
I really appreciate that. Thank you. I yield back.
Thank you. I recognize the gentleman from Oregon.
Thank you, Mr. Chair, and thank you for being here today and for your patience. I disagree with the bitter end phraseology that was used. I think the entire conversation has been extraordinarily interesting, and I appreciate your being here to share your thoughts. I'll set this up with a standard question. Do you agree with the following statement from former Commissioner Wilson? The agency lacks the expertise and in some cases the jurisdiction to pursue the additional societal goals embodied in the strategic plan. And jumping just to the phrase unwarranted health, safety, and privacy risks. I'm actually looking at the plan right now. For example, unwarranted health, safety, and privacy risks. Tell me how those became part of the focus of the FTC, because that seems to be an expansion of what the FTC used to focus upon. Or maybe I'm wrong, but that's not my question to set up, my first one.
So I think you said unwarranted safety, health, and privacy risks, is that right?
Yeah, actually, I'm just reading from the FTC focuses on investigating and litigating conduct that causes or is likely to cause substantial injury to the public. This includes not only monetary injury, but also, for example, unwarranted health, safety, and privacy risks.
So the statute says that an unfair practice is one that causes, one of the prongs is substantial injury. Substantial injury is not defined, but for years now, the FTC has interpreted that and courts have ratified that to mean not just monetary harm, not just losing money, but certain types of harm to wellness and safety and health. So some of the deceptive advertising cases.
Are you referring to courts? Is that where you said that?
That's right. And
okay,
recently,
so just because I want to move on,
sure.
If you could provide me with the cases that you're referring to, please, so that I can see the courts that you're relying upon for that effort. Now, let me slide that aside and let me go to the next issue. This is one, of course, that you brought up in your famous paper, the Amazon Antitrust Paradox. And the issue is, and forgive me, I'm not an expert in this space. I didn't even take this class in law school. So my question, antitrust, so my question is, what if not the consumer welfare standard, what standard? And I'm basically lifting this right out of Bork's book, about 25 hours I'll never get back, that I want to spend reading it. And my question to you is, if not that standard, what standard are you going to apply? Or do you still apply just that sole standard in determining the challenges that bigness creates?
So we applied the text of the statutes that Congress passed, and we look closely at the language in the statutes that Congress passed, consistent with legal precedent. There are some case holdings related.
If I may,
Yep.
if I recall correctly, before Bork's learned treatise, there was a mishmash of legal precedent. You could select among almost any standard. That's one of the reasons he was so clear in stating what he thought would be the proper standard, and that is the best for the consumer. So I'm asking you, if you're going to move away from that standard, which he so artfully articulates in his book, what is the new standard?
So we're focused on the law, including the case law,
Wait. I just pointed out that before Bork, there was any number of standards. Just grab one. So when you say you're looking at the law, which law?
The Sherman Act, the Clayton Act, the FTC Act,
So those
the
are extraordinarily, they were written to be very broad and to give you the power to try to control this economy that we've got. Bork went in and tried to find some sort of a standard against which you could measure your actions. And his ideas were accepted. I think your article, you know this way better than anybody in this room. So my question is, what's the new standard? Please don't take me into the law, and don't do that. Tell me what do you have that's better than what Bork suggested?
So in instances where the Supreme Court has said, for example, that the Sherman Act should be interpreted consistent with consumer welfare, of course we look closely at that. But the Sherman Act is not the only statute, right? For the FTC, we're charged with prohibiting unfair methods of competition. And I think it's incredibly important for us to honor Congress's intent in creating multiple...
Wait, stop. You're a lot of generalizations. What's the standard that you are suggesting to take the place of the consumer welfare? What's your standard? Please don't give me generalizations.
So the standard depends on the statute that we're enforcing, because each statutory scheme is slightly different. When we're enforcing the FTC Act, the words of the FTC Act are unfair methods of competition. That's the standard we're enforcing. We laid out a policy statement last year that laid out in very clear, in great detail, what that standard means, reflecting a century of case law. So
I'm out of time, but I will look at your explanation, and I appreciate your time here today. Thank you.
We are going to take a 5-minute recess, and we're going to strictly adhere to that. It will be 5 minutes.
You said, quote, we do things to make sure that the market has clarity. To make sure that the market has clarity was the quote I wrote down from you. And I was glad you brought that up, because the Second Circuit, as you said of the FTC, quote, the commission owes a duty to define the conditions under which conduct would be unfair so that businesses will have an inkling as to what they can lawfully do, rather than be left in a state of complete unpredictability. But by moving away from the consumer welfare standard, I would posit that the FTC has effectively created a moving goalpost standard. And Mr. Bentz pressed you on that with several questions, and you just said, well, basically, it kind of depends case by case. We're going to look at different laws. Is that effectively the summary of what you said and the guidance that was provided last year in the policy statement regarding the scope of unfair methods of competition under Section 5 of the FTC?
So Section 5 of the FTC Act is a different statutory scheme than the Sherman Act, and so we look at case law that's specific to Section 5 and specific to the FTC Act when interpreting that provision.
With respect to that November 10th, 2022 dissenting statement of Commissioner Christine Wilson as it relates to that Section 5 of the FTC and the policy statement, she stated this, quote, unfortunately, instead of providing meaningful guidance to businesses, the policy statement announces that the commission has the authority summarily to condemn essentially any business conduct it finds distasteful. Did it concern you that one of the commissioners would issue such a statement and reach such a conclusion?
So the benefits of having a multi-member commission is that we can have that discussion and debate and disagreement, and we always take seriously input that we're getting from other members of the commission. As you'll see in the policy statement itself, it reflects decades of case law that our team took a very close look at to make sure that we were hewing very closely to this text of the statute as well as the relevant precedent.
With respect to the early terminations issue that Mr. Bentz talked to you about earlier, I sent you a letter earlier this year about that issue, and you wrote in response that granting early terminations consumes agency resources. Can you explain how reinstating the early terminations diverts agency resources?
Sure. So our staff is reviewing merger filings. They're in the process of litigating. They're investigating. When they are looking at the HSR filings, their primary goal, our statutory mandate, is to be identifying transactions that may violate the Clayton Act or any of the other antitrust laws. granting early termination is a discretionary function, and so we decide to put resources towards the mandatory functions in the statute over the discretionary ones.
But for years, that early termination policy allowed the FTC to allow mergers and acquisitions of a small size or a size where there was really no competition issue really presented for you to go ahead and give surety to those businesses that they could proceed with those mergers and acquisitions. But that's no longer the case in the FTC, right? You're holding businesses in limbo because you're giving them these letters and saying, well, we're going to look at it. We're not sure. But then businesses have trouble moving forward with those mergers and acquisitions because sometimes the financing's tied up in the time frame that they need a quick M&A. Is that true or is that untrue?
So Congressman, the context here is we're talking about 30 days. 30 days that firms have to wait before they're able to consummate if they don't hear from the agencies. In the past, maybe firms would have gotten early termination on day 25. Now they're not getting it, but after day 30, they're able to consummate. So we've decided that as a matter of where we're allocating our resources, it's a better use of resources to be identifying which transactions may be creating problems for consumers, for workers, for honest businesses, rather than prioritize the kind of 5 days that firms may have gotten in the past.
It seems that a lot of the resources, when you talk about allocation of resources, have been going towards new rulemaking in the FTC rather than actually working through some of these issues that you guys are looking at, some of which you should be looking at, some of which you probably shouldn't be looking at. Is that the reason why in 2020 the FTC brought 31 challenges to mergers, which was a 2-decade high, but in 2021, the year you became chair, the FTC took only 15 actions against mergers, and in 2022, only 17 actions? Is that because you're focused too much on rulemaking and all your resources are allocated in that direction?
So there are no real, I mean, we're proposed a rule to update the HSR form in the Bureau of Competition, but aside from that, the vast majority of resources are focused on enforcement. I think some of those numbers you mentioned are outdated. Our team would be happy to provide you with updated numbers. Our enforcement is squarely in line with prior years.
Thank you. I yield back.
The gentleman yields back. I recognize Mr. Hunt from Texas.
Thank you, Mr. Chairman. Thank you for being here, man. Really appreciate your time. I know it's been kind of a long day. First question for you is, on July 13th, 2022, the FTC proposed the Motor Vehicle Dealers Trade Regulation Rule. Are you familiar with this rule?
Yes.
Okay. Did the FTC conduct a cost-benefit analysis for this rule and determine what cost of implementing this rule might be? And what did the cost-benefit analysis conclude, if you can recall?
So we did have to conduct that analysis pursuant to the Administrative Procedure Act, and the notice of proposed rulemaking lays out some of that preliminary analysis.
Any idea on the cost?
I'm not recalling off the top.
Okay. I'd like to ask for unanimous consent, sir, to enter this into the record. This is a research study that's done by the Center of Automotive Research, which conducted a full cost-benefit analysis of this rule and determined that the rule would impose a cost of $38 billion with a B over the next 10 years. Are you familiar with that at all?
That objection.
Thank you.
This is a study done by some outsiders, you said, or this is the FTC analysis?
No, this is actually an outsider, the Center of Automotive Research.
I'm not familiar with it. I know we got a lot of comments on the rules, so our teams are looking at those closely, and maybe this was one of those.
So what we'll do is we will send this to you. I would implore you to take a look at it, and now that you have a copy of it, I would love for you to reconsider that burden and that cost that it would actually place on the American people, if you don't mind.
Happy to. I mean, I will say generally, the auto rule that we've proposed is designed to address junk fees, bait and switch tactics, some of the harms that consumers time and time again have been encountering in these contexts. We've received over 100,000 complaints from consumers over the last few years relating to some of these deceptive practices in the auto purchasing context. So that's what our rule is really designed to address.
Okay, understood. And I think this is kind of what our goal is, to make sure that we prevent any undue burden on the American people. Obviously, the issue that you just addressed, and also most importantly, just cost, because right now we as a country are suffering immensely with inflation, everything that we've been seeing. So I want to make sure that we do protect the American voter here in this country. Switching gears, the FTC has made a mandate protecting consumers and their privacy. Under that mandate, do you think it's appropriate for the FTC to compel a company to collect and retain consumer data, including their personal identifiable information?
Is there a particular context you're thinking about, Congressman?
There is a
It's hard to
particular
say.
context, but I'm just kind of wondering what your overall feel of this issue is. I can't exactly say who asked this question for their own anonymity, but I was just wondering what your overall feel is about including their data that has their personal information in it as the FTC.
Overall, the goal of our data privacy and security is to protect the privacy and security of Americans' data. What ultimate remedy or relief we're seeking is generally speaking designed to minimize the data being collected. I'm not sure what specific instance you're referencing.
I understand. And last question. Do you think it's appropriate to suspend the collection of this data in the name of protecting consumer data as a whole?
Again, would be happy to look at any specific matter that you're considering, but a key goal of some of our recent privacy work has been data minimization to really limit what data is being collected in the first instance, because we've seen that that's the best way to minimize risk of privacy breaches and security breaches.
Thank you very much. Thank you for your time. I yield back the rest of my time.
Gentleman yields. Recognize the gentleman from South Carolina for 5 minutes.
Thank you, Mr. Chairman. Ms. Khan, thank you for being here. I know it's been a long day. You know, the FTC's mission is to protect the public from deceptive and unfair trade practices and from unfair methods of competition. Even on your website, the FTC's work to protect consumers and promote competition touches the economic life of all of us. I'd say the FTC is charged with a very important mission and have for a long time. A Bloomberg report recently found that 71 attorneys left the agency in a 2-year period between 21 and 22. This is the highest number of departures in 20 years. That being said, it's pretty tough, I would imagine, to protect the American consumer and promote competition when your staff is leaving. As you know, Congress receives federal employee viewpoint surveys, or FEVSs, to inform us on how agencies are functioning. In 2020, 87% of FTC employees agreed that senior leaders maintain high standards of honesty and integrity. And in 2 years, that dropped from 53%, and also in 22 to 49%. Similarly, in 2020, 83% of FTC employees agreed that they have the highest level of respect for FTC's senior leaders. Again, in 21, that dropped to 49%, and in 22 to 44%. In 2020, again, 80% of FTC respondents agreed that senior leaders generate high levels of motivation and commitment in the workforce. Under your leadership, that has dropped to 42% in 21 and 36%, alarmingly, in 2022. So I think my question, quite frankly, is why is it so unpopular to work at the FTC?
So we have fantastic career staff who day in, day out are fighting for the American people and looking to protect them from unlawful business practices. I take those survey results seriously, and we've been engaged in taking a series of steps to make sure that the FTC is a great place to work. I've been really thrilled that over the last couple of years, we've been able to onboard hundreds of new employees at the FTC. Just the other month, we launched a new Office of Technology. Within a matter of a week, we got 600 applications. Technologists, these are data scientists, data engineers, highly qualified people who want to come work at the FTC to make sure that we're able to use their technological expertise as we continue to do our work to protect the American public.
Well, Chair, I would imagine with the high number of vacancies that have been as a result of the last 2 years that you would be hiring more people in addition to the, I think, 33% increase in your budget. So I would imagine that there is a drive to hire people just in general to fill those spots. But I think my concern is the unhappiness of people within the agency and why that is. Do you care to comment on that?
Yeah, I take that very seriously, and we've engaged in a lot of conversations and meetings to understand what some of the source of those issues were. We've been able to implement a set of steps, including streamlining decision-making, expanding communications around priorities. We clarified what our workplace flexibility policies would be, and I'm hopeful that each of those steps has contributed.
Yeah, and Chair, please don't take my comments as me attacking you or your agency, but it is a concern to me that when I read that, of course, my colleagues up here have echoed a lot of policy frustrations with your organization, and maybe you, but when I'm reading about employee satisfaction, I mean, the FTC serves such a vital purpose in our country. It's just really alarming to see it go from one of the top performing agencies of employee satisfaction to really the bottom in a 2-year period. It's just really alarming. So what do you think that you've learned? I mean, you've been here for 2 years and you've seen, some tumultuous times. Do you think you've learned anything as a result of maybe your leadership or leadership around you on how to handle this and correct it?
So as I said, we undertook a set of steps to make sure we were appropriately streamlining decision-making, expanding communications with staff across the agency. In terms of learnings, I've had the privilege of seeing firsthand just how hard FTC staff are working day in, day out. Oftentimes they're having to go up against companies whose resources really dwarf ours, and there's a clear mismatch in resources, but we're still able to go toe-to-toe on talent, and that just reflects the sheer talent and dedication of our staff.
Well, good, and I hope that these issues correct. There's a lot. I think Mr. Gates talked about an important issue about creepy data collection that's going on. You've hit on that all day. The mission is important, but you have to correct the ship. You have to correct the type of management that you perform, and I think that starts with you. That starts with your team, because I don't want to read about toxic environments or people feeling like they're not heard or mismanagement at the highest levels. There has been a lot of ups and downs with the FTC over the last 2 years, and I'm hopeful that you can correct that. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. I yield 5 minutes to myself. I just wanted to take up a little bit where Congressman Biggs and Congressman Johnson were speaking, talking about the diversity, equity, inclusion issue that Commissioner Slaughter has evidently championed. Do you believe, and I know it's hard, but if you could just give me a yes or no answer, do you believe that should be a major and significant part of antitrust enforcement? Do you believe that's your job?
So our job is to enforce the antitrust laws, which prohibit unfair methods of competition or deals that substantially lessen competition or tend to create a monopoly. We endeavor to do that work to protect everybody.
So what does that have to do with diversity, equity, and inclusion?
I'm not really sure. I mean, could you share more about what your specific concerns are?
Well, Commissioner Slaughter has said, and we have quotes, that this needs to be and have a major role in antitrust enforcement, that that's a very major piece of it, that it's part of it. Do you agree with that or not? I didn't think, in all honesty, there are agencies who have that job and that responsibility. I didn't believe that yours did, but I was just, concerned, are we gonna, as it is, you're short of resources. We can't do all the things we want to do to protect the consumer. I don't know why we would divert resources, time, energy, and people power to actually going forward with that.
Yeah, look, I won't speak on behalf of my colleague. I mean, again, what I think about is the ways in which concentration of economic power and monopoly power hurts everybody.
I understand.
And we need to keep that in mind as we're using these tools and making sure we're protecting all parts of the American public from these practices.
I agree. I'm concerned, and I'm just picking up where Congressman Fry left off on some of the state of morale at the FTC since you began your tenure. Examples such as hiring a chief of staff described as frequently creating friction with an aggressive managerial style, or choosing an associate director for litigation in the Bureau of Competition with less than 2 years of legal experience before joining your office as a high-ranking member. Can you speak on that for just a moment?
Yeah, I'm really lucky to have a fantastic senior
You do have good staff. I'm sorry to interrupt you, but you do have a good staff. But some things, and let me say this just to maybe clarify this more. On the matter of agency morale, the Bureau of Competition, which you're familiar with, whose mission is to enforce the nation's antitrust laws, one of your top priorities, I believe it is, saw its engagement and satisfaction score drop by 33% since you began your tenure. Do you think that's a result of your leadership style? Is it a result of something else? Or are there other factors that are affecting FTC employees? You do have a lot of great people there, but the point is, a lot of those great people have also expressed that they're not happy. Why?
And I couldn't agree more that it's important for us to understand what some of the source of those numbers are. And as we've been looking to do, and I should also note, I mean, for the Bureau of Competition in particular, over the last couple of years, they've been on the front lines of a surge in merger filings. I mean, year over year, they were seeing a 70% increase in the number of filings coming in while their numbers were
I understand that, but they're not happy. We have a lot of people that work very hard, but they're happy.
just to commend them, of course. And so we've been looking to understand, again, what more can we be doing?
So
to
you're working on
streamline-
this?
Correct.
Okay, you think it's going to get better?
I'm hopeful.
Okay. I wanted to talk about unpaid consultants for a moment, which the Office of the Inspector General, this was not me saying this, the Inspector General said this, labeled as, quote, unprecedented, end quote. The Inspector General report from last year said you didn't give these consultants clear guidance or limits. I'm not saying it. This is not a Republican saying it or a Democrat or anybody else on their work, and that there was concern that these practices may, quote, violate policies for federal agencies that stipulate that such agencies, these hires are not allowed to play an inherently, quote, an inherently governmental function. Can you tell us how many of these consultants are working at the FTC, what they're doing, and how often you meet with them?
So there is federal authority allowing government agencies to make use of some of these consultants, especially in areas where we don't have existing expertise.
Respectfully, I understand that. We're running out of time. Why did the Inspector General sound an alarm, though?
The Inspector General's report identified certain areas where we could be tightening up our processes and procedures to make sure we're mitigating against risk. We followed very closely the IG's recommendations and have been moving forward to implement those recommendations.
Okay. I have items for the record. I have 2 articles from the Americans for Tax Reform titled, quote, Lina Khan has some explaining to do, end quote, as well as Khan reveals that she, quote, handpicked controversial unpaid consultants. Thank you for your answers. I'm going to yield back with that. I think that will conclude today's hearing. We thank our witnesses for appearing before the committee. We thank you for being here. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, this hearing is adjourned.
to see that you
requirements and instructions. So this new proposed rule would require submission of substantial additional documents from what is currently the status quo, including draft agreements and term sheets as opposed to just the final proposal for review, information about creditors, minority shareholders, officers, directors, and information on labor markets, data about workforce, including geographic information about employees, and details about prior penalties and findings by the NLRB. Is that right? Among other things.
Yes, we issued a proposal of suggestions for additional information that we'd be getting. Another key area would be foreign subsidies. So Congress told us to get information about whether firms that are looking to merge are getting subsidies from China or other countries.
Thank you. But in summary, this proposed rule would substantially expand the types and volumes of documents and information that are being submitted as part of this pre-merger review process, correct?
That's right.
Okay, and we also know that this rule, this new rule, if adopted, would substantially affect the time and the cost associated for entities who want to participate and make submissions under the pre-merger review process, correct?
Yes, people would have to comply with the new form, which is seeking additional information.
Right, and your agency, in fact, has estimated that this would increase by over 100 hours the time necessary to compile compliance documents to make this submission, and in some cases, in some of the more complex or larger cases, even much more than the 100 hours, correct?
These are some of the estimates in the NPRM, yes.
Yes. And the internal estimate also identified a cost estimated of $350 million impact for the change in the rule for compliance. Is that right?
That's on the higher end. I mean, I will say a lot of this will depend on the complexity of the transaction. If you're seeing a merger between two fairly small firms that don't have any, complex holdings or that sort of thing, I imagine it would be much less.
But you just raised a very interesting point, and it was one of the things that I wanted to ask about. So if we know going in that the time and the cost now associated with this pre-merger review process, the time's going to increase, the cost is going to increase, won't this affect the businesses that are at the lowest end of the reporting thresholds the most? They would be the least able to those costs and time without it affecting their overall margins?
So again, it really will depend on the complexity of the merger. If it's a fairly simple transaction, I imagine it'll be much easier to comply. I should also note, this is all about what firms need to produce on the front end, and it's our belief that by getting more information on day one, that'll allow us to more efficiently and effectively administer the laws in ways that could create more certainty for businesses on the back end.
But at the conceptual level, the large corporations, the ones, in fact, that I believe you're probably the most concerned about, the very largest corporations are the ones who are the most capable of saying, yep, let's bring in our outside counsel and spend a couple more 100 hours, or let's allocate additional costs to go through this process. They would be the ones who could most easily absorb this change as opposed to the smaller entities at the lower end of that threshold. Now, let's go here. So by expanding the types of documents, by the types of information that you all are reviewing in assessing whether a merger should be approved and allowed to proceed, you're really expanding the bases upon which the FTC could choose to approve, seek more information, or disapprove, are you not?
We're still squarely focused on whether the merger may substantially lessen competition or tend to create the monopoly. That remains our legal standard. We're seeking
How is it that some of the information that you're requesting, though, such as demographic information about employees or information about shareholders and officers, how would that relate back to that core mission that you all have been pursuing prior to now?
So issues relating to officers or things like potentially, overlapping directorates, those can affect, for example, Section 8 of the Clayton Act in terms of if you have interlocking directorates. So those are some issues in which, they're squarely within the confines of the antitrust laws.
So let me ask this then. The proposed rule, it's something that you all have developed in essence because you believe it would have a significant impact, correct? On mergers, on the health of the economy, on businesses. You're pursuing this because you think it's meaningful, correct?
We're pursuing it because we think it'll allow the FTC to administer the laws that Congress has charged us with more effectively and efficiently.
So you believe it's consequential?
Go ahead.
We
Last
think
question.
it'll meaningfully enable the FTC to do its job, yes.
But without a specific mandate from Congress to engage in this behavior, correct?
I disagree with that. The Hart-Scott-Rodino Act allows the agencies to get information on the front end when firms governed by this law are required to do so, and we're acting pursuant to that authority.
Time has expired.
Thank you, Mr. Chairman. I yield back.
Recognize the gentlelady from Indiana.
Thank you, Mr. Chairman. Thank you, Commissioner Khan, being here. So I want to bring a few issues, and I would like you to respond. But first, I belong to a group of people, even though I very much agree with Mr. Tiffany that majority of monopoly problems which are significant because we created this monopolies, incentivized this monopoly. And unfortunately, we created more companies now, too big to fail. And all of the laws that we try to deal with them, including like Dodd-Frank Act, which I was actually one of the implementers when I work in public accounting, now created this institution even bigger. And now we're going to be dealing with that. But I also understand that there are some of the areas where we have now problems so big that it involves us to looking at the barriers of entry, like healthcare, and then looking what are we going to deal with now with these monopolies that distorting the market and using very aggressive behaviors to suppress suppress competitives and really not delivering value because they can't. They are not natural monopoly. We created, and we have to look at that. So I think your agency has an important function, but unfortunately, and I want you to really respond on that, we have a lot of concerns from the Republican side, and that agency has been politicized, and agency has been used to really the hammer and sickle and, to actually pick, a kind of in fashion to pick losers and winners. And I think, it's becoming a problem. And if you look at your even, the missions that you have and objectives, you said we will really need to have more, merge together consumer protection, competition, and you want to, your agency shapes distribution of power. I truly don't believe that that is an agency. I think the agency should be, dealing with the real abusers in the system that want to not have competition, use monopolistic power. So even in the statements, it's a problem. And I think we have one common ground that it seems like a lot of time we have a lot of talk is on healthcare. But when we come to the action, it's even recently, we put it on the table with President Biden's administration on dealing with, with site-neutral payments on hospitals that bankrupt in Medicare, total abuse of power, allow them to buy private practices, allow them to put these doctors in crazy non-competes, enslave them, building Taj Mahals, not paying taxes, investing billions on Wall Street, and pay billions to executives by subsidies that are now countries gone bankrupt on, because sort of our spending is healthcare, not delivering value, they didn't want to deal with that, and then you have a challenge now because a lot of these entities, nonprofit, which is really doesn't even have guidance, that's that like next business I'm going to have is going to be tax exempt, you don't have a full jurisdiction to deal with these entities, and no one has, and I would like you to deal with that, but now my colleagues here have a concerns. We have actually a bipartisan bill, but a lot of my people here feel concerned with you that you're not going to be enforcing it properly, and you will use it as a power, to actually pick losers and winners again. So I wanted you to see how you can respond, with what you're doing in this area. I think there is a PBM, probably common ground. We have that area. But if we look at that, 50 to 60% of spend is, hospitals and physicians, 5 to 10 is actually only spent on drugs. So this is a huge amount of money. How would you respond what you're doing on that, and how you would address some of these Republican concerns? Because I think your agency has some functions. But unfortunately, everything got so politicized. And a lot of people here on my side of the aisle don't feel comfortable to give any more power to your agency.
So thanks for the question, Congresswoman. You're absolutely right. We have a whole set of work streams underway relating to healthcare markets. We're concerned about instances in which monopolistic practices or a lack of competition in healthcare markets may be raising prices for consumers, maybe depriving them of access to quality healthcare. Our teams have for many years now been challenging hospital mergers where they've determined that the merger would either raise prices or lessen competition in ways that was harming patients. We have work underway, as we've talked about extensively today, relating to PBMs and the potential conflicts of interest that are created through their vertical integration, as well as issues that may be created through the rebate schemes that they have in place. We also have work looking more directly at drug prices and whether mergers and acquisitions done by pharmaceutical companies may be inhibiting innovation, maybe keeping lower cost alternatives out of the hands of American patients. So that's all work that we have underway, and we're working hard to move quickly on all of that.
Well, my time has expired, but we still need to figure out how you can address concerns of my colleague, and I yield back.
Gentlelady yields back. I recognize the gentleman from Texas.
Thank you, Madam Chair. It's good to have you here today. I'd like to talk about the Horse Racing Integrity and Safety Acts. Well, it's called the Horse Racing Integrity and Safety Authority, which Congress created and put under your commission's rulemaking authority. I know you didn't ask for this, but you got it. And I've got some questions. They're not complaints directed toward you or your leadership, but I just like to say that I'm very disappointed in how they have operated. The HISA was intended to improve safety and fairness in horse racing. It's fallen short of its promises. And some of the issues I have, I'm not even sure you're aware of. And when I'm done, I want to ask that we can sit down and talk about it more. But the FTC has allowed them to operate in a way that they are making rules, I believe, without the authority or without any oversight. There's also a budget of $66 million. My question is, does the FTC monitor how these funds are being spent and who the recipient of their budget funds are going to?
So the statutory scheme lays out the relationship between the FTC and this kind of self-regulatory organization. You're right that we didn't ask for this authority. To be honest, it's been a bit of a challenge for us fully implementing it. We don't have real deep expertise in this area. On your specific question, to be honest, I'm not totally sure. I don't think we have that authority to be overseeing how they use their money.
Okay.
I'm happy to get back to you on that.
Separately, if the FTC enforcement staff was investigating an antitrust case and thought it needed to conduct a search of a business's premise, would the FTC need a search warrant for that search?
Presumably, though I do know that I believe it's Section 9 of the FTC Act does give the FTC ability to, engage in some of that activity as well.
All right. I would just let you know that this authority under your supervision can conduct a search without a warrant. They can also impose an immediate suspension on horses and trainers and owners if there's any evidence or suspicion of doping. One of the reasons they were created was because of the deaths in the horse racing in the past, but we've seen just this year that even more deaths have happened, and I would make a case that this authority is poorly run and operating in a way that I suspect if you all really knew, you would disapprove of. I'd like to sit and talk with you all about that after this hearing down the road. Moving on, I want to talk about some of the mergers and the policies with respect to those. I'm specifically curious because I'm looking at a letter that Senator Warren sent you all in January of this year about some pharmaceutical mergers. How much interaction does her staff or her have with you all with respect to these? Do they have influence with the direction you all go on some of these investigations?
Congressman, we hear routinely from members of Congress. We get letter week after week, including from many members of this committee. We take all of that under advisement and want to understand what our members' concerns, but any law enforcement decisions that we're making on an independent basis based on the facts and law before us.
Well, I'm looking at particularly the Amgen and Horizon merger, which I understand was moving along pretty well. And it's different than some of these mergers that she mentions in this letter that I'm reading. And I know y'all probably have a copy. I'll get you one if you don't.
But Horizon is an Irish company. It's a kind of a special case because it inverted in 2014 by acquiring this Irish company. So they actually left the U.S. For tax benefits. And now Amgen, as I understand it, is looking to acquire this company. They're involved in totally different drugs. And what this would do is actually bring a company back to the United States, which I believe is a goal that we all share, is bringing industry here at home. So I would also ask, especially since it seems to have been stopped right after Senator Warren sent this letter, if I could sit down with you all at some point and we talk about this one as well. Can we commit to doing that?
We'll be happy to have a follow-up conversation with you. Yes, Congressman.
I appreciate your work and thank you very much for being here. I yield back.
Gentleman yields back. We are going to take a recess when we have to vote. As soon as votes are completed, we will be back. Thank you. You're going to get a longer recess now.
Charges facing antitrust today were, quote, the result of a choice made 40 years ago to follow the misguided philosophy of people like Robert Bork. In other words, according to Chair Khan, the prevailing view over the last 40 years, a bipartisan view, shared over more than 20 Congresses, 6 presidential administrations, and adopted and developed by all 50 states in their enforcement, is now somehow wrong. Consider that over those 40 years, the U.S. economy grew from about a $3 trillion annual economy to $25 trillion and was the single greatest period of wealth creation in human history. But everyone who oversaw economic policy for those 4 decades, according to the chair, was wrong. She knows better. She's trying to usher in a radical departure from the norms that made the American economy great to a system where her and her cronies have unchecked power over business practices in our country, untethered from any reasonable reading of precedent or statutory law. So we should ask now, over the 2 years into her tenure, how has her approach to antitrust been playing out as she heads one of those critical agencies in our government? The short answer is that it's been a disaster. She's pushed investigations to burden parties with vague and costly demands without any substantive follow-through or, frankly, logic for the requests themselves. She's centralized the decision within her office, eliminating any pretext of due process or transparency in that decision-making. Her approach is best characterized as one of intimidation followed by inaction. The best example of this, which was only brought to light because of our work on the Weaponization Select Committee, was her targeted harassment of Twitter. After Mr. Musk bought the company and following pressure from Democrat senators, left-wing activist groups, the FTC issued over 350 requests for information from Twitter. These requests included asking for every communication about Mr. Musk inside the company, and most troubling, for information about Twitter's work with journalists, working to shed light on the government-driven censorship practices that existed at, and I think in some cases still exist at big tech. In fact, we got a great court decision last week who talked about this, how pervasive this effort was, and a preliminary injunction from that federal court in the Western District of Louisiana. Just this morning, though, in a filing in federal court, we have learned that the situation is actually even worse than we could have imagined. This wasn't harassment, it was a shakedown. The FTC, as is common practice pursuant to the consent order, required Twitter to hire an independent assessor whose legal obligation is to be truly independent and objective, not for one party or another. Well, it turns out objectivity was not what the Federal Trade Commission was interested in here. Here's what the filing said about Ernst & Young, the independent assessor hired in this matter. Quote, the FTC was so adamant with Ernst & Young conveying that this is absolutely what you will do, and this is going to occur, and you'll produce a report at the end of the day that would be negative about Twitter, that senior Ernst & Young leaders feared that if Ernst & Young resigned as the independent assessor, the FTC would take exception to their withdrawal and create other challenges for Ernst & Young over time. This is not conjecture from Twitter. This is from sworn testimony of the independent assessor in the deposition itself, taken just last month. This is outrageous. This is unacceptable. And it's the kind of behavior that occurs in banana republics, not in the United States of America. And so it's no wonder Chair Khan has no interest in providing information to the people's representatives in the Congress, to the people on this committee when we ask for it. To date, the FTC has not fully complied with a single request for documents from this committee. And because of her mismanagement, not even her own staff is impressed with Chairman Khan's leadership. In 2020, the last year under the Trump administration, 87% of FTC employees agreed that senior leaders maintain high standards. Under Chair Khan, that figure fell to 53% in 2021, has declined even further to 49% in 2022. In 2020, 83% of surveyed FTC employees agreed that they have a high level of respect for the FTC senior leaders. Again, under the chairman, that figure plummeted to 49%. And these numbers were before it was revealed recently that the chair was advised by FTC's Ethics Council to recuse herself from a major case. She did not recuse herself and then appears to have misled Congress about taking that advice. We have a lot of questions today to get through. We look forward to the response from the chairman of the FTC. And with that, I would yield to the gentleman from New York, the ranking member, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, since you brought up Robert Bork, I must say that I have thought for the last 40 years that the court's unfortunate following of Robert Bork's doctrines, upending all prior understandings of antitrust law, has resulted in a terrible misinterpretation of antitrust law and is directly responsible for the overconcentration of industry and the power of big business in today's economy. Mr. Chairman, yesterday the director of the FBI sat at the witness table for nearly 6 hours, enduring a steady stream of baseless attacks and conspiracy theories meant to fit a far-right narrative that may resonate on Fox News, but that lacks any basis in fact. Today, it is the chair of the Federal Trade Commission's turn to step into the alternate universe that is the House Judiciary Committee under MAGA Republican leadership. Chair Khan, the last time you were here, you sat on this side of this table, helping to reinvigorate this committee's work on antitrust matters, and I thank you for your service to the committee. Unfortunately, I expect that today you will be the target of a barrage of personal attacks and wild accusations about the work of the FTC under your leadership. Republicans will tell us that the Commission is wasting resources, but the FTC has returned over $430 million to consumers under your watch and is vigorously enforcing the laws that Congress has entrusted to it. Meanwhile, it is the House Republicans who have wasted untold congressional and staff and agency staff resources and millions of dollars in pursuing a fruitless search for evidence of misconduct at the FTC. The majority will also argue that the FTC's investigation into Twitter was politically motivated and conducted at the behest of congressional Democrats. This argument also has no basis in fact. Twitter has been in trouble for failing to adequately protect the privacy of its users for more than a decade. It has been subject to a consent decree on this topic since as far back as 2011. It came under a second consent decree last year, and given the haphazard conduct of its new owner, it may very well be subject to new scrutiny today. It is the FTC's duty to review compliance with these consent decrees, particularly when, as occurred last year, there are credible concerns that user data may have been compromised when the majority of its legal and engineering staff was fired. This work has nothing to do with the new owner of the company and his political views. Protecting user privacy is not political. Rushing to defend a company at all costs and investigating the agency that attempts to hold that company accountable merely because the new owner shares your political views is another matter. Ultimately, Chair Khan, you will face attacks today because you are doing your job, and that is what threatens Republicans the most. The Federal Trade Commission was created and charged with enforcing antitrust and competition laws to respond to a rise in consolidation across the market in the early 1900s. It helped bring down the trusts and lessen monopoly power, which strengthened the economy and helped support the formation of a strong middle class. Unfortunately, in recent decades, the executive branch took a radical turn away from enforcement of the antitrust laws that kept us safe and prosperous for nearly a century. That failure led to massive consolidation across the market that gave rise to a handful of dominant companies with the power to squash competition. The rise of monopolies and monopsonies in several fields was a boon to the corporate class, but it has been devastating to consumers, workers, and small businesses. This began to change when the Biden administration announced several steps to reinvigorate the enforcement of federal antitrust laws. By faithfully interpreting the original intent of the antitrust laws and the FTC Act to ensure fair competition and prices, the administration has announced that the party is over for large and unfettered corporations. And although most Americans welcome this change, and indeed our economy is booming and unemployment is at a historic low, the commitment to enforcing these laws has raised alarm among our Republican colleagues, so they have taken aim at your agency and the important work the FTC does to protect consumers and promote competition. I hope that my Republican colleagues will find it within themselves to put their baseless and often personal attacks on pause long enough to listen to the importance of your mission. In any event, I appreciate your appearing here today, and I appreciate the valuable work of the FTC. I look forward to your testimony, and I yield back the balance of my time.
Gentleman yields back without objection. All of the opening statements will be included in the record. We will now introduce today's witness, the Honorable Lina Khan. Ms. Khan is the chair of the Federal Trade Commission. She was sworn in on June 15, 2021. We welcome our witness and thank her for appearing here today. We will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect the witness has answered in the affirmative. Thank you. And please know that your written testimony, you've seen this before. You've sat back behind the chairman before, the former chairman before. So that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. We'll be a little lax with that if you need a few extra. Chair Khan, you may begin, and then we'll move to questions.
Chairman Jordan, Ranking Member Nadler, and members of the committee, thank you for inviting me to testify today. I'm glad to join you to discuss the FTC's work to promote fair competition and protect Americans from unfair and deceptive practices. It's a particular honor to appear before this committee, where I had the great privilege of serving during its historic bipartisan investigation into digital markets and the power of large technology platforms. As this committee knows well, there has long been a battle in this country between monopoly power and America's democratic institutions. Congress created the FTC in 1914 against the backdrop of an industrial revolution that had delivered significant technological advances, but also enabled intense consolidation. Given deep national unease about the unchecked power that these monopolists could wield, lawmakers tasked the FTC with preventing unfair methods of competition and scrutinizing business practices through regular data collection and continuously building expertise. In the subsequent years, Congress has expanded our legislative mandate to include laws aimed at protecting consumers. With each of these efforts, Congress has redoubled its commitment to fair competition and to rooting out unfair or deceptive business practices. At the FTC, our North Star is fulfilling the important mandate that Congress has given us and doing all that we can to faithfully enforce the laws and safeguard America's citizens and businesses from harmful and even dangerous concentrations of private power that characterize significant swaths of our economy today. I am endlessly impressed by the talent and tenacity of the FTC teams, especially in the face of ongoing resource constraints and legal challenges to our authorities. Over the past 24 months, the FTC has moved to challenge major transactions that would have eroded competition in critical sectors of the economy, including defense, semiconductors, energy, digital markets, and pharmaceuticals. We are tackling anti-competitive practices, including those that harm American farmers, small businesses, and workers. Last year, the FTC and a bipartisan coalition of 10 state attorneys general charged the 2 largest pesticide manufacturers with unlawful schemes that prevented farmers from having access to cheaper products, costing them billions of dollars. In January, the FTC proposed a rule that would ban employers from imposing non-compete restrictions that lock in workers and collectively depress their wages by up to $300 billion, while also depriving startups and businesses of the employees they need to expand and compete. In the months since proposing this rule, we've received over 21,000 public comments, including from nurses and doctors, fast food workers, and hairdressers, who all told us about how non-competes had hurt their livelihoods and undermined their economic liberty. Already, several enforcement actions by the FTC have led firms to drop non-compete restrictions imposed on thousands of workers. The FTC also continues to use its tool to conduct market-wide inquiries. Last June, the Commission launched an inquiry into the practices of pharmacy benefits managers to shed light on the opaque operations of the large middlemen who can dictate pricing and access to life-saving drugs for millions of Americans. This inquiry follows thousands of public comments the FTC received explaining real-life costs that can follow from PBM's current practices. One doctor, for example, recounted how delays in PBM approvals caused her patient to develop resistance to an otherwise effective treatment, ultimately leading to the needless loss of her patient's eye. In addition to these critical areas of work, we are redoubling our efforts to protect Americans' privacy and combat fraud, while also activating additional authorities that Congress has given us. We've brought actions to protect consumers from Made in USA fraud, protect military families from predatory financing, and protect addiction recovery patients from deception. We are fighting to protect the security of people's sensitive personal data and have obtained record monetary judgments, including the largest ever judgment to protect children's privacy. The Commission has also proposed rules to address some of the most widespread scams, like government impersonation fraud, Made in USA fraud, and fake online reviews. The agency is tackling junk fees plaguing American consumers and scrutinizing dark patterns that trick people into incurring unwanted charges or surrendering sensitive data. Our click-to-cancel proposal would require companies to make it as easy to cancel a subscription as it is to sign up for one. The FTC is also committed to fighting for people's right to repair their own products. The FTC has brought several major actions against companies for imposing unlawful repair restrictions, hurting customers and independent shops alike. In other words, the FTC is firing on all cylinders, fighting every day to protect the American people from unlawful business practices. These efforts reflect the extraordinary work of our agency staff, whose talent and dedication are second to none. It is a deep honor to serve in this role, and I am enormously proud to see how our enforcement actions and policy work are materially helping Americans in their day-to-day lives. In the aggregate, our work helps promote the open, competitive, resilient markets that have been the bedrock of America's economic success and dynamism throughout our nation's history. Thank you for the opportunity to appear before you today, and I am happy to answer your questions.
Thank you, Madam Chair. We will now move to 5-minute question. The Chair recognizes the gentlelady from Wyoming.
Like other federal agencies, the FTC has a designated agency ethics official known as DAO. On April 18, 2023, you testified before a subcommittee of the House Energy and Commerce Committee. At the hearing, Chair Rogers asked you, quote, "Are there any instances where you have not followed the DAO's advice?" End quote. You responded no, and you followed up by saying that you, quote, "have consulted with the DAO and taken actions that are consistent with the legal statements that DAO has made," end quote. On June 16, 2023, a Bloomberg journalist published a leaked memoranda written by the FTC's DAO analyzing Chair Khan's ability to sit as a judge in the FTC's review of Meta's acquisition of a company called Within. According to the ethics memoranda, the DAO, quote, recommended you recuse to avoid an appearance of partiality concern pursuant to federal ethics regulations. Do you believe that you were completely honest and forthcoming with Congress when you asked if there were, quote, any instances where you had not followed the DAO's advice, and you answered no? Yes or no?
Yes, Congresswoman.
Okay. In the letter that you sent to this committee yesterday evening, you claim that you received only oral advice from the DAO, but never saw the leaked memo until after you decided not to recuse yourself. First, it is unbelievable to me that you would not ask for written ethics advice on this particular topic. You admit that you have written ethics advice on other topics, but on this topic you claim you did not see the written memo. Instead, you want us to believe that you only received oral advice and not specific oral advice, but only general advice on, quote, understanding the legal framework, end quote. Did DAO give you advice that is different than what was written in the memoranda?
Thanks for the question, Congresswoman. My work before I joined the commission was focused on assessing the power of large
I
technology
need you to
companies.
answer the question that I asked. The question that I asked was, did you receive different oral advice than what was written in the memoranda from Deo? Very simple question.
So I consulted with the ethics official. The ethics official, as was noted in the memo that you cited, although I did not receive that memo, noted that the ultimate framework for instances in which somebody has no financial conflicts of interest.
Did she give you different oral advice than what was in the written memoranda?
The legal framework
Yes or no?
is for the employee to themselves determine whether they should or should not recuse.
Did she give you different advice than what was orally than was in the written memoranda? Yes or no?
Congressman, as was noted in the written memoranda, there was no ethics violation created by my participating in the
But you didn't follow the Deo's advice, did you? You could have recused at any time, couldn't you?
I followed the determination that there was no ethics
You could have recused at any time, couldn't you?
There was no violation under the ethics laws because I have not a penny in financial stock, not a penny in financial
The
interest.
Deo gave you the
relating
advice
these
to
companies.
recuse, and you did not do so, correct?
Congresswoman, as was noted in the memo, as I noted in the
I'm
letter.
going to move on since you're not willing to answer my question. I read your 4-page letter, which was nothing more than an affront to your obligations of honesty, integrity, and candor before this tribunal that is owed by every public servant. And I would reference Part 2635 of the Code of Federal Regulations, which describes your ethics standards. I want to note that the ethics standards are actually higher than one owed by lawyers, which brings me to my next point. Do you expect lawyers at the FTC to follow federal ethics rules?
Of course, everybody at the Federal Trade
Do you expect lawyers at the FTC to be an active member in good standing of a bar of a U.S. state?
If they're practicing as a lawyer, they need to be in good standing with the relevant bar rules.
I understand that you were admitted to the New York bar on July 16, 2020, but in 2019 and 2020, according to your Senate questionnaire, you held yourself out as counsel for the Democrats on this very committee. You used this title, but you were not licensed to practice law. Counsel is a term reserved for lawyers, licensed lawyers. And in Wyoming, a person who in any manner holds themselves as competent to practice law without a license to do so is guilty of unauthorized practice of law. I believe the law in the District of Columbia where you held yourself out is similar. Do you believe it is appropriate for non-lawyers to claim the title of counsel?
Congressman, when I had the honor to work for this committee, I complied with all of the document requests that the HR folks requested, including documentation about the fact
When
that
I checked your registration status this morning, I learned that you are not in good standing with the New York bar. Your license is listed as delinquent, which means you have failed to file your biennial registration, and it means that you have not been paying your bar dues, completing your continuing legal education, and maintaining your law license. I believe it's shown on the screen. It also means you're subject to referral for disciplinary action. I find this situation to be stunning and a reflection on your ethics. With that, I yield back.
Gentlelady yields back. The chair now recognizes the ranking member from New York for 5 minutes of questions.
I find the statement of the gentlelady from Wyoming incredible. Will the Republican staff all commit to recusing themselves from any matters that relate to their work on the committee? Because that is the standard they are holding Chair Khan to. Chair Khan, thank you for coming before our committee today. Under your tenure, the Commission has returned over $430 million to consumers and proposed a ban on non-compete agreements that would increase workers' earnings by nearly $300 billion a year, would save consumers up to $148 billion in health care costs, and would close racial and gender wage gaps by between 3.6% and 9.1%. What are some other ways that the Commission supports a strong economy?
Thanks for the question, Congressman. So our work on the antitrust side is focused on ensuring robust competition. This has involved blocking mergers that we believed would have eroded competition, including in the defense industry, including in healthcare. We've brought a set of lawsuits alleging that certain types of hospital mergers would have deprived Americans of access to quality, affordable healthcare. We have a whole set of work underway focused on the fact that all too often drug prices are way too expensive for American people, and we're scrutinizing the ways in which potentially unlawful practices may be contributing to those high prices. We're also hearing directly, day in, day out, from small businesses, from independent grocers, independent pharmacists, franchisees, about the ways in which the FTC's work can help ensure that they have a robust, open opportunity to compete in the marketplace and make sure that Americans are benefiting from robust competition.
Thank you. And you have made it clear that antitrust enforcers like your own agency must be more active in enforcing the law and bringing high-impact cases, even if those cases ultimately are unsuccessful. Can you expand on this for us and share why you think having a strong cop on the beat is essential to a fair marketplace?
Thanks, Congressman. I mean, I've been very clear that my worry has been about under-enforcement. Unfortunately, I think there were missed opportunities in the last few decades where all too often entire sectors were allowed to consolidate. That has now created markets that are closed off to competition. Recently, the Defense Department has been noting how this consolidation is also now directly undermining national security, where significant consolidation in the defense industrial base is harming our military and making it more difficult for us to compete globally. These are just some of the harms that we've seen from consolidation. Because of that, we think it's incredibly important to be vigorously enforcing the laws that Congress has charged us with enforcing. This includes the FTC's Act's prohibition on unfair methods of competition. It includes the Clayton Act. It includes the Sherman Act. There have been provisions of these statutes that unfortunately had been left dormant, and we are fully committed to reinvigorating the law and make sure that we are fully enforcing all of the provisions that Congress has charged us with enforcing.
I know that you, I assume you also enforce the Saller-Kefauver Act. I know that you also support bringing court actions instead of reaching a settlement under a consent decree with a company that has broken the law. Why is this?
So, Congressman, we assess every matter on a case-by-case basis. On the antitrust side, we have seen, unfortunately, instances in which certain remedies that were achieved in merger settlements, unfortunately, fail to fully protect competition in the ways that the agencies are required to do under the law. So certain behavioral commitments that firms make, divestitures, really fail to preserve the competition that we're charged with safeguarding. As a result, we're learning from that experience and adjusting and modifying where needed. In some cases, that means bringing a lawsuit if a remedy that's being offered we don't believe will fully resolve the underlying competitive harms. In other instances, it means really improving and strengthening and tightening up the remedies that we are achieving. So it really depends on a case-by-case basis.
Thank you. Despite claims from the majority that you did not follow ethics guidance, we know for a fact that under the law you have no conflicts of interest that would require you to recuse yourself, correct?
Correct.
And indeed, the designated ethics official instructed you correctly that the decision to recuse yourself was a personal one that you are charged to make, correct?
That's right.
And you also spoke with the General Counsel's office, who also stated that you do not have a conflict of interest that would require your recusal, correct?
That's right, correct.
And you do not own any stock in any corporation or have any personal ties that would require you to recuse yourself, correct?
I have not a penny in any individual firm stock, correct?
The Federal Trade Commission plays a critical role in protecting consumers, ensuring competition, and enforcing the laws we have entrusted to it. The agency has done this work for over 100 years, and I appreciate that it will continue to do so under your leadership. And finally, Mr. Chairman, before I yield back, I ask unanimous consent to enter into the record a copy of the letter from Lina Khan to the Honorable Kathy McMorris Rogers and yourself.
Wow. Letter, it's already, I already have your one in. I appreciate it. That's fine. Without objection, so ordered.
Thank you. I yield back.
The gentleman from California, Mr. Kiley, is recognized for 5 minutes.
Good morning, Ms. Khan. A few days ago, you lost another case. This was your challenge to the Activision acquisition. The Northern District of California, in an opinion by a Biden appointee, denied your request for a preliminary injunction. After what the court called a voluminous pre- and post-hearing written submissions, the court found you are not likely to succeed on the merits. You seem to be losing quite a bit, and I don't say that to be disrespectful, but these are, after all, taxpayer funds. You're now 0 for 4 in merger trials. The average win rate for the FTC in the modern antitrust era is around 75%. So I have to ask, why are you losing so much?
Thanks for the question, Congressman. I should note, first of all, that the FTC has some of the best litigators around. And in the very trial that you mentioned, it was just phenomenal to see, and the judge herself personally commented on how the fact that the FTC, despite being totally out-resourced by some of these companies, was really able to go toe-to-toe in terms of legal talent and skill. And I'm enormously proud of our litigators.
Well, I'm not sure the taxpayers are going to take much, delight in the legal talent and skill of enforcement actions that cost great taxpayer dollars and end in defeat. So the question is, why is your track record so poor when it comes to actually winning cases?
Congressman, we've had significant success in the courts. There are a whole set of matters, including our case against Martin Shkreli, where the court found resoundingly in the FTC's favor, also banned Martin Shkreli for life from the pharmaceutical industry. We also had...
Okay, so you're 0 for 4 in merger trials. And so when I was trying to figure out what's going on here, I found maybe a clue in an article from the New York Times, December 7th, 2022, which reported comments you made at a conference where you said this. You said, if there's a law violation and agencies think that current law might make it difficult to reach, there's a huge benefit to still trying. She added that any courtroom losses would signal to Congress that lawmakers need to update antitrust laws to better. I'm certainly not somebody who thinks that success is marked by a 100% court record, you said. So this raises the question, Chair Khan, are you losing on purpose?
Congressman, the key clause in the quote you mentioned was, if there is a law violation. We only bring cases when the facts before us lead us to believe that there is a law violation under the existing laws. On the merger front, there are a whole set of cases where we've won, including in instances where the parties abandoned and walked away after
Okay,
the
you're
FTC
0 for 4 in
filed
merger
a
trials. So
complaint.
what did you mean when you said that any courtroom losses would signal to Congress that lawmakers need to update the antitrust laws? What does that mean?
So there is an institutional dialogue, right, between enforcers, between Congress, between the courts. There's a century worth of antitrust back and forth between the agencies, between Congress. This very committee in the 1950s determined that the agencies were not bringing the types of cases that Congress was worried about in terms of monopoly power.
Okay, but you're actually bringing the cases. You're losing because you don't have the authority that you want from Congress. So this is how you think you're going to persuade Congress to give you more authority, is by exceeding the authority that you now have?
Congressman, again, we only bring lawsuits where we believe there is a law violation, given the facts and the law at hand. We fight hard when we believe that there is a law violation, and unfortunately, things don't always go our way, but we make determinations
But
about
are you
whether
bringing
to
cases
appeal.
that you expect to lose?
Could you repeat
Are
that?
you bringing cases that you expect to lose?
Absolutely not.
Okay, well, your track record seems to suggest otherwise. Let's look more closely at the Activision decision, though. The court first noted that in an attempt to lower your burden, you essentially made up case law. You couldn't find anything actually that's the courts have provided in terms of precedent, so you cited to your own FTC decision as precedent. But irrespective of the legal standard, the court, you probably wouldn't have won under any standard, because the court said this, that the FTC has not raised serious questions regarding whether the proposed merger is likely to substantially lessen competition. Not raised serious questions. The court also not only rejected your assertion of a likely anti-competitive effect, but found just the opposite, that the record evidence points to more consumer access. So why should Americans have faith in your judgment when this Biden-appointed judge says you are so far off the mark?
Congressman, this matter is still pending before the FTC in administrative adjudication, so I'm just going to be limited in what I can say about the merits. Our complaint lays out the staff's view of what this merger would result in and why that would be a law violation.
But the judge roundly rejected it and said there weren't even serious questions, and now having lost, you're spending even more taxpayer money on an appeal that you're even less likely to win, because the appeals court is going to defer to the trial court's findings of fact in this very fact-intensive matter. So why are you spending even more taxpayer resources pursuing this appeal?
So I can say, again, this was a staff recommendation. I can say it a general matter. Staff always looks closely at an opinion and looks at whether there are certain errors in law that they believe are worth appealing on. Those are, in general, the types of determinations that go into whether the FTC ends up appealing.
Gentleman's time has expired. The chair now recognizes the gentleman from Tennessee.
Thank you, Mr. Chair. Chairman Khan, I thank you for being here and for putting up with some of the questions you have been asked. Yesterday, FBI Director Wray sat here for almost 5 hours and put up continual questions attacking his patriotism, his judgment. It was really amazing, the hypocrisy that was shown. The issue was weaponization of the FBI, and yet every member of this panel who was here on January 6, 2021 knows that the government was weaponized on that day, as I said, nuclearized, to take over the government, to overthrow the government, in contradiction of the oath of office that each of us had taken, and that we've learned that certain members of this committee went and met with Donald Trump, and that they were participating in the overthrow of our government, the nuclearization/weaponization of our government. And yet they had the chutzpah, the audacity, the lack of integrity to question Wray's judgment, and went on and on. And I was sorry, I came in here today and I'm
Is the gentleman accusing us of a lack of integrity?
Mr. Chairman, if you would ask whoever it is to shut up.
I'm sure the chairman will rule when he comes
I came in
back.
today and I heard some questions about your relationship with the Bar Association. Hey, you don't talk about rope in a house where a man's been hung. You don't ask about membership in the Bar Association on a judiciary committee where there are members who never passed the bar and aren't members of the bar. And they are members of this committee in good standing. So we need to get beyond the hypocrisy and realize where we are and don't raise such subjects. Chairman Khan, let me ask you this. The Federal Trade Commission deals in issues that protect consumers. And subscriptions to magazines, to service on subscription services for media are everywhere, and you can subscribe to them easily. But it's hard to unsubscribe. It's difficult to find that spot. This has been a problem to consumers, and the companies just make money hand over fist as people give up on trying to unsubscribe or cancel their membership. What steps is the FTC taking to reel in these predatory practices?
So, Congressman, you're absolutely right. We have a complaint database where we hear directly from consumers. Oftentimes we hear about significant frustrations about these subscriptions that are very easy to sign up for, but effectively impossible in some cases to fully cancel. We've brought enforcement actions, including a case we brought against Vonage last year. We also recently proposed a rule. It's our click-to-cancel rule that required that companies make it as easy to cancel a subscription as it is to sign up for one. We've been collecting public comments. We're going to look closely at the record and determine how to proceed.
Thank you for that. I've tried to, I had a bundle with Disney, Hulu, and ESPN 26 or something. And I tried to get out of that bundle and just do Hulu or something. And whatever it is, I'm being charged for both of them. And I've given up. I've just tried to cancel, and it's just too much. It needs to be easy.
That's right. And we've also seen through our work that companies sometimes use what are known as dark patterns. These are these manipulative design techniques that are designed to trick people into either, signing up for unwanted services or that make it very difficult to cancel or opt out of something. And so those manipulative design tactics are very much on our radar.
Another anti-consumer practice is robocalls. And I've heard about it forever. And it bothers me, it bothers so many people to get these robocalls and asking you to sign up for this or sign up for that and to speak, and they get you. This is also, I think, the FCC maybe, but what is the FTC doing with these deceptive calls?
So we work hard on this front. One thing that we've been thinking about is how can we be most effective and efficient with our resources. We've been looking upstream at the voice protocol providers who sometimes are helping facilitate or enable these robocalls, and so we've brought a whole set of enforcements against them in order to have a more deterrent impact and really protect consumers from these unwanted calls.
And have you tried to encourage or help companies that the public where antitrust actions could give them more choices and better prices?
Absolutely.
Well, I thank you for what you're doing. By the way, do you have any books that you checked out from the library that are overdue? No. The public really cares about that. That's important. I yield back the balance of my time.
Gentleman yields back. The gentleman from California is recognized for 5 minutes.
Thank you, Mr. Chairman. And
on behalf of the committee for the work that your 1,600 plus full-time equivalents do on areas like thwarting robocalls and your efforts to promote the right to repair. I want to thank the people at the FTC. Our beef, though, is not with much of the good work you do, much of which, as you said to Mr. Kiley, is successful in when you litigate. Our problem here today, my problem here today, is that you're a bully. You have $500 million to spend, and you choose to spend it promoting a policy that when you were a staffer sitting behind us, you seem to be very much into it. I believe you've taken the idea that companies should have to be less competitive in order to merge, that every merger has to be somehow bad for the company and good for the consumer, a standard that cannot be met. I will take, for example, Illumina, a situation in which they have had the audacity to tell you that a company that they spun off but still held major assets in, that asked to be reacquired so that a breakthrough non-competitive drug, a technology of detection of cancer could be promoted more quickly, one which has no current competitor, one which is not on the market. And yet you decided that a company with a market cap of about 10%, that of Pfizer, somehow would be anti-competitive if it assimilated a new, took on something that would be new, that it had helped internally produce before spinning it off. You're failing in that, you're going to fail. You then took on Microsoft. Microsoft's a big company. Everybody up here seems to want to beat on anyone that has over $1 trillion market cap. And when you served on the committee, you were big on, if you were over $1 trillion, we need to break you up or stop you. However, that merger that you lost the other day is one in which a protected market that Sony enjoys in Japan, a company that is already larger, needs competition. The reality is, we are a global market, and you are thinking only of who you want to go after for some reason. And I cannot find your logic, and I believe that it begins at the top. I do. When you blamed your staff and said staff decisions, shame on you. The fact is, you run this organization, and its left turn came when you took over, not with the staff that many of whom would have already been there. Now, one of the things that beyond Illumina that gets me is, and this is my question to you, if cancer patients die because it blocked the merger, which you didn't because they went forward over your objections and will continue to fight you, if cancer patients die because they don't have the money to bring this technology forward, where is the consumer benefited? And I know that you're going to say, Illumina is currently pending. We're still working on it. I can't answer. It's interesting to answer no to the Democrats, but you can never answer simply to us. But I'll give you a chance. If something is not on the market and an organization of two companies say we want to merge to bring something to the market, where does the FTC see anti-competitiveness? Briefly, if you can answer.
So before I answer, I should just note, if anybody asks me on either side about an ongoing
No, please answer my question. My time is limited.
I will not be able to answer about ongoing adjudicative proceedings. Relating to the matter that you mentioned, I was not at the commission when it was voted out. There was a recent commission opinion. In that opinion, we lay out our view, that was voted out unanimously. We laid out our view about how the antitrust laws apply in nascent markets. There is significant case law around how it's incredibly important to be protecting competition, not just in well-established markets, but especially in nascent markets.
So let's go back through this. Your opinion, the opinion whether you inherited it or not that you seem to bear, is that in the future there could be a failure to have competition in a market that has not yet occurred. If people have to meet a standard of your hypothetical market will not develop because we have to predict the future. If your ability to predict the future is so good, how is it you could not predict that you were going to lose 4 out of 4 cases? How is it you can predict the future of markets when in fact the stock market can't even do it? I would contend that you have overstepped your boundaries and your $500 million budget is being wasted. And I, for one, will not support your $160 million increase as long as you do not stick to those things which you do well, which the FTC has a responsibility, and for those robocalls that, in fact, you have never managed to stop. And with that, I yield back.
Gentleman yields back. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman, and I want to commend my colleagues on the other side of the aisle in the 108th Congress in diversifying the membership on their side of the aisle. But frankly, we haven't done enough. They have not done enough. They can't do enough at this point. And it reflects in the treatment that a witness such as yourself, Chair Khan, receives from this committee. When a witness comes in, sitting solo at that table in front of all of these interrogators, it's a daunting look. The American people can see it, and when we treat a witness who looks like you with the politics of personal destruction, and when we only attack witnesses who look like you with allegations of incompetence and a lack of ability to lead their agency, it's indicative of the need for this committee, what the American people look like. And I want to appreciate you today for withstanding what you have had to endure thus far, and we've only begun. But I will say this, Chair Khan, Americans rely on regulations to protect consumers and workers in this country, and the Federal Trade Commission should be as aggressive in its enforcement as the circumstances dictate. Today in America, there are only 4 large corporate conglomerates that control the market for beef, pork, and poultry. Consolidation in the meatpacking industry shows up at the grocery store, resulting in inflation for consumers, and at the same time, coincidentally, record high profits for the corporate conglomerates who are soaking profits from the American people. A single company controls most of the web searching, and a single company controls nearly half of all e-commerce. That's too much power in the hands of too few corporations. And they can hike prices with little recourse. They control vast amounts of personal data, and consumers are being squeezed by consolidation in almost every aspect of the marketplace, from food production to hospitals. So I'm glad to see that you are using your position to strongly enforce antitrust laws to ensure fair competition and prices. Moreover, we're lucky to have an FTC chair who does not have personal or monetary conflicts of interest that would require her to recuse herself from cases involving big tech companies. That is a good thing. Because of that, Chair Khan is able to lead an agency that is properly investigating companies like Amazon, Meta, Facebook, and Twitter. And I'm glad that we do not have the fox guarding the hen house, that we instead have an FTC that is actively working to protect American consumers. Now, I want to ask you, Chair Khan, pharmacy benefit managers manage prescription drug benefits on behalf of large insurers, large employers, and other payers. However, this middleman role allows PBMs to artificially inflate the prices of drugs that individuals must pay for critical medications, resulting in consumers having to pay almost 20% more for generic drugs. And the market for PBMs is an area of the market that is highly consolidated, with just 3 PBMs controlling 79% of the market. What can the Commission do to ensure the market for pharmacy benefit managers is competitive and fair so that Americans can afford their prescription drugs?
This is an area where we're looking very closely. We issued a policy statement last year unanimously noting some of our concerns in the pharmacy benefit management space. In addition to the consolidation that you mentioned, we've also seen vertical integration. So these PBMs have also now expanded into insurance. Sometimes they're competing with the very pharmacies that are dependent on them. We've heard that that can create conflicts of interest. We've also heard that these PBMs demand rebates in ways that may be denying patients access to more affordable drugs. So we've put the market on notice that we are looking at these practices closely. If we find law violations, we won't hesitate to act.
Thank you, Mr. Chairman. I have a unanimous.
Mr. Chairman, I have a point of order.
I have a unanimous consent request.
Do the point of order, then I'll come to your unanimous consent.
Mr. Chairman, I waited for the gentleman to complete his time, but I must raise a point of order that I personally felt that he was referring to all Republicans, but particularly to me, for his comments about diversity and his comments about our treating the witness apparently because of the color of her skin, which happens to be similar to my brown skin. And I would ask that that portion of his testimony be taken down as inappropriate and argumentative to and making a racial slur against myself and other members of the Congress, who, by the way, yesterday treated what I would call a very white man of a greater age.
Is this a
very
point of order,
similarly.
Mr. Chairman, or is this a speech?
I don't think the gentleman's point of order has been stated in a timely fashion. It's supposed to happen right after the statement.
Then I withdraw my point of order, but not my objection.
Well, I would just point out we should all engage in proper decorum, not disparage colleagues, not disparage people in the government, not disparage anyone. So let's just keep that in mind. And with that, I know we got a unanimous consent.
And thank you, Mr. Chairman. I would move for the entry of a letter from Small Business Rising to yourself as well as to the ranking member, Gerald Nadler, into the record without objection.
Without objection.
And I'd also like to take, if the chair will allow me to, the opportunity to simply clarify to my friend
briefly,
Chair Issa, that no personal affront was intended. This was directed at the entire panel.
We got that. The chairman recognizes the gentleman from Wisconsin.
That makes me feel good, Mr. Johnson. Thank you. Chair Khan, thank you for being here today. Last December, I sent you a letter along with several of my colleagues asking about the FTC's consideration of environmental, social, and corporate governance factors, or ESG as it's known, in merger enforcement. I appreciate that you had a prompt response in answering that FTC would not support conditioning the approval of the unlawful merger on the adoption of a particular set of ESG policies or commitments. While pleased with the first part of the response, you did not answer whether you would block a merger if it met traditional competition criteria but falls short of some standard on ESG goals. Can you commit that ESG criteria will not play a role in a decision by the FTC to block a merger?
Microphone, please.
Apologies. We look at the text of the statutes, which tell us to block mergers if they substantially lessen competition or tend to create a monopoly. That's what we look at. Again, if companies make certain commitments to us about social justice commitments or ESG commitments, those are irrelevant to us.
Okay, thank you. Since becoming chair, have you ever communicated using Signal, WhatsApp, or through a different encrypted messaging app on matters principally related to antitrust or consumer protection policy, FTC enforcement actions, press, political strategy, or any official communication? In particular, I'm interested to see if you've had any communication with Senator Warren, state's attorneys general, or outside groups.
Congressman, the FTC has a very clear policy requiring that any FTC business relating to substantial matters be conducted only on authorized FTC devices, and I fully comply with that policy.
Did you have any communication with now senior advisor, Ms. Sarah Miller? Sarah Miller works for you, is that right?
Ms. Miller joined my staff earlier this year, correct?
While she was in her role at the Economic Liberties Project, regarding the decision to air attack ads on members of this committee, including myself, for our opposition to the FTC's proposed non-compete rule.
Congressman, I talked to a lot of people, but I'm never involved in those types of discussions.
So you weren't involved in the idea to, in fact, go after members of this committee in their districts?
Congressman, we're really excited about this proposal. We're accepting a lot of public comments. We're eager to hear from members of Congress. I've talked to many of you about the proposal. We're eager to hear your feedback and input.
It was announced last night that you intended to break 30 years of precedent by challenging the court's ruling in the merger of Microsoft and Activision. Can you explain why, despite 39 countries and the European Union already clearing this merger, that you intend to move forward with on administrative proceedings?
So, Congressman, again, this matter is pending before the Commission in our administrative adjudication, so I can't comment on the merits. When we get an adverse ruling, our teams look closely at the text of the opinion, determine whether there are errors of law that they believe warrant an appeal. Those are the types of considerations that they take into account.
In April this year, the FTC's Associate Director for Litigation for the Bureau of Competition stated at a conference that, quote, merger policy is industrial policy, and, quote, there is a role for merger policy in directing the way capital flows into projects. That means at the next venture capital meeting, they're not going to say, what's the exit via acquisition? It will be, how do we get to an IPO? Do you endorse this statement?
Congressman, I'm not familiar with the details of it. Happy to look at it in a question for the record. I'll say generally, it is true that antitrust and competition policy is about ensuring robust competition. Entrepreneurs benefit from that. Startups benefit from that. I just met with some venture capitalists the other week that were expressing concern about a lack of exit options that don't involve being bought up by one of the large technology companies. So these are certainly issues that we hear about.
I think the issue for myself and many of my colleagues has been that the way you're running the FTC, that you're not simply trying to kill deals in the boardroom, you're also killing small businesses still in the crib. You want startups to seek an IPO rather than an acquisition, but the cost of entering the public markets has doubled since the 90s, and your colleague, Mr. Gensler, at the SEC has been piling on with the rulemaking. So I don't know if this is what the administration means by Biden economics, but I have to ask, why would anyone start a small business under this administration right now?
So, Congressman, we hear regularly from small businesses. One of the things that we started since I joined the commission is open commission meetings where anybody in the country can sign up and come talk to us. We hear from a lot of small businesses. More often than not, what we hear is about the challenges that they face in being able to compete in an open, competitive marketplace. We hear about how the existing giants and existing incumbents are squeezing them and making it difficult, be it for an independent grocer, an independent pharmacist. So we are very eager to hear from small businesses and make sure we're enforcing the laws in the ways that are enabling everybody to compete in the marketplace.
Chairman, I yield back.
Time of the gentleman's expired. Gentleman yields back. The gentlelady from California is recognized.
Thank you, Mr. Chairman, and thanks to our witness for being here. I have an interest in several areas where it seems to me the FTC has been less than robust, and which maybe you can disabuse me of that notion. First, in the area of swipe fees. Visa and MasterCard have more than 83% of market share. This is, Congressman Gooden and I introduced the Credit Card Competition Act of 2023 to introduce competition. Our small businesses pay a higher swipe fee than people do in other developed nations, and I'm wondering whether the FTC will be having an active engagement in this area. I'm also concerned about the issue of consolidation in the grocery sector. These large companies have the power to secure preferential pricing and treatment from suppliers to the detriment of independent grocers. Now, recently, Mr. Tiffany and I led an appropriations request for $10 million specifically for FTC enforcement of the Robinson-Patman Act. I'm interested in what you can tell us about FTC and Robinson-Patman. I also have long been a champion of right to repair. Congressman Ice and I recently introduced a legislation to limit the enforcement period of design patents so that monopolies cannot prevent individuals from repairing their own what they own. The nixing the fix report was before your tenure, but I'm interested in what FTC is interested in doing in this area going forward. And finally, Congresswoman Eshoo and I introduced what I think is the toughest online privacy act that's ever been introduced in Congress. It simply prevents companies from collecting data so they cannot then use it to manipulate Americans. I'm interested in what actions the FTC is going to take to minimize data minimization, which I think is a key to data security, privacy, and also helpful in competition.
So on your first point, just a few months ago, the FTC announced an enforcement action against MasterCard. We alleged that there was a violation of the Durbin Amendment and that MasterCard had engaged in unlawful tactics to block competing networks and really stifle the competition that Congress has sought to encourage in this market back in 2010, because I think you're absolutely right. We still see fees that are much higher than what we see in sectors where you have more competition. Robinson-Patman and reinvigorating enforcement of it is a top priority. We've certainly heard from independent grocers about the ways in which differential treatment and discriminatory prices may be squeezing them and disfavoring them, making it difficult to compete, especially in parts of rural America. That's something that we're looking at closely. We also, several months ago, launched a market inquiry looking at supply chain disruptions and the degree to which that type of differential treatment may have contributed. On right to repair, this has been a big area of focus for us. In addition to the great staff report you mentioned, we also issued a policy statement. We followed up with several enforcement actions, including one against Harley-Davidson, one against Weber. Since then, we've also been working with state legislatures, several of whom are also considering right to repair legislation. Just the other month, one of our staffers went to California to testify before the state Senate there to give input and feedback on their legislative efforts in this area. So we're bringing our own lawsuits, but also looking to serve as force multipliers where other legislators are looking to be active. Ensuring robust privacy protections for Americans is a top priority. We've been extraordinarily active in this area, especially when it involves children's privacy. We brought an enforcement action against Epic Games because we found that certain lax privacy policies that they had in place were endangering children. We've also been looking at people's sensitive health information and instances in which companies are collecting health data for the purpose ostensibly of providing health services, but then are turning it around and making it available for advertising. And we're also looking at geolocation data. We have a lawsuit pending in Idaho against a data broker called Kochava, where we allege in our complaint that its practices allowed companies to track and get very sensitive geolocation information on consumers in ways that revealed whether they were going to church, whether they were seeking certain types of health services, whether they were seeking addiction recovery facilities, very sensitive data. So that lawsuit is still pending.
Thank you, Mr. Chairman. I see my time has expired, and I yield back.
Gentlelady yields back. Chair recognizes himself. Madam Chair, why are you harassing Twitter?
Congressman, thanks for the question. As you might know, the FTC's work on Twitter goes back a decade. Back in 2009.
I'm not talking about a decade. I'm talking about now.
Back
12 demand letters in 10 weeks, over 350 separate requests you've demanded of Twitter. Why are you harassing them?
Twitter has a history of lax security and privacy policies.
You've asked for every single communication relating to Elon Musk, not communications that he just sent to someone or some communications he received, but any time he's mentioned. That actually seems more than harassment. That seems like almost an obsession. Why such an intense focus?
So, Congressman, again, it was found that Twitter's lax privacy policies allowed unauthorized users to co-opt Twitter accounts, including that of Fox News. Subsequently, Twitter voluntarily entered into a consent order with the FTC.
Here's what you wrote in December. Madam Chair, here's what you wrote in December. Identify all journalists and other members of the media to whom Twitter has granted access since Musk bought the company. You want to know the name of every journalist a private company has talked to? Think that's consistent with the First Amendment?
Congressman, as a former journalist, I take extremely seriously the valuable work that they do and understand that there can be instances in which government action is unjustifiably
Particularly, Madam Chair, if I could just interject, particularly in the context here. I mean, it's bad enough if you got government asking a private company about who are the journalists you're talking to, you name 4 of them and say, we want the other names of any journalists you may in fact be communicating with. That's bad enough, and I think a threat to the First Amendment freedom of the press. But in the context of giving us information about how government had suppressed speech on these platforms, that's the context you're asking for. I think that's particularly troubling, don't you?
Congressman, the consent decree that we have prohibits Twitter from sharing personal information with third parties. When we read in the papers, like everybody else, that Twitter may have granted access to third parties, that's what our teams were seeking information about. Again, this is a company whose history with the FTC goes
Madam
back
Chair,
a decade.
we got limited time. Madam Chair, who is David Roque?
Could you repeat that, Congressman?
David Roque, R-O-Q-U-E. Who is David Roque?
I'm not familiar with
You
that.
deposed him last month, June 21st, 2023. David Roque is the independent partner for Ernst & Young's independent assessment of Twitter's program. That's part of this consent decree. Do you know what Mr. Roque said in that deposition?
I'm not aware.
Okay, let me read it for you then, because I think it's pretty important. Mr. Roque testified, again, one of your lawyers, you deposed him, testified that FTC's conduct made him feel as if the FTC was trying to influence the outcome of the engagement before it had started. He said, in some of the discussions that we were having with the Federal Trade Commission, expectations were being conveyed about what those results should be before we had even begun any procedures. So they're the independent assessor in this consent decree the FTC has with Twitter, and you're telling the guy who is the person. He's the guy. He's Joe the accountant who's going to get this information. You're telling him, you're putting your finger on the scale, telling him what you want the outcome to be, and he's supposed to be the independent fact finder. Why are you doing that?
Congressman, I'm not familiar with those.
Because it was just filed today, but we are. This is filed in court today, and this is your deposition.
I'm happy to take a closer look at it and be back in touch. I will say as a general matter, we want to make sure that the assessors and auditors that are responsible for overseeing compliance are doing their job.
You say Mr. Roque's line, what he testified here, what's been filed in court today, that there were suggestions of what they would expect the outcome to be, they being the FTC, there were suggestions of what they wanted him to go find in his independent assessment of the consent decree agreement between the FTC and Twitter.
Again, I'm happy to take a close look and we can be back in touch with you about that allegation, but our staff are consummate professionals. When they conduct these investigations, they're focused on determining whether there was a violation.
Is your attack on Twitter, harassment on Twitter, is that based on the fact that all kinds of Democrats have asked you to do this and frankly some things that you've written about dealing with, quote, disinformation? Does that have anything to do with it, Ms. Khan?
Congressman, we make only independent determinations about whether there were law violations.
The statement from Chairman Nadler, the statements from the letter, the press release and the letter from 7 Democrat senators that had no impact on it, that's not why you're doing it?
Absolutely not. We look very closely at the specific matter at hand. Again,
12 demand letters in 10 weeks telling the independent assessor, hey, put your finger on the scale, this is the results we want. That's not harassment, and it had nothing to do with the fact that every Democrat in this town seemed to be telling you to go after Twitter.
Our focus is on protecting people's privacy and security. Twitter has sensitive data on 150 million Americans, including private messages. We need to make sure, especially given its history going all the way back to 2010, we're doing everything to make sure Twitter is complying with the order.
That's fine. Don't put your finger on the scale, and don't attack the First Amendment and the rights of journalists.
Mr. Chairman,
that,
point of order.
I yield back and recognize the gentleman from California for 5 minutes.
Thank you. Madam Chair, thank you for your testimony today, and thank you for the refreshing and aggressive approach you're taking to ensure competition. In my view, we have reached a dangerous point in this country where there has been a tremendous concentration of corporate power at the expense of working families. The challenge we face today is not that people aren't working. People are working. The problem is they're not making enough to get by. And part of that is the result of this concentration of power in corporate hands, the likes of which I don't think we have seen in our history. So I appreciate the work that you're doing. I want to ask you in particular about an issue I've written to you about that concerns me, and that is consolidation among the large grocery stores, the large grocery chains. This has the potential of not only having an adverse impact on price, but also having adverse impact in the form of job losses, in the form of creation of food deserts impacting communities. I would, if you're able to share your thoughts in terms of that particular merger, great. If you're not, I would ask more generally what you're looking at in terms of impacts and also vis-a-vis the narrowness of the doctrine that focuses only on consumer prices. Would that prevent you from looking at other criteria such as the impact on communities and the impact on workers?
So we seek to take a 360 view to make sure we're fully understanding how a particular merger may be lessening competition in ways that are harming consumers, but that may be hurting suppliers. In the context of grocery mergers, we really take care to make sure we're looking at all sides. As you noted, there is a pending investigation that Kroger Albertsons have disclosed. The FTC is looking at their proposal. I think you're absolutely right, though we've seen the consolidation in the grocery sector can have devastating effects for communities, contributing to food deserts. One practice that is also on our radar is the way in which grocery chains can be using what are known as restrictive covenants to try to lock out competition geographically, which may also be contributing to these food deserts. So we're looking at that closely, and we want to make sure that we're enforcing the antitrust laws in ways that are serving all communities.
Well, I appreciate that. I have grave concerns about the Kroger-Albertsons merger and the impact on the communities that I represent and many others throughout California and the country in terms of impact on workers, on prices, and on communities. Let me just turn to the issue that the chairman was just raising with you. You didn't get much of a chance to elaborate on the privacy and security problems at Twitter and how they could impact the privacy of millions and millions of Americans. I'd like to give you that opportunity because I'm both concerned with the enormous proliferation of hate speech on Twitter, the firing of many of the individuals charged with security at Twitter, and what impact that has on the rise of hate, but also on the decrease in security and privacy of people's data at Twitter.
So again, we're squarely focused on the privacy and security implications of any decisions that may be made. As I noted, Twitter's history with the FTC goes back over a decade, where serious security and privacy lapses led to personal information being compromised. As you noted, Twitter today also has access to deeply personal sensitive information. In 2022, we entered into a revised consent order because we found that Twitter, unfortunately, had been in violation of the prior consent order. Whenever we have repeat offenders at the agency, we're always thinking very hard about what we can be doing to prevent repeat violations. Our revised order has even tighter privacy and security provisions. It was voted out unanimously at the commission, and we'll continue to make sure that our orders are being followed and that companies are protecting people's privacy and security.
Well, I appreciate that, and I'd also like to ask unanimous consent to enter in the record a couple articles, one from Gizmodo, Elon Musk, king of censorship, 10 times the free speech abolitionist silenced Twitter users, and also an article from Rest of the World, Twitter's complying with more government demands under Elon Musk, which includes Twitter's self-reported data shows that under Musk, the company has complied with hundreds more government orders for censorship or surveillance, especially in countries such as Turkey and India. It requests consent to enter
Without
the
objection.
record. Thank you, Chairman. I yield back.
Gentleman yields back. The gentleman from Colorado is recognized.
I thank the chairman. Chair Khan, thank you for being here. Do you own stock in Apple, Amazon, Facebook, or Google?
No,
Do you own stock in any of the competitors to those companies?
I do not.
Do you know that the ethics official who requested that you recuse yourself from any activities involving Facebook owned stock in Facebook?
I learned about that, yes.
Do you know how much it costs to buy Congress? Well, big tech does. They spent $250 million against the bills that passed out of this committee last Congress. They spent money lobbying. They spent money on advertising in members' districts. They spent money with third-party think tanks. They spent money that no other effort in recent memory certainly has been spent. And it's not just the money that they spent, but on lobbying, for example, Meta spent, and I call it Facebook, $20,070,000, Amazon $19,320,000, Alphabet $11,770,000, Apple $6,500,000. But it's not just the money that they spent on lobbying and those activities. On June 18th, 2021, just 5 days before the markup hearing of the big tech bills in this committee, Paul Pelosi, Nancy Pelosi's tech investor husband, bought 4,000 shares of Alphabet via a call option in which he promised stocks at a later date at a price of $1,200 a share. A month later, now this is after we've passed the bills, but Nancy Pelosi, the Speaker, sent Steny Hoyer, the Majority Leader, to the press to tell the press that these bills were not ready for the floor. A month later, the stock price rose to over $2,500, making Paul Pelosi $5.2 million richer without spending a penny. Speaker Pelosi's office, it should be noted, issued a statement denying any involvement or prior knowledge of the transaction. The fact remains that she refused to bring to a vote on the House floor those bills that resulted from an 18-month-long investigation. We had last year, as a result of Congresswoman Jayapal's efforts and my efforts and some other efforts, a stock ban in the House, a ban that would prohibit members from buying individual stocks. You probably also don't know that more than 50 members of Congress bought stocks in pharmaceutical companies during the COVID crisis when Congress immunized, a good term, I guess, to use during the COVID crisis, immunized pharmaceutical companies if there was any problems with the vaccines that they created. But we can't pass a stock ban, but we can call you into Congress and suggest that somehow you shouldn't be involved in activities involving some of these companies because you wrote a law review article. Do you have a child? I don't want you to answer that question just yet because that's personal. But do you have a child who is lobbying for Amazon or Facebook?
No, he's turning 6. He's turning 6 months this week, so no.
Okay.
They'd probably still hire him.
Yeah. If they thought they could influence you, they would hire your child at 6 months old because, in fact, they've hired Senator Schumer's daughters to lobby for them. And the same bills that passed the House didn't get a chance, the same bills that passed the House Judiciary Committee passed the Senate Judiciary Committee and never saw the light of day on the Senate floor either. But that's just how the game goes. You're well aware of the need to update the antitrust laws concerning the new economy that we are facing. And I'd just like you, if you could, briefly to explain what is the need? Why is it so difficult to apply antitrust laws written at the turn of the last century to the new economy?
Thanks, Congressman. So there is antitrust doctrine on the books that has embedded within it certain economic assumptions about how certain markets work, about what types of incentives businesses face. That doctrine in some cases is 30 years, 40 years old, way before we had the advent of digital markets. These digital markets function differently, right? You have the self-reinforcing advantages of data, network externalities, companies face different incentives, they're engaged in different strategies, and sometimes there can just be a gap between how the doctrine is saying businesses are acting and what we see in reality. And so legislative updates can be needed to close that gap between what the theory says or what the doctrine says and what we're all living with in actual markets. And so that's in particular where legislative action can be absolutely critical.
Gentleman's time has expired. Gentleman yields back. The gentleman from California is recognized.
Thank you, Mr. Chair. Chairperson Khan, welcome today. What is your job?
I have the great honor of serving as chair of the Federal Trade Commission.
And what do you do in that role?
Well, help manage the agency, oversee both our Bureau of Consumer Protection's work.
Protect consumers?
Protect consumers, protect fair
Where do you get that
competition.
authority?
Congress charged us with that in the FTC Act and subsequent legislative amendments.
Is that new?
Excuse me?
That authority new?
That authority stems back to 1914 and then subsequent amendments in the following decades.
We talked a little bit earlier about litigation fees, enforcement costs. Let me ask you, are you a profit center or are you an agency in charge of protecting consumers, enforcing the law, and going after individuals that may prey on our consumers or taxpayers?
We're a government agency that is using every dollar we have to protect the American people from illegal business practices.
Thank you. Let's talk about Main Street, people who sent us here to Washington. I get scam calls every day, robocalls. Seniors get robocalls every day. Veterans get robocalls every day. How are you working with the FCC to stop these calls from happening?
So we in the FCC have overlapping jurisdiction, as you noted. One thing that we're doing, in addition to going after some of the robocallers themselves, is identifying what are some of the upstream factors that are allowing these calls to proliferate. Sometimes these calls are originating from other countries in ways that can make it difficult for us to go directly after them. This is why we look at VoIP providers and other upstream
Madam
service
Chair,
providers.
a number of years ago, I had a situation in my district. We had to get Interpol involved. Calls were originating from Mexico. One of the local telephone companies were providing the calling information, and it was a huge, huge mess. International, very much a difficult challenge. What can we in Congress do to help you rein in these predatory calls?
There are certainly legislative updates that we're happy to recommend to you and your team. I would say generally, given that the FCC also has authority over the telecom carriers themselves, directly taking action at that layer could also probably have a very big impact.
You know, at the end of those scam calls, you have victims, people that get hurt really bad and struggle to get that money back. What is your agency doing to help consumers get their money back?
We're bringing lawsuits where we can. Unfortunately, a couple of years ago, we suffered a big setback in court where the court said that 13B of the FTC Act, which has been a core provision that we use to go into court and get back money for people who have been scammed out of money, the court said we can no longer use that authority. That was a big setback. Since then, we've been activating other legislative authorities to make sure we're trying to get money back where we can, but there's no doubt that billions of dollars evaporated after that court decision and people are losing out as a result.
So do you need legislative help from Congress to do your job, protect consumers in this area of junk fees?
Absolutely. Legislation, in particular, enabling the FTC to go into court under Section 13B and get money back so that lawbreakers are not profiting from their lawbreaking, that would be essential.
I think that's important. Lawbreakers need to know there's somebody there, a police officer waiting to make sure that they follow the law. And too many times, my locals get ripped off. They call the local PD. They don't know what to do. They call the local state agency. They don't know what to do. And I hope that you and your agencies can continue to be effective in making sure that consumers on Main Street are protected. Our seniors especially, that sometimes are embarrassed to call me and tell me I just got ripped off, that don't have the energy or the wherewithal to defend themselves. These are the people we need to be protecting. I asked you if you were a profit center. I know you're not, but nonetheless, I encourage you to continue to do a good job, because my constituents, American taxpayers, are relying on your agency and doing a good job. Thank you very much. And Mr. Chair, I yield.
Gentleman yields back. The gentleman from Virginia is recognized.
Thank you. Madam Chair, you implemented the use of omnibus resolutions in antitrust investigations.
These resolutions, in effect, give the chair of the FTC sole control over FTC investigations. The chair could direct staff to investigate a transaction, sign all subpoenas without a commission vote, which was previously necessary in investigations of almost all mergers and business conduct. Former commissioners Phillips and Wilson resigned over much of this type of action from you, said that this paragraph eliminated the only layer of commission oversight. Wouldn't you agree that the use of omnibus resolutions in this matter undermines the bipartisan nature of the commission model? And are you trying to turn the commission into your own personal empire?
Congressman, omnibus resolutions have long been used at the FTC before I joined. It's fairly standard for there to be omnibus resolutions on the consumer protection side, again, long before I joined. Changes we made brought the consumer protection side in symmetry with the competition side in order to empower our staff to act nimbly.
Okay, let's talk about that, because the staff has been leaving in droves. A report by Bloomberg found that 71 senior attorneys left the agency in the 2-year period between 2021 and 2022, the highest number of departures in the category for a comparable 2-year period since 2000. Coincidentally, the Progressive Change Campaign happens to have a list of 400 recommended names for positions in the FTC and the Biden administration. Has anyone, including Adam Green of the Progressive Change Campaign, communicated with you to hire any of these individuals?
No.
Okay. And have you hired any of these individuals?
No, I don't know what list you're talking about,
Okay.
to be honest.
Let's move on to this committee and your responsiveness or lack thereof to this committee, following up on what the chairman asked. In March, your director of the Office of Congressional Relations testified before my subcommittee on responsiveness and accountability to oversight regarding your refusal to produce documents related to this committee's oversight of the FTC's harassment of Elon Musk following his acquisition of Twitter. It's well known that the FTC frequently seeks extensive information from the parties that it investigates. When those parties fail to produce what's required for the FTC to conduct its investigation, the FTC seeks sanctions. In the FTC's response to this committee's inquiry, most of what it has provided is already publicly available or otherwise incomplete. I find it inconceivable that the FTC would tolerate such a production from parties under its investigation. So what should this committee do and take from the FTC's paltry production to date on this matter?
Congressman, our team has been enormously responsive. We've been working day after day to accommodate this committee's requests. We've offered and provided numerous non-public briefings, including on the matter that you mentioned. It is true when we have an ongoing law enforcement investigation, there are additional considerations we have to take into account to make sure we're not compromising law enforcement or chilling any of the free speech of the third parties that communicate with us.
Does that include communication through non-governmental email accounts? Because in the limited materials that you provided, we can see that your staff communicated using Gmail accounts. In other instances, employees from other agencies were using the employee's email account attached to that separate agency. So you were talking about how you're committed to using government communications methods. I don't know if you're aware that your staff is not, but what steps have you taken to secure responsive material from sources outside the FTC?
Congressman, whenever anybody onboards onto the FTC, we provide extensive training to make sure everybody knows only to use authorized devices. If sometimes inadvertently there is a message that props up somewhere else, you're supposed to forward it to your FTC email, and I imagine that's why it was actually captured in those productions.
Okay, you asked Congress for a historic budget increase of $160 million, or 37%, citing staffing shortages, which you're largely responsible for, and insufficient resources. Did you announce a joint effort within the DOJ Antitrust Division with the FTC to send staff to Europe to assist with implementation of their Digital Markets Act?
Congressman, we have a really fantastic Office of International Affairs that I inherited. It was launched in 2007 during the Bush administration. As part of our international efforts, we're routinely sending detailees.
Do you know how much that costs?
Excuse me?
How much does it cost to send staffers to Europe?
I don't know off the top of my head, but we're happy to provide that information if it would be helpful to you.
Okay, well, due to the rank partisanship that's come up in your agency, the fact that you all are ignoring congressional requests for information and the wastefulness that we've seen, I know that the Appropriations Committee is marking up your budget as we speak, and they are seeking a 25% reduction in funding for the FTC today. Actually, the Appropriations Committee is going to be passing that government funding bill. So actions have consequences, Madam Chair, and you're about to see what consequences your actions have had. I yield back
Gentleman yields back. The gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman. Chairwoman
Oh, I'm
Khan-
sorry. I was told.
Sorry,
I
Mary
was just told that too and forgot. The gentlelady from the other side of the country is recognized from the state of Washington.
Thank you, Mr. Chairman. Chair Khan, as head of the Federal Trade Commission, I would just like to thank you for the FTC's investigations and enforcement actions that protect small businesses and hardworking Americans and promote competition. You have done what few before you have dared to do. Few before you have had the courage to take on big corporations who use their endless lobbying money to hurt Americans with more fees, less transparency, and higher costs. You're taking on big tech and the monopoly powers that allow them to use our data and snuff out small business competitors. That was something that yesterday I got a lot of bipartisan praise for in taking on Director Wray at the FBI around privacy. You're doing the same thing, and there should be more people like Representative Ken Buck talking about that on this committee, talking about the efforts that you are making to finally put teeth into protecting consumers, and I am grateful to you. In fact, I think it's precisely because of your success, your courage, and your integrity that you are receiving all these baseless attacks on your character. So just for the record, here are the facts. It was FTC ethics official L'Oreal Pankey who owned stocks in Meta when she recommended that Chair Khan recuse herself from investigating Meta, Facebook's parent company. In contrast, Chairwoman Khan owns no stocks in big tech, not one penny, and a federal judge ruled that her stances do not constitute a conflict of interest. So I want to thank you to your integrity and your commitment to mission, which is precisely why the President appointed you to head the FTC. Now, I want to spend my time talking about your accomplishments, the FTC's accomplishments under your leadership. 1 in 5 workers are affected by non-compete clauses, which essentially means that employers restrict or ban workers in their employment contracts from freely switching jobs, just for the average person who's out there listening. The FTC is currently working on banning these non-compete clauses. Can you explain in plain language why your agency proposed this rule to ban non-compete clauses?
I'm happy to, Congresswoman. I would be remiss if I didn't know you mentioned our ethics officer. From working with her, I know our ethics officer to be a dedicated career professional who serves the agency with nothing but its best interests at heart. I understand in that instance she sought guidance from the Office of Government and acted consistently with it. On non-compete, so these are clauses that lock in workers and prohibit them from being able to seek an alternative job competitor for a period of time and oftentimes geography limits. We've seen our work that these clauses suppress workers to the $300 billion, and they also make it difficult for startups and entrepreneurs and new businesses to enter and compete. That's why we've proposed a rule.
And which of workers are going to benefit from the implementation of that rule?
At the proposal stage, it would be everybody. We've heard from gardeners, journalists, healthcare workers, fast food workers, engineers, scientists. I mean, these non-compete clauses have really proliferated across markets and across our economy in ways that are now hurting everybody.
So let me turn to your work on junk fees. There are a few issues today that unite members of Congress more on the Hill, and I'm proud to say that junk fees attract the ire of both Democrats and Republicans because, as your agency notes, they are, quote, surprise charges that inflate costs while adding little to no value. So tell us how widespread these junk fees are and give us some examples of what you're talking about and how they harm consumers.
Yeah, I mean, I'm sure everybody can relate to this in their day-to-day lives. These are mystery fees that show up, be it a resort fee charge on your hotel bill or an unwanted or unnecessary charge that shows up somewhere else. One of the areas where we've heard most about these junk fees is in the auto context. Buying a car is one of the most significant financial investments that people make, and unfortunately, we've heard that all too often consumers are saddled with charges for unnecessary or unwanted or redundant fees. We're moving forward there. We also brought a lawsuit last year against Vonage for also including some of these junk fees when people tried to cancel their subscriptions. So that's just some of the work. We currently sought comment on whether we should do more work on junk fees, including through potentially proposing a rule. we're reviewing those comments and determining how to move forward.
And the FTC's got a long history of dealing with junk fees, is that correct?
That's right.
Can you talk about that?
So again, in the auto context in particular, I mean, we've gotten hundreds of thousands of complaints about this. We've brought dozens of lawsuits addressing junk fees that consumers are saddled with when trying to buy a car. But it's really, market-wide that we've seen these charges emerge and that we're looking to be actively addressing.
Well, I want to thank you for your work. Hope that we talk more about some of the shared interests that we have across the aisle. Thank you. I yield back, Mr.
Chairman.
How timely. You are a brilliant woman with a tremendous ability to impact how consumers are going to interface with the digital world for a long time to come. And I want to get to those areas of agreement, but there is some ugliness we got to deal with. Now, you guys putting in the names of reporters in a correspondence to Twitter was solely predicated based on anonymous news source, right?
It was based on reporting that
Right, and we would agree that anonymous reporting is not a sufficient predicate to target, to send letters about journalists who are your critics, right?
Congressman, the goal is third parties, but this is good feedback. We want to make sure we're not in any way suggesting that we're interested in, affecting journalists' work. It's really about privacy security. So I
appreciate your acknowledgement that that is not the way we ought to do things. As someone who has seen ugly government action emerge out of anonymous reporting, perhaps I'm a little sensitive to that, but I'm glad that you got acknowledgement. Let's get on to the important work that you are doing. Millions of Americans have Ring doorbell cameras. And your agency recently put out a correspondence saying, quote, during a 3-month period in 2017, a Ring employee viewed thousands of videos of female users in their bedrooms and bathrooms, including videos of Ring's own employees. There was also, according to the FTC, an unauthorized tunnel that allowed a Ukraine-based contractor to access consumer videos, where a Ring employee gave information about a customer's their ex-husband was also something that you uncovered. You also state that bad actors at Ring took advantage of the two-way communication functionality to harass and threaten people who used Ring cameras. There was a case where an 87-year-old woman at an assisted living facility was sexually propositioned through Ring's two-way features. Kids were subject to racial slurs. A hacker got in and threatened a family with physical harm if they did not pay a Bitcoin ransom. And one hacker even communicated through the two-way feature to a customer that they had already killed the customer's mother and, quote, tonight you die. What is going on at Ring?
So as you noted, we recently took enforcement action precisely because of these very serious lapses in data privacy, which endangered Americans in their day-to-day lives. Overall, looking at some of these surveillance devices and how they can be misused and abused is a top area of focus for us because people's privacy is paramount.
Yeah, I thought that when people got Ring, it was to enhance their personal security, not to have their 87-year-old relative in an ALF sexually propositioned, their children to be slurred at, and then to be told that they were going to be killed if they didn't pay Bitcoin ransom. So thank you for that effort. Let's go to another evil company, Kochava. Kochava is one of these data brokers that you're going after, right?
That's right.
And the American people should know that Kochava geolocates where people go to church, and then they sell that data to commercial enterprises, right?
That's right.
That's real creepy, isn't it?
I believe people would have that reaction, yes.
I got onto the FBI director yesterday for their creepy FISA activity, and now we have Kochava literally selling to people, oh, well, this is a Baptist, this is a Methodist, this is someone who goes to temple. Are you going to get these people and stop them?
So we have a pending lawsuit. We filed it last year. The court dismissed it. They gave the opportunity to refile. We just refiled an amended complaint. I think it's urgent to have here because, types of stigmatization and harms that can stem from being able to track people's sensitive geolocation information is just critical for us to be addressed.
We didn't like it when the FBI wanted to infiltrate the Catholic churches. I don't know that I want data brokers to do this. By the way, we've even seen how the FBI is using the data brokers to do an end run on the Fourth Amendment. So I really want to encourage your work in this space. And I hope that your litigation with Kochava is something that creates precedent. And you know what? If there's been criticism of your losses in court, we as sophisticated lawyers know sometimes that a motion to dismiss an initial complaint can create a pathway to an amended complaint to achieve relief. And so if the laws are insufficient to stop data brokers from selling information about where my constituents worship, and if the laws are insufficient to stop Ring from these activities, I really hope you'll work with us to change those laws. And all of Mr. Buck's points are really central to this because Congress is bought off. If people are just coming here to beat you up over what email you use or if you've been on to Europe, I think misses these things are far more central to the life that our constituents lead. Thank you for it.
I would say we're going to sell it. The FBI is probably buying it. That's the scary part. So
Agree with
I
both.
appreciate
Let's
that.
get a bill, Mr. Chairman, to deal with those data brokers.
We're working with the lady who just went right before you to do just that. That I think this committee can completely agree on. I need to mention earlier, Madam Chair, we've been at this hour and a half. If you need a break at any time, just let us know. We can keep going because we can get up and leave, but you can't. So you let us know if you need a break with that. If you're willing to keep going, we'll go to the gentleman from Pennsylvania for 5 minutes.
Thank you. Chairwoman Khan, I want to start by thanking you and the FTC for your work to protect American businesses and workers and consumers on issues ranging from privacy concerns to deceptive business practices to unwanted telemarketing and robocalls. To fraud and financial exploitation that targets seniors, service members, veterans, and those in recovery from opioid disorder. Those are all really important issues, and we hear from our constituents regularly about all of that. You don't have an easy job. It's not made any easier when bogus claims are levied against you in congressional hearings. Every day, some of our colleagues seem to be trying to prove the legal maxim that if you don't have the law on your side, argue the facts, and if you have the facts either, just argue. So we appreciate your patience in responding to a lot of fact-free questions. I want to focus my questions on hospital consolidation and the growing problem of private equity firms buying up hospitals and healthcare groups. In the Philadelphia region in recent years, we've had 2 major hospitals purchased by private equity firms, after which those firms mismanaged the healthcare functions of the hospitals, stripping them of their assets, and then either closing the hospitals or for sale. There was a hospital in 2020, which was in the middle of a pandemic, after a private equity-backed real estate developer bought it. That left a gaping hole in our frontline healthcare system in one of the poorest cities in the country. And then currently, the Crozier Health System is teetering on the verge of bankruptcy while hemorrhaging talented staff and medical practices after a private equity owner stripped the system of assets, undermined its relationships with medical staff, and has reduced access to medical care, particularly maternity care, emergency services, and behavioral health care. The impact on our local healthcare system has been so extreme, we've seen local Republican politicians calling for government intervention in this private equity firm's hospital business to prevent it from closing or bankrupting the system and its constituent parts. We're also seeing this troubling national trend in which private equity firms have embarked on a buying spree to scoop up smaller healthcare groups. And there was a revealing report from the Petra Center at UC Berkeley and the Washington Center for Equitable Growth detailing the trend of private equity firms buying multiple doctor groups in a city and then using that consolidation to raise prices. So we're really concerned about this trend. It's reducing access to care and raising prices. So what is the FTC's response to the call for more regulatory scrutiny over these transactions? How can it increase oversight and enforcement activities to ensure that we preserve competitiveness in our healthcare system?
This is such an important issue, Congresswoman, and we at the FTC, our team has done a fantastic job addressing hospital consolidation, in particular in low markets, a whole set of successes, really standing hospitals trying to merge in ways that would hurt patients. Our staff was able to block that transaction and the parties walked away. I think you're absolutely right, though, that today we're seeing different types of strategies, including the incursion of private equity. I recently met some emergency medicine physicians who had come from across the country who were sharing how the incursion of private equity is really harming the quality of healthcare people in very material ways. So that's something that's on our radar. We're trying to figure out how to update our tools to be able to address this. We recently issued some updates to what's known as our Hart-Scott-Rodino form. Sounds very technical, but it's basically the information that parties have to provide us when they're looking to make an acquisition. Partly, those changes would give us more insight into some of the type of roll-up strategies that you need so that we know on day one whether a private equity firm has this history of roll-ups that could put us on high alert. So definitely something that we're looking at closely.
Okay, I've got a couple more questions on that same topic that I'll save for the next round or submit to you, but I did want to yield 30 seconds to Representative Jayapal.
Thank you so much, Representative Scanlon. I just wanted to say quickly, before I ask my question, that I was not trying to attack the ethics of your ethics officer. I was trying to point out the hypocrisy of those on the other side who raise that you have a conflict of interest and don't mention other issues that might exist there. I just want to go to evil actors because there's one we really want to talk about, and that is tax preparation companies. For years, Intuit, the maker of TurboTax, flooded consumers with ads promising free tax filing services, only to trick and trap them in paying, which is why taxpayers pay $250 on average each year just for the privilege of filing the taxes. So state attorney generals have won taxpayers money from Intuit, and the FTC has also taken action. Can you speak about that?
Absolutely. So last year, the FTC brought a lawsuit into it for the very types of deceptive practices that are laid out in our complaint that is pending, but I could agree more. Claims of something being free, but then ultimately it not being so really hurts people.
Gentleman's time's expired. Gentleman,
Thank you, Mr. Chairman. Chair Khan, I'd like to begin with policies related to diversity, equity, and DEI that you instituted at the FTC during your tenure. Last month, you implemented a so-called Equity Action Plan, calling the FTC Bureau of Competition to, quote, update its case selection based on this new criteria. Allowing the Bureau to wade into picking cases based on these amorphous terms like equity is an idea that we believe is solve problems. We've also hired staff who have published articles on the topic of, quote, anti-racist antitrust. Can you explain to the committee what that means? What does that term mean?
Congressman, it's not a term that I've used. I can say generally, I know that there is a lot of worry that concentrated economic power hurts everybody, all communities, and that the FTC needs to be mindful to ensure that our work is focused on the harm that is affecting everybody.
Everybody, right? So anti-racism should not play a factor in competition and protection policies at the FTC.
And we bring a lawsuit based on the law at hand, so we look closely at where we
This is not one of the factors. Anti-racism is not going to be used on your watch, right?
There are instances in Congress that ask the FTC to look at whether particular community are being defrauded. In those instances, we follow what Congress has told us to do. But otherwise, we just follow the general laws. Correct.
Okay, a senior staff for your FTC recently attended an event, gave a speech, discussed applying the gender lens to antitrust, and senior staff raised a cross-agency equity team. Are you applying a gender lens in the constitutional analysis now?
To be honest, I'm not really sure what that means.
We are. I hope you're not. Okay, is there a cross-agency equity team? Are you accurate about that?
We have a lot of cross-agency teams. There are teams that are focused on how you make the FTC a better place to work, including by making sure that certain
Okay, but equity is not in your bid. You don't have a team dedicated, correct?
We have an agency team that's thinking about how to ensure that.
It's just she overspoke. Okay, fine. Do you think reorienting the FTC from protecting consumers to protecting favored groups, that idea would run counter to what the FTC's mission is, right? I mean, you said it's applied to everyone, right? You shouldn't be injecting these, I guess it's progressive policy initiatives that we're concerned about. The FTC has a really important mission, and we don't want you to get off course. Last year, on a party line vote, FTC also expanded its authority under Section 5 of the FTC Act well beyond what any previous FTC has done over the last years. In November 2022 policy statement, that power was expanded to unfair methods of competition that is described as, quote, conduct that goes beyond competition on the merits, and that, quote, here's the key, even when conduct is not facially unfair, it may violate Section 5. Following that decision, former commissioner stated, this is what she said, quote, the commission has created the authority to summarily condemn essentially any business it finds distasteful. That is an extraordinary power. Very concerning because unfair is an amorphous and very objective term by nature. Are you using Section 5 authority to determine what's unfair, even if it's facially unfair, whatever that means?
Congressman, we look very closely at the text of the statutes that Congress wrote. It's to the FTC Act and prohibit unfair methods of competition. We have to take those words seriously. When putting together that policy statement, our team closely at decades of case law to try to understand how courts interpreted what this means, and the policy statement reflects that.
Okay, real quickly, there's an example recently, I believe you're in the process of ending non-compete agreements as an unfair method of competition, and that's going to affect next year.
We've got 24,000 comments on the proposal, reviewing and determining how to move forward.
Would you favor a blanket ban on all non-compete agreements? Is that position?
So the proposal bans the vast majority of non-competes with a few exceptions, one of which is non-competes that are included as part of the sale of a business.
Okay, let me ask you a question. Have you ever run or worked in a small business?
I personally not.
Yeah. So do you think it's reasonable for entrepreneurs and businesses to spend considerable time and money developing practices to compete against their rivals to fund your ban on non-compete agreements? Unfair.
We'll hear from them. I know we've gotten a lot of input. The other things that we hear from small businesses is that non-competes make it difficult to compete. Because if they're going to enter and compete, some of the big guys locked up all workers who non-competes at small businesses. So we really have multiple views on this issue.
Out of time. Yield back.
Thank you, Mr. Chairman. Aware of that profound enemy of the free enterprise system, who pays lip service to free competition, labels every antitrust prosecution as persecution. Those words were by Franklin Delano Roosevelt 9 years ago. And I've listened to him today here, Madam Chair, and we're grateful here today. I've listened to many of the criticisms made by my colleagues, their leadership at the FTC, on the side of the aisle, not all my colleagues, most of them. And the vast majority of these criticisms have nothing to do with your ethics or your integrity, your approach to the job, and everything to do with corporate power. And the reality is that you have pursued your duties as the chairwoman of the FTC in a way that puts the interests of the consumers first. And that is a new approach at the FTC. I don't want to belabor the point because I have some substantive questions for you, but I'll ask for unanimous consent later at the conclusion of my remarks and our colloquy here for an article in the Wall Street Journal from June 30th, 2023, headline of which is Ethics Official Owned Meta Stock While Recommending FTC Chair Recuse Herself from Meta Case. We've spent time hearing my colleagues talk about this particular issue. I will just simply echo the comments made by my colleague from Colorado and my friend, Mr. Buck, who I thought spoke very powerfully on this front. Only in Washington, D.C., can an individual who has no financial interest in the merger before her be accused of an ethics violation by members of Congress who own financial, or have rather financial interests in the company that has petitioned for that, or is rather proceeded with that particular murder that is under review the FTC, on the basis of an opinion that was issued that didn't conclude that there would be a per se violation for the commissioner in question to proceed with considering the matter, but nonetheless opined that there was an appearance of impropriety, and of course the individual had financial interest in the company that was involved in the merger. And I'm not commenting, I agree with Paul, on the propriety of the decisions made by the individual or the estimate more broadly. I'm simply depending on the state of affairs in Washington, D.C. Because for years we've had FTC commissioners who had real conflicts of interest. You didn't have any financial interest in Meta, right?
That's correct.
You've never worked for Meta.
That's correct.
Basis, I understand it, for the objections by my colleagues and others, is that you have a certain view when it comes to putting consumers first and ensuring that monopolistic power does not reign supreme in our country. And I just think it's unfortunate that some of my colleagues in that approach. I will say, for my part, I'm grateful for the work that you have done at the department. I also am grateful for the work that your partners, and of course, other antitrust enforcement regulators, the Assistant Attorney General Cantor, has done over the course of the last several years. We, as you know, passed a bill on a bipartisan basis last year, as well as the Merger Filing Demonetization Act, which I believe will strengthen your efforts and your ability and the efforts of your workforce within the FTC by changing the fee schedule for mergers, actually decreasing the fees for smaller mergers, but increasing fees proportionally for billion-dollar transactions, giving you the source that you need to fight consumers on behalf of the American public. I wonder if you might talk a bit about the particular bill implementation and the impact it will have on aid resources.
Thanks for the question, and thanks for your effort leading that bill. It was much overdue effort. The filing fees, as you noted, made clear for larger transactions, there is a higher fee, for smaller transactions, lower fee. We can rely on those fees to be able to fund our enforcement, so that's absolutely going to be making a difference.
Well, as I said, I'm grateful for the approach that you are taking. I was proud to work on that bill with Representative Buck, who has been a champion on these issues, among other colleagues of mine on sides of the aisle, and I think we look forward to working with you, Madam Chair, for years to come on this front. That
Gentleman yields back from Kentucky's recognized.
I thank Chairman. You kids are contacting me worried about mergers between companies or that sort of thing, but one of the things I've contacted about multiple times is the small independent grocers feel like their monopolistic practices being used against them. And Mr. Korea and I sent a bipartisan letter to you asking for an update because in November 29th, 2021, this is 17 months ago, the FTC ordered 9 large retailers, wholesalers, and consumer goods suppliers to provide detailed information to help studies behind ongoing supply chain disruptions. And I appreciate you being able to give us a briefing, but can you brief us today? Like, what have you found? And are you able to help these complain about they can't get products, or there's discriminatory pricing, not based on quantity, but based on other things, or different package sizes? What can you tell us here today?
Yes, this is such an important issue, and we've heard from those independent folks as well. And it's part of what more decisions launch this study. We're moving as expeditiously as we can. As you can imagine, sometimes firms don't have an incentive to give us all the information we need as quickly as we need it, but we are moving ahead full speed and happy to be providing you with the non-public detail found so far. And we're looking to make our finding public as soon as we can.
I hope soon, in some months, to give the information. I understand it takes a while to get it to you, but I would hope we get that very soon. Another issue that concerns me are the so-called pre-commission warning letters. On August 3rd, 2020, FTC announced they would send warning letters in connection with and fully investigate within the time provided by the statute before the deal closes. Well, why should people trying to do regular business be behind it because it's taking you too long to do your job? And how many of these so-called pre-consummation warning letters have been sent by the FTC?
So the statute gives us only 30 days to deal to determine if we need to investigate further. As deals have become more complex, that can be a very, very, very tough timeline. We heard from some businesses that if we don't act within that 30-day period, the for them is that there are no issues and there are no concerns. So we thought it was important to put business on notice to provide clarity and transparency. That if there is a deal, that we increase concerns, but we need to act within 30 days. We're putting them on notice about that. Again, to ensure that the market has clarity on it.
Commissioner Phillips publicly tested in the first 6 months of this practice over 50 letters in and raised the question of whether any of those investigations actually remained open and whether this approach is simply a tactic to scare business I'm worried that whether it's a tactic or not, that's the effect that it's having. It's having a chilling effect. And then when you issue one of these letters and you never tell them whether the case closed or not, kind of without doing anything, you've stopped transactions that would be helpful to Americans. I want to now yield back the remainder of my time to Chairman Jordan.
Appreciate the gentleman. When FTC attorney deposing Mr. asked him for a quote, no one from the FTC directed to read the conclusion out to a program. He claimed to the contrary. There were suggestions of what they would expect the outcome to be. He testified that FTC communicated with Ernst & Young. Again, Ernst & Young is the independent assessor, the fact finder that the FTC selected and made Twitter for, that he communicated to Ernst & Young that, quote, Ernst & Young, under all circumstances, will be conducting an issue on behalf of the FTC order, and was very adamant about this is absolutely what you will do, and this is going to occur, and you will produce a report at the end of the day. The FTC was adamant. Ernst & Young leaders fear that the FTC would take exception if they chose to withdraw from the case. So on the one hand, you're harassing Twitter, and then you're saying the guy who selected, the entity selected Ernst & Young, the accountant we've selected to be the fact finder, you better find what we want, and if you try to get out of it, we're going to retaliate against you. That's, when we talk about the weapons government, this from the same agency that tells criminals to, that's what we're concerned about, Ms. Khan. That's what has to change. You can comment if you want. I'm reading the motion today in court. And it's amazing, too, even this person in, your lawyers deposed him. He's the guy that you've set up as a fact finder, and you know who it was. Did you sign off on any of those 12 letters sent to Twitter in that 10-week time frame?
Congressman, we're fortunate to have a lot of work underway. A lot of this work is delegated to the line staff that are able to move quickly and make sure.
Yeah, but you're in front of Congress today, and you're going to get questions that say you don't know this. I find amazing.
It sounds like it was a late-breaking development. By the morning, something on my radar. I'd be reluctant to get in and setting up looking yet. Take questions for the record and age later.
Put on your radar that you told, based on testimony, that he felt would be retaliation if someone could get out of the agreement. Wow.
I yield back.
Now recognize the gentlelady from Pennsylvania. 5 minutes.
Thank you. And for my 5 minutes, I ask unanimous consent to enter into what Mr. Hughes had hoped to enter ethic official owned stock while recommending FTC recuse herself from Medicaid. Thank you, Mr. Chairman. Thank you, Chair Khan, for being here, speaking with us today about the important work that FTC does to safeguard consumers, crack down companies that would exploit them. I come from perspective as a mother, as a grandmother. I care about exploitation of seniors, of children, of businesses, consumers generally. In written testimony, you explained that FTC work to protect the security, fight fraud, include fraud like opioid recovery, and for domestic manufacturers, small businesses have a chance to compete fairly. Somehow, Republicans are using this time in other ways. I apologize, I'm late to the hearing today, but I'm pretty sure I missed some of what happened. I had another hearing with Secretary Kerry on climate crisis. Give me for coming late. I want to ask you about the issue around opioid addiction and abuse and what FTC is doing. I know the FTC recently returned $60 million to people suffering from opioid addiction. I know you know as well that the health crisis in the country around flood opioids and opioid addiction is grave. 110,000 people last year of overdose. That's 300 people a day. Can you tell us about your work to try to protect consumers? Maybe this case, the similar case with Rectic. I don't know how to say that. Can you tell us about your work in that area?
Yeah, happy to. And we're, this is a newer authority that Congress gave us, and I've been pleased that we've been able to quickly put it into action. We brought it of lawsuits using this authority to make sure that if companies are deceiving potential patients of opioids recovery facilities, that we are acting quickly to prevent that. I licensed a firm called R360 because we found that they were engaging in some of these deceptive practices in ways that were harming opioid recovery patients. Recently brought another action that also noted that deception around tobacco addiction recovery is also illegal under the statutory authority. So we're working hard to make sure if people are being deceived under legal authority, we're acting, we're getting money back.
Thank you for that work. I hope you will continue in a robust way. For full disclosure, I was on long-term recovery, 10 years of recovery from opioid addiction. We've lost too many others to this problem, and the deceptive practices are so egregious that it's very upsetting. I want to move to, if I have some time, I do good. Pharmacy benefit managers. They operate behind the scenes. Consumers don't really know what they're all about. They're a middleman in the drug market and determine patients' access to medication as well as prices consumers pay. In this role, BMS have power to raise prices that are part of these consumers pay 12% more than they should for generic drugs. Can you speak to what FTC is doing around the issue of PBMs, disclosure to consumers, and cracking down on the price hike?
Absolutely right. Those firms are often behind the scenes, so people aren't interacting with them. But often their decisions are determining what medicines make it on what's known as formulary. And unfortunately, we've heard reports that suggest that rebates between drug manufacturers and the PBMs may be keeping low cost generics off the horse. What that means in practice is there's a lower cost generic out there, but when a patient go into pharmacy, they're not actually able to get it. They're having to pay more for the branded drug. And so, we've done a policy statement. We are very concerned about that and are looking at it.
Yes, and how can we, that? Can FTC have some rulemaking, some effectiveness in interrupting that blockage of information to the consumer?
So looking closely at there may be violations of the FTC Act, also prohibits certain types of acts. We do see a Robson Act, so we're really laying out all of our priorities and making sure we're using them to FTC because oftentimes we hear from patients about how they haven't been able to afford life-saving medicine potentially because of the tactics. So we recognize the urgency of this work.
Again, on behalf of consumers and seniors and kids out there, thank you for your work and the work of your entire team. I yield back.
Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. Thank you for being here today. I will say I wrote down something you said. I think I got exactly right down. Not only was it, I think, substantive, meritorious, but also people's privacy is paramount, quote. If only the FBI leadership believed and acted that same way, I'd be happy. I want to ask you first about the EU's Digital Markets Act. You previously commented and opined in response to Mr. Klein's questioning. He asked you how much, I think you said you don't know. I wonder how many employees or personnel are working on the EU Digital Markets Act.
Is we currently have one employee that's details to Brussels. These are routine. They've gone on for many years. They help improve coordination among agencies for us to better understand.
Is that employee working to help implement the EU Digital Marketing Act, or are they just observing? What's their role there?
It was a general matter when we detail. They're focused on antitrust enforcement, enforcement of the competition laws.
This is in Europe, though. This is the implementation of a new law.
So
how does that impact antitrust law in the States of America?
So these laws, as you noted, govern Europe. If the European Commission is working on implementing them, that's work that they're doing. It's focused on enforcing the U.S. laws. These types of details across agencies.
That begs the question, and I'm looking for. I'll move on because the 5-minute form is basically absurd. We can't answer a question. So I'm hoping maybe you or your team will respond more fulsomely as to why we have someone there even observing the implementation of an EU law that is not here, unless you're intending to support something like that here. Are you familiar with someone named Rebecca Slaughter? Are you familiar with someone? So I have a quote from her. Interesting. Glad you're here. She called for an equity, inclusion, and anti-racist agenda in antitrust enforcement, yet antitrust enforcement typically is focused on the consumer standard, right? So do you agree with Ms. Slaughter, Commissioner Slaughter's call for equity, inclusion, and anti-racist approach to antitrust enforcement?
So let me say, first of all, it's just a huge relationship on the commission alongside Commissioner Slaughter. She thought so hard about how do we make sure we're using all of our...
We only have 5 minutes. Send me a letter. I'm glad you are. Please respond to my questions.
An enormous amount of to speak for. The way
I'm not asking you to speak, I'm asking whether you agree that that is the appropriate approach and when it's a de facto from the consumer welfare standard.
So we enforce laws that Congress charged us with. That includes prohibitions on unfair methods of competition.
So it's not to interrupt, but to interrupt. You're not answering my question. My question is real specific. Do you support and agree with this new approach, which would because it departs from the consumer welfare standard? Do you agree, Ms. Slaughter, call for equity, inclusion, and anti-racist as a basis to examine antitrust violations?
So again, we examine antitrust violations under laws Congress wrote.
Can you name a law do the antitrust that obviates the consumer welfare standard and with equity, inclusion, and anti-racist standard? A statute.
The
Federal statute.
Statutes are worded broadly. We look at them as well as any law.
Can give me one that would facilitate obviating the consumer welfare standard and replacing with the equity, inclusion, and anti-racist standard.
So, Congress, right, there aren't cases on these specific questions. I will say when Congress was passing the anti-monopoly laws, they were doing so because they were worried that concentrations of economic power hurt everybody.
That's right. That's right. That's from that point of view is from the consumer welfare standard developed and evolved. Now, if you were to take the equity, inclusion, anti-racist agenda and use that as your new standard, you would have moved away from statutory and case and probably imposed it. That's the point I'm trying to make, and that's the point you're not responding to. I would ask that maybe you or Ms. Slaughter even, I don't, whatever, would respond in the future chance to get to the bottom of that. Appreciate you being here. Thank you. I yield.
Gentleman yield back. Gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I do want to start by commending Congressman Buck and Gates for their comments earlier today. I was pleasantly surprised to hear the affirmative comments they made with respect to the FTC, but also legislation working with Ms. Jayapal that I think is important and critical legislation that could be useful. I kind of know that we have hearings legislation like that. I've had a lot of hearings for weaponization issues, a lot of hearings trying to tie administration in various ways. We haven't had any hearings on affirmative legislation that would have an impact on people in these markets. And I'm on the Antitrust subcommittee, and I think we had 2 hearings there. One, Mr. Massey put together that dealt with agriculture issues. I think it was meatpacking in small entities, but it wasn't as explicitly an antitrust hearing. It so happened that witnesses at the table noted that the big 4 companies that are dominating that industry are the ones that are questioning small arms and not business and increasing prices. But I requested some sort of approach that would try to address that concern, but nothing come back yet. And I would note this too. We've got matters pending, in the United States here before your commission or Department of Justice. Some of it mentioned today already. The PBM, Big Mass, JetBlue, over Albert's merger, the like Microsoft matter yesterday. The committee on antitrust had no hearings on any of those issues whatsoever. So this is an oversight hearing with respect to the FTC. But it might make sense we take a moment and have a little oversight for ourselves on what's going on here on the subcommittee. A minute ago, it was raised about a subpoena that the FTC issued, and I guess comments that it was overbroad. But I did want to raise this as well. The Judiciary Committee on May 25th sent a document to the Department of Justice that demanded, and I'm quoting, all documents and communications between or among the Department of Justice and the Internal Revenue Service referring or relating to any investigations involving both the Department of Justice and Internal Revenue Service from May 1, 2023 to the present. Now, we'll set aside for a moment that include grand jury potentially, which of course they can't turn over on a letter like this, even for Congress. If we're going to throw rocks, let's make sure we're not in a glass house, because that is beyond overbroad. And I think this isn't, I just picked one out of it. There's a lot of requests that this committee has sent out to the administration and in some instances to private companies, depending on whether you're on the good side of the Republicans or not. And I think we'd be very careful in making sure we're using the power of the committee and House of Representatives in an appropriate way, just like they're asking the FTC to do. And then I did want to close with this point. That's with respect to the recusal issue. That's been discussed quite a bit. And I think it's been addressed, and Judge Bozeman's opinion, I thought, made it crystal clear why you didn't need to recuse yourself. And in fact, he said, in judging the motions that had been filed to him, that it wasn't necessary or even appropriate. But at the same time, this committee, again, is ignoring one of the most obvious issues with respect to recusal and ethics, and that's with respect to the Supreme Court. We had 35 members send a letter to the Speaker and to the Chair. We heard him, Justice Thomas, and he's getting buying property from his mother and taking yacht trips, and a lot of justices had similar sorts of issues. We sent to both Speaker and the committee chair have hearings that we take a look at a code of conduct for justices. They should consider whether there should be rules in place with respect to recusal for members of Congress. To that, my knowledge, there's been no response to this letter. But more importantly, no steps that have been taken to try and address the issues that have been made very obvious by the conduct of Justice Thomas and Justice Alito. And that's just the beginning. So I would move for unanimous consent to have an op from Ed Wegman as Justice Alito himself, and then Daniel Buguzlaw, I think, Samuel Alito's white lease land to oil and gas from Justice, while the Justice fought the EPA, and the letter from April 17th to Honorable Counsel Jim Jordan from 35 of the House. I would ask that all of these be made part of the record.
Ms. Khan, there's a journal called by Christine Wilson. She's on the FTC because of a range of concerns over how to charge you. But what caught my attention was the censoring % in the Meta acquisition case. Severe agreements around here are far for the courts. We go great length every day on this committee to demonstrate that. But we saw outwardnesses by freely exchanging of views meant that this process will separate truth from lies, wisdom from folly. A free society because of people knowing the different for themselves. Censorship is utterly destructive of this audit. Can you explain what controls to criticizing your conduct was entered?
So, Congressman, I couldn't agree more that type of debate and discussion is critical. Designed the FTC as a member commission, and we really enjoy internally those discussions and debates.
Well, obviously not, because her comments were in her dissent censored. So why was that? How do you explain that?
So the way the commission procedures work is that I was walled off from those decisions. As the majority of the commission explained, they were identifying non-public information relating to staff analysis and protected by deliberate process that have long-standing FTC policy adopted during the administration that says we don't disclose that to analysis because we don't want to show.
So this was critical. Did you have any sessions with your colleagues over this?
No, again, I was totally walled off from the proceeding.
So what do you see as the role of government turning is misinformation, or for that matter, hate speech?
FTC focused on deceptive advertising, so I guess, if a company says it's made in America, but it's actually made in China, that, from our perspective, is fraud and deceptive.
Well, you were discussing Twitter just about an hour ago. You see the government having any role in determining misinformation, or what is hate speech?
We're not involved in that. Again, we're focused on deceptive advertising, like made in USA, and that's really what we're focused on.
What's your view of capitalism?
Excuse me?
What's your view of capitalism?
The FTC's job is to promote competition.
What's your view of capitalism?
Could you explain what you mean by that term?
Good system with its strengths and weaknesses.
So I think open, competitive, robust, resilient markets are critical to America's economic success. The FTC has an honor playing a really big role in ensuring our competitive and position America to compete globally.
Of course, the beauty of a capitalist system is that the consumers every day vote with every dollar they spend on what the economy produces and what prices are willing to pay. Do you see a role in interposing its judgment for theirs?
The role of the FTC is really one of a referee. We believe in open competitive markets, but in order for the markets to deliver good, we need to make sure companies are playing by the rules of fair competition. That's the job that comes to the FTC, and that will do.
I think you go much farther than that. I certainly hope you take part in the economic decisions that you've heard today. Mergers, for example, generally occur when companies determine that it's going to improve their efficiency and productivity and enhance the ability to serve their consumers. And that grows the economy and it helps consumers. And I'd urge you to be very careful, and your colleagues, very careful and very humble with your powers. Because when decisions harm the economy, you're also harming your administration. And the average consumer might not follow the daily decisions of your commission, but they know how they're doing in their own lives. And I'll yield to the Chairman.
I'll wait. I'm Jim Yielding.
Then we'll go back.
Thank you. Back to Jim from North Carolina. North Carolina is recognized. Thank you.
Thank you very much, Mr. Chairman, and thank you, Chair Khan, for joining us today. And also thank you for mentioning your work on PM reform in your opening statement. This is a very important issue for our healthcare industry, and as you pointed out, the health of our constituents. This Congress has been working with a bipartisan coalition of lawmakers to address abusive and exclusionary practices by pharmacy benefit managers, or PBMs. Access to affordable prescription drugs is a critical issue for all Americans, and I'm hopeful that the FTC will take substantive steps to address ways in which PBMs take advantage of patients and providers in their pricing strategies. I know that you got a general question from Congresswoman Dean a little bit earlier, but to be much more specific, the FTC has been working on a 6-week study since June of 2022. When do you anticipate completing that study, and do you have any interim conclusions or findings that you can share with us today?
As noted, we recognize very deeply the urgency of this work because it potentially means that patients not get access to affordable, and that, as we all know, can have death consequences. So we're moving with great haste on the companies to process information in a timely way. We're trying to drive that forward as much as we can in general. Strictly, some of these studies at the agency have taken 4 years, 5 years. My goal is for us to be able to move. I should also note that if, as a matter of course, this inquiry we instead identified practices that we turn on lawful, nothing would stop us from being able to focus on those law regulations and proceed the enforcement track.
Correct. And also, the FTC recently expanded the scope of the PBM investigation to group purchasing organizations, GPOs, that have opened in recent years. How does the FTC believe that PBMs will be using these GPOs, and what kind of harm could they have in the market for drugs?
So GPOs are entities that are not clearly central, below market. We've out the general request because we want to ensure we're getting a full 360 view of what's happening with these practices. I'd also note we have stories about major shortage of critical drugs. We've also received letters input suggesting the role of the GPOs may be contributing to some of those shortages of essential medicines. That's the thing that's not addressable.
Great. And given 3 large PBMs are currently control 80% of market, I'm interested in how consolidation in the PBM industry affect patient access. In addition to PBM consolidation, largest drug plan sponsors also own their own PBMs. So we're seeing a great deal of vertical integration. PBMs set out to cost based on full undiscounted list price drugs, so patients don't see the PBM discount at the pharmacy counter. And we know that some health plan-owned PBMs require patients to fill prescriptions only at certain pharmacies or providers, which reduces access. How are you seeing this consolidation and vertical integration impacting patients?
Yeah, that's a great point, and this is one of the issues which routinely hearing from people. We've been to kind of collect input around people seeing about being practices. We receive thousands of patients, thousands of public comments. Many of them patients who are concerned that some of these decisions about which medicines the PBMs are putting on the formulary or putting on is not being driven by what's best for the patient, but is instead potentially being driven by which is the PBM the highest rate. So I think that could be an instance where there's a conflict of interest between what's in the PM's own interest and what's for patients. So that's something that we've heard a lot about.
Final quick question. Do you see a role for Congress in this area as well, not what your agency does?
Absolutely. This is such a problem relating to unaffordable drug prices for Americans. I get an all-hands-up moment.
Thank you, Mr. Chairman. I yield back.
Yield back, gentleman from Texas, recognized.
I thank the Chair, Ms. Khan. Thanks for telling me. Would you commit to me to provide updates necessary with respect to the Live Tour merger, and you're also looking into what occurring with that?
So Carmen, at least our partners at the Justice Department are looking at that.
The FTC is also have some look into what's going on with the accounts I see, but I just appreciate any updates from your office about that and the concerns. But I'm Chair.
Thank you for yielding. And I believe, Jennifer, you said people privacy paramount. I agree more. And we talked earlier. I do think there's part of the support to deal with that. This sweeping up of data that happens there yet is FBI purchasing that data. So that is a paramount. I would say the First Amendment is paramount important too. Would you agree?
Absolutely.
And
then the gentleman from Freeman, I asked you, what's this information? You don't really have an opinion on that? Was that fair assessment of your answer?
It's part job at the FTC. We're focused on deception and fraud and something.
Well, you wrote a couple years ago in a law review article, digital business such as Twitter, their users by facilitating spread of information. What were you talking about there then? What's disinformation?
Happy to take a closer look at the material, but as part of the FTC, we've seen how fraud and scams can sometimes proliferate these social media sites. We've launched an inquiry to try to understand why some of these crypto scams delivering on these sites. What can we be doing?
These are the first sentences in the introduction of the piece you wrote. Such as Twitter, users by still spread disinformation. Who decides disinformation?
From the FTC perspective, it's deception and fraud.
That's fine. You can keep using them, but I don't know who decides that deception, who decides that it's fraud, who decides that it's disinformation. In this case, talking about social media companies that posted on the platform. Who decides what's information? What is it?
So again, the FTC focused on fraud and deception. There's a standard of what constitutes fraud. This is about.
But you didn't ever deception. Disinformation. My concern is again, at the top of it, but the staying tack on Twitter when the ownership had changed and the platform was to not taking down speech, not taking down posts, allowing the share of information, and censoring it. It was just a major decision last week from Louisiana, where they said, in fact, pressuring big tech companies to censor, and big tech companies will know it. Now you're going to the one company that changed how they're doing things. That's what concerns me, particularly in light of the fact you just a few years ago saying this is what goes on.
I'm glad to have the opportunity to clarify issues here. So we at the FTC have no view on who should not own a company. All we care about is that the company is following the law. That's really what our focus is.
We've covered ground. I want to know about disinformation and who decides what disinformation. The government should decide that?
Congressman, it is concentrations of economic power, particularly speech platforms and communications platform. That's that concentrated power, the ability to pick who gets heard, doesn't get heard, make these types of decisions. That, I think, is concerning all of us, and the FTC's job to be promoted.
What kind of speech was getting censored? You know what the last week? Have you read the opinion?
I have not.
You know what kind of speech was getting censored? You know what the court? Conservative speech. Conservative speech was it's virtually all conservative. This is not Jim. It's not Republicans on the judiciary committee. The federal judge had facts, these pages of facts, laid out the facts in the law in his opinion, that it was conservative being censored and labeled disinformation.
I fully understand why industry concentrates power over some of these platforms, why people would be afraid and worried of censorship. I couldn't agree more that when you have a handful of people making decisions about what gets seen, what doesn't get seen, who gets heard.
And you have to decide disinformation. It's not.
Congressman, the FTC are job competition. More competition means more people making these decisions and can alleviate some of the censorship your share.
Gentlemen, that's fired. You're not recognized the. It's Georgia? Okay, I didn't know who came first. Gentleman from Georgia, for 5 minutes.
Thank you, Mr. Chairman. Good afternoon, Chair Khan. It's a pleasure to have you before today. I have reached testimony. Thank you for your time and your testimony. Ensuring that emerging American businesses have an opportunity to grow and thrive is essential for our economy. And the most of American practices. So America is a country that's built on the success of creative and innovative ideas. The connection of its people is so vital. And the endless opportunities of its society. And for these reasons, we must do all that we can in our power to support competition, investment, and buy monopolies which crush American opportunities. A robust antitrust framework supports small businesses by helping to ensure that they are not intimidated into conciliation and for the American people by allowing freedom of choice in the marketplace. A robust antitrust framework strengthens American workers against monopolistic efforts to lower wages and limit benefits. That is why it's so wonderful to have you here today. Thank you so much for being here at the helm of the FTC. You actually been a champion of America's antitrust and competition for years, and America's economy is stronger forward. And in fact, the U.S. has the highest post-pandemic growth of any nation in the G7 and lowest inflation with a historical unemployment rate of 3.7%, and that must be the today. As I spoke on earlier, enforcement of antitrust laws helps to promote fair competition across the United States economy while protecting consumers and workers from deceptive and unfair practices. Balancing competition and effective antitrust enforcement are critical to protecting consumer, worker innovation, and economic equity in this country. Over the past 20 years, U.S. consolidation across all markets, whether it be nursing home industry or agriculture industry. Can you please comment on how this is applied in context of large mergers that affect smaller competitors in the marketplace?
So, Congressman, we see mergers between two large firms, especially if they're competing in the market, make it more difficult for newer entrants to come into the market. We've seen entry barriers can be raised. Independent firms, small businesses have difficult time competing on a level playing field if the merger is to market that allows firms to get specialized firms or discriminatory benefits that are not available to us.
So these past 2 terms, Congress has actually been examining the role of big tech companies and their excessive market dominance, which has allowed them to profit and to leverage their gatekeeper power for new companies. And continue to talk about steps that you are taking to ensure smaller companies, especially in the tech marketplace, get a fair chance to compete against bigger or entrenched companies.
So the FTC has looked closely at digital market since before I commissioned. One of the first actions that we took when I joined was refiling the FTC's complaint against Facebook, where the FTC alleged that Facebook's positions of Instagram and WhatsApp were anti-competitive and really helped Facebook maintain its dominance in a way that locked out rivals and really hurt consumers at the end of the day. We're looking closely at mergers and acquisitions to make sure that if we rate these acquisitions are similar, going to create dominance and allow firms to maintain their monopoly, that we're acting swift there.
So under your tenure, FTC has endeavored to restore meaningful antitrust law enforcement over the years. In the process, FTC has made some powerful enemies. Have you not? Yes, you hear from others. So isn't the lesson learned here that antitrust agencies should trust vigorous competition and antitrust enforcement to deliver innovation and better services rather than enabling entrenched gatekeepers to continue growing through acquisition markets?
Absolutely. I think America's history shows that promote fair and open competition. That's the best presentation and allow us to succeed.
Thank you, amount of time.
Thank you. Right, gentleman from Wisconsin for 5 minutes.
Thank you very much. I'm going to take 5 minutes to say a real brief thing here. We heard some name problems yesterday. I don't have a question for Liz. We heard some of the same stuff in the FBI yesterday that we respect constitutional laws, and but nonetheless, they are censoring the American people. And it was so interesting to hear yesterday, and the director of the FBI was here, and he said, well, these companies work within the free market. We can't show they about operating. But when you have a FTC, whether it's the FBI or the FTC, comes calling at your front door, and they say, gosh, maybe you should be doing things a little bit differently, they pay attention. And I would use the example of the man who originated Facebook. He said in a podcast last year that to the FBI, when they come calling, you're going to pay attention. And censorship happens from it. And I hope you are cognizant of that as you go about doing your business. Second thing that I would say is that we talked about entrenched gatekeepers and stuff like that. The barriers to entry that have been built here in Washington, D.C. for the last few decades are significant. And I go back to material for over a decade old now. One being Obamacare, the other one being Dodd-Frank. We see probably the entrepreneurship that had happened in the healthcare and finance banking industry. We've seen decades because barriers to entry are so high. And I hope that you will respect that. While building these regulations out here, while passing laws as happened over a decade ago in regard to Obamacare and Dodd-Frank, it is harm the rest of America. It's harm entrepreneurs. It's harm Main Street America. We no longer have a bank. Their bank being consolidated into something bigger. So you may say that, boy, we're going to go after these big companies. Well, hell, we created them here. And I hope you won't participate in creating additional barriers to entry so that entrepreneurs cannot participate in the free market society that was built in the United States of America over the last nearly 250 years back.
Thank you. A couple questions I had. I just want to use a little bit of time there. Jim from Georgia mentioned that he thought you were being treated unfairly, remember, at the beginning of an hour and a half ago, and differently with the FTC. Is that true?
Question I'm focused on really.
I know you, but
the questions you all are asking.
Oh, but I'm curious. Do you believe that's true? If you watched the hearing, I was offended. To be honest with you, if you watched the hearing yesterday, we gave a gentleman a pretty thorough raking over, asking some difficult questions, and I hope that you know it has nothing to do with FTC. I hope you feel that. I was wondering if you do. Yes or no?
Point of order.
Yes.
Oh, Mr. Chair, just wonder who time we're using right now.
He yielded his time to me.
Okay.
And he had time left over.
Oh, thank you.
Mr. Tiffany, yes, go ahead. Just give me a if you're truthful.
It sounds like there's a robust debate among committee about these issues, and I defer you all.
One of the things we have to change is that when West said that it's so hard when people come before us. I just say one other thing before we move on. Robocalls. I know you heard about them today. It's a really big deal. You want to talk about a way that you're affecting people's lives. They are sophisticated. They're scary. People are getting in trouble out of them, and everything from Social Security to buying timeshares. It's a real big problem. I would love to, and speak Korea, I would love to work with him. I'll love to work with whoever to do something about that issue. I have other questions for you later, but at this point, I'll recognize the young lady from Missouri.
Thank you. St. Louis and I are here today in strong support of the rights of workers, of consumers, small business, and the broad public to be free or greed that monopolizes our access to information and treats employees and communities as expendable. Thank you for being here, Chair Khan. I appreciate your service as a staff on this committee, your groundbreaking scholarship, trust law, and anti-monopoly issues, and your record of accomplishments as FT Chair. This has a role to play in protecting our economy from the harms caused by greed, reckless corporation, profit, and power over people. Look, big tech, big pharma, big oil, and any concentrated industry. These companies and profit-obsessed executives behind them have used their power for too long, and it's time that they hold accountable. So we absolutely need the plenty of workers and consumers. The FTC can and try to help under your leadership, and I appreciate that because it makes a difference in communities like mine. For example, in recent years, FTC lawsuits have resulted in more than $33 million provided to more than 178,000 Missourians. In 2020 alone, the FTC provided $0.6 million in Missouri, including St. Louis. That's real money for real people harmed by corporate greed. It's on the table, it's a roof overhead, it's clothing for a child. Another example is for proposed rule to ban non-compete agreements. Chair Khan, as was brought up earlier, banning non-compete agreements is estimated to raise wages by over $200 billion each year and to close and wage gaps by 9%. Is that correct?
Congressman Scott was making those are some of the estimated facts, yes.
Thank you. Of money in pockets of workers and black and brown people in particular. Can you explain specifically how banning non-compete agreements means workers will get paid more?
So our staff does look very closely at the empirical evidence that has now surfaced in light of different policies. We see that states have limited non-competes are able to ensure that workers are moving around more freely. Though unfortunately, we still see that all too often companies are still trying to include non-compete. We also seen is that being able to switch jobs, being able to move freely between jobs and have better job opportunities is a key mechanism that workers have to use to be able to get higher wages and employment opportunities. When you freeze workers in place, when you want them in place to do non-competes, that means that they're not able to go across the street, even though the firm across the street is in the better wages or better working conditions. That's bad word.
Absolutely. Thank you. And that's a real impact with survivors. But Republicans don't like this. The party that is in the pocket of supremacists and wealth corporations will talk a big game about fighting for everyday people and then show up to Congress and do whatever their corporate donors want them to do. That's what this is about. So let me be clear. There is nothing unethical about standing up for consumers and small businesses. There is nothing unethical about enforcing the law. Powerful and destructive companies like Meta and Twitter. They're unethical about putting your principles into practice. But what's unethical is being apologists for the corporate greed that is fleecing our communities. What's unethical is coming to care workers and then selling them out. That's the real ethics scandal here, and we need not forget it. The bottom line is that the corporate monopolies are for social destruction. Any lawmakers who claim to stand workers and consumers must advocate against dominance by large companies that care more about profit than people. We need to aggressively enforce our antitrust laws for the purposes Congress intended, and we also need beyond the digital economy dominated by billionaire for-profit companies. Chair Khan, you have never tried to hire or believe, and I thank you for that. I thank you for your leadership. I look forward to working with you and your agency on these critical issues. Thank you, and I yield back.
Thank you. Recognize the gentleman from North Carolina, Mr. Bishop.
Thank you, Mr. Chairman. Doesn't sound, yes. Something out to me just this morning, the FTC, well, it was disclosed, the FTC said a civil investigative ban to OpenAI. Are you familiar with that?
Congressman, involves non-public information, but if publicly reported, may be accurate, but I haven't shared anything non-public in this.
It's on Twitter, and among, it seems to be acting among other things for whether Chat GPT or whatever the process have will generate statements about persons. Can you explain the gist of that, or what is the regular authority of the FTC that civil investigation is being issued under?
So as general matter, some of the concern we're seeing in the AI space is that ChatGPT and some of the other services are being fed a huge trove of data. There are no checks on what type of data is being inserted into these companies, and we've heard about reports where people's sensitive information is showing up in response to an inquiry from CEOs. We heard about, lumbled entry statements, untrue things are emerging. That's the type of fraud and deception that is concerned.
So as general, you said something, you spoke to libel and slander or defamation issues, and I come to that because that's an issue of state law, I understand it. But is the regulatory reach there defined by, the FTC? Is that something you guys explain that stuff with something like OpenAI?
So that's what we don't address this thing.
About Twitter, the about releasing private information, was that so subject to regulatory reach under the FTC because it was somehow deceptive? Or there's other statutory sources that generally in charge of sensitive information about people?
Yes, FTC but unfair deceptive practices in terms of competition. That's primarily we use in these instances.
Okay, and that that's interesting. And just for the people in the public, the operative language 5 that you guys I think are using in the context of a non-compete rule that you've come out with, and it just says unfair methods of competition in affecting commerce and unfair or deceptive acts practices affecting commerce are here declared unlawful, right? That's the language?
That's right.
Okay. And so it's not really very detailed. Let me ask you for a minute about non-compete rules. So you guys have this proposed rule you're seeking comments on in the process, then once those comments are reviewed, you guys will decide, the FTC will decide to proceed with the final rules. Is that the way it works, basically?
Correct.
And so I litigated these contracts in state law for years. And I know California has a rule that absolutely bans them. There are different renditions of law, some statutory, some made by the courts every time in states over the country, and have been for a long time. So your rule would displace all that state contract law in one fell swoop if it were made final, wouldn't it?
It would create a new provision, yes.
It would create what?
Yes, it would be creating a new provision to determine that these are
So you not only, and we say, I've stated here, it was proposed last set would be, you saw this inherently coercive or unequal, but rule would be per se, except for a very narrow category. A majority would be per se the people involved in this contract, right?
That's we did ask as part of our notice of rulemaking some questions about whether that's
I don't get into marriage long 3 seconds. Let me just ask you this, because if you take that example, many other people got concerned about concentration of economic power like that. Isn't there a best to be concerned about concentration of legal power, lawmaking power? So you 30,000 judges have made rules, 558 state legislators, you got lots of members, you can multiple chambers. If you, as the bare majority of the FTC, could make such a rule, isn't that something that Congress should be concerned about, how much power you yield?
So we make these determinations to authority that Congress has given us. When we promulgate rules pursuant to the Administrative Procedure Act, there are a whole set of procedural protections that go into play, leading to the periods that we have to use to get public input. There's standard review for judicial review. There are so many checks as part of the process, and it's really quite regular for administrative agency engaging in.
But you get to say what's unfair, right?
So interestingly, Congress, when passing the FTC Act, was doing a debate. They said, should we act to list out in this act all the practices that should be fair? And Congress determined, well, businesses are so innovative, find ways to end or run any practices. Let's allow the FTC to use their expertise to make sure that as markets evolving, business are evolving, they can ensure their statutory authority to be pace. So this was a determination and decision that Congress made that we followed the law.
Wish I had more to you.
Recognize the gentleman from Vermont.
Thank you, Mr. Chair. Before I begin my line of question, make note of some our colleagues have touched a few times today on words of a third-party auditor who was deposed as part of the Twitter lawsuit. I think it's really important to point out, for the sake of transparency, this deposition was held last night, and here we are talking about it today. Really coincidence, I really do, but that's pretty lucky coincidence that that evidence supposedly providing Republican accusation was released in such a timely manner. So I think it's really important to make note of that. Chair Khan, thank you so much for being here. Thank you for being here. I really appreciate your testimony. I touched on a extremely timely and controversial issue, which is artificial intelligence. And specifically, I'd like your thoughts on generative AI and competition. It's tough to imagine online platforms gaining even more power, but it seems that big tech firms who control their own AI systems and access to cloud data are in position to do just that. And I find that alarming, as do my constituents back in Vermont. So what I ask you is, how could AI technology lead to even more consolidated landscape, even fewer choices for consumers?
So, Congressman, let me say, first of all, these moments of technological disruption, we have these game-changing technologies enter the market, sometimes provide a lot of opportunity for disruption and displacing some of the existing incumbents in giants. So there's always a chance that that'll be the effect. Right, these technologies, we see inputs acquired that really favor dominance and favor scale. So, you need huge compute, you need access to huge amounts of data, models. Our staff recently published, obviously, some of these competition. But I think you're absolutely right. We all need to be very vigilant to make sure that this potentially transformative technology is further consolidating market power in ways that could really harm competition.
And how would a firm use AI to illegally in their power?
So, I want to get hypothetical. This traditional type of concern that you might have is if firms with market power conditioning access to one set of Gs and critical on firms having also buy other services, those with time agreements, and especially when having an exclusionary effect, keeps our laws.
And are you concerned about this issue in relation to digital markets?
In general, we're bigger about competition.
Okay, my last time here, I also want to touch on another issue, which is dark patterns. Amazon has reached a point where it's particularly possible to avoid. FTC recently to Amazon to task for using a series of digital tricks or dark patterns to control people in crime without their intent, or to prevent people from canceling their subscription. And this is something I hear a lot from my constituents about. Last year, the agency reported that, quote, more companies are using digital dark patterns to trick people into buying products and give away their personal information. How common is it for online companies to use these dark patterns?
Unfortunately, through our work, we've seen that it is too common that we see companies using these tricks. Our staff published a report going into detail about different types of dark patterns we see, which in practice end up tricking or manipulating people into making choices that they're not risky to make. And so we want to make sure that we're really grasping how these dark patterns are working. We've been bringing forward a whole set of technologists that are able to kind of dig deep, look under the hood, figure out what's really going on. So it can be an area of focus for us.
And something that really struck me, it's essentially about taking away people's choice. When you're not transparent about the ways in which consumers are being entrapped into signing up or not being able to cancel them, that's taking away their ability to vote with their dollars, essentially, which is something we've heard about in this hearing today. What effect does this then have on competition and privacy innovation? Just briefly.
So we make sure that companies are coming on deep. We don't want businesses to lose out to firms that are engaged in dark patterns and these types of practices. So there's a consumer protection dimension, but there's also a competition dimension.
I really appreciate the yield back.
I recognize gentleman Mark.
Thank you, Chair, and thank you for being today and for your patience. Just for the base, I'll use that the entire conference has been extraordinarily interesting, and I appreciate your class. Do you agree with the number of the agency expertise and some of the direction to goals embodied in the strategic plan? And just to the phrase unwarranted health, safety, and privacy. I'm actually looking at the plan right now. For example, unwarranted health, safety, privacy risks. Tell me how that goes behind the folks of the FTC. Because that would be an expansion of what you see used to respond. That's not what I just said.
I think you said unwarranted health, is that right?
Actually, we see focuses on investigating and litigating conduct of injury, including only monetary injury, also, for example, warranted health, safety, and privacy risks.
So the statute says that unfair practice one that causes the substantial injury. Substantial injury not defined, but for years now, the FTC has asserted that in court to be not just monetary harm, not just lose money, but a certain type of harm. But wellness is out safety, system that's advertised.
You said, right, just because I'm on, you provide me the cases that you're referring to, so that I can see that you're that. We said that's not linked to. This is one court that brought in your paper. The Antitrust paradox issue is, and my question is, what if not the consumer standard applied standard? And basically, looking at this out of book about 25 hours or get back. I need it. And the question to you, not that standard, what are you going to apply? Or do you still apply just that sole standard in determining the challenges that business
So So we apply the text of the statute that Congress passed and look closely at the language in the statute that Congress passed, consistent with legal precedent. There are some cases.
If I may, if correctly works, there was a rush of legal precedent select among almost any standard. That was the reason so clear in seeing what would be the proper standard and the best for the consumer. I'm asking you, if you're going to move away from that, would you articulate in the book? What is it?
We're focused on the law, including the
Wait. You just point out before there was a number of standards. When you say you're looking at the law, which law?
Insurance Act, the Clean Act, the
Those are
Act.
they were written very broad and give you the power to trade controls this economy that we've got. Work on to define some sort of trade, some sort of standard to measure your actions. And inside is where I think we're ready with this way, but my question is, what new standard? Please don't take into the law. Don't do that. What do you have this and what works together?
In instances where the Supreme Court said, for example, the Sherman Act be interpreted consistent with consumer versus low stat, but Sherman Act not used for the FTC, which prohibiting unfair competition, and I think incredibly important for us under Congress's intent.
Wait. Stop. A lot of generalizations. What's the standard you are suggesting to take place? Well, what's your standard? Please don't give me on the
So it depends on the statute. We're enforcing each statutory. When we're enforcing the FTC Act, with the Act, our unmet competition, that's the standard we're enforcing. We laid out a policy statement last year, laid out very what that means, affecting century case.
So I will look at your calculation. I appreciate time today.
We are taking a 5-minute recess, and it's really here to that. It will be 5 minutes.
He said, quote, we do things to make sure the market has clarity, to make sure that the clarity was the quote I wrote for you. I was like that up because the second circuit, no act in 1984 said the FTC chose to define the conditions of conduct would be unfair, so the businesses have inkling as to what they're lawfully, but they cannot rather be left in a state of complete indignity. But I'm going to away the consumer welfare standard. I would want the FTC effectively created a moving goal here. And his best question on that, so with several questions, he said, well, basically, it kind of depends by different laws. Is that effectively the summary of what I said and the guidance that we provided last year in the policy statement regarding the unfair methods of competition under Section 5 of the FTC?
Section 5 of the FTC Act is a different statutory scheme than the Sherman Act, so we look at case law specific to Section 5 and specific to the FTC Act when interpreting.
November 10th, 2022, the sentencing statement of Commissioner Christine Wilson handles that, Section 5 of the FTC in the policy statement. He said this, quote, fortunately, instead of providing any guidance to business, the policy statement says the committee has the authority to merely condemn essentially in business conduct it finds distasteful. Did it consider that one of the members would issue such statement, such conclusion?
So the business members can have discussion, debate, and disagreement, and also seriously input they're getting from other members of the commission. As you see in policy itself, it has reflects the law that we can go very close look at to make sure that we're hewing very closely to this text statute as well as relevant precedent.
Let's get to the early termination issue that Mr. Burns talked about earlier. I sent you a letter earlier this year about that issue, and you wrote that early termination costs or consumes agency resources. Can you explain the early diverse agency resources?
So our staff is reviewing filings, they're in the process of litigating or investigating, and they're looking at agency filings. The primary goal, our statutory mandate, is to identify transactions that violate Clayton Act or the other antitrust laws. Granting early termination is a discretionary function, and so we decide to put resources for the mandatory function in the statute over discretionary.
But for years, that early policy allowed the FTC to allow merger and acquisition of a small size or size where really no acquisition issue really prevented. You go in for those businesses that they proceed with merger and acquisition. But that's no longer the case, TC, right? You're holding businesses in limbo because you're getting the letters saying, oh, we're going to get it. We're not sure. And businesses have to move forward the mergers and acquisitions because sometimes the finance is tied up in the time frame that they need. Is that true or is it untrue?
So the context here is we're talking about 30 days. 30 days before they're consummated to hear from the agencies. In the past, we have done early termination on 8.5. Now they're not getting it, but after day 30, it's a consummate. So we decided that it's a matter of allocating our resources, the better use of resources, identify which actions be a good problem for workers or honest businesses, rather than how kind of heavy firms may have gotten in the past.
It seems that a lot of the resources about allocation resources have been going towards new rulemaking. The FTC, I think, work through some of these you look at, some should look at, and probably look at. Is that reason why in 2020 the FTC got going down just was a 2 high, but in 2021, the year you came here, the FTC took only actions against mergers. In 2022, only 17 actions. Is it because you're focused too much on rulemaking? All your resources are allocated in that direction?
So there are no real, we're proposed a rule to update the HSR form in the Bureau of Customs, but aside from that, the vast majority of research on force. So those numbers you mentioned are outdated. We provide the updated numbers, and Ford is squarely in line with prior years.
The gentleman yields back. Recognize Mr. Hunt from Texas.
Thank you, Mr. Chairman. Thank you, man. Really appreciate it. It was kind of a long day. First one for you is on 13/22, the FTC proposed the motor vehicle dealers trade rule.
Yes.
Did the FTC conduct a cost analysis for this rule, determine the cost of what this rule might be, and what did the cost-benefit analysis include in the call?
So that conduct that analysis pursuant to Administrative Procedure Act. Notice proposed rulemaking lays out so that preliminary analysis.
Any idea cost?
I'm not calling it.
I got 4%. This is a study that's demonstrated auto research conducted that a full cost analysis of the rule and imposed a cost of $38 billion to be over the next 10 years.
Objection.
This is a study done by some outsiders. This is the FTC analysis.
No, this is an outsider.
I'm not familiar with comments on rules, so I'm looking at the closing names of those.
What was this to you? I'm pleased to look at it, and now your copy. I would love to read, sir, that cost. Actually, it's in the American, if you don't mind.
How do I will similarly, the rule we proposed is designed to address trunk fees, bait switch tactic, some of the harm that consumers have been encountering in context. We received over 100,000 complaints from consumers last year related to some of these deceptive practices in the auto purchase. So that's what I really trying to address.
Okay, and things will prevent unborn possibly the issue that you just addressed. No, supporting these costs, guidance and transparency with inflation, we've been so sure that we protect the American. Switch gears. The FTC has made a mandate protecting consumer and privacy. Under that mandate, do you think the FTC compel a company to obtain certain data, including identifier information?
Is there a particular context you think of?
This particular context about kind of the flow of this is. I can't exactly who asked the question for them anonymity, but what's your overall view of including their data have personal information as the FTC?
Overall goal of data privacy and security is to protect the privacy and security of data. What remedy or relief we're seeking generally speaking to my data be collected. I'm not sure what this means.
Unless do you think the purpose has been the collection of and then more particular data as a whole?
Again, would be happy to look in a specific matter that you're concerned. Key goal of some private work been data to limit what data is being collected. In the first instance, because we've seen that the best way to minimize risk of privacy and security.
Thank you very much.
Gentleman yields. Recognize the gentleman from South Carolina for 5 minutes.
Thank you, Mr. Chairman, for being here. I know it's been a long day. The FTC's mission is to protect the public from deceptive and unfair trade practices and competition. Even on our website, the FTC's work to protect consumers and competition touch the economic life of all of us. The FTC is charged with very important mission and have long. Bloomberg report recently found that 71 attorneys left the agency in a 2-year period between 21 and 22. This is the high number of departures in 20 years. That being said, it's tough, I would imagine, to protect the American consumer remote competition when your staff is leaving. As you know, Congress receives employee viewpoints for FTC visas to enforce agency's function. In 2020, 87% of FTC employees agreed that senior leaders maintain high standards of honesty and integrity. In 2 years, that dropped from 53% and also 49%. Similarly, in 2021, 83% of FTC employees agreed that with the highest level of respect for senior leaders. Again, in one that dropped 39% and 22 to 44%. In 2018, FTC agreed that senior leaders had high levels of motivation and commitment in force. Under your leadership, that has dropped 52% 21 and 36% in 2022. So my question, frankly, is why is it so popular to work at the FTC?
So we have been tactic staff with data audifying the people and protect them from unlawful business practices. I take those surveys all seriously, and we've been engaged in series steps to make sure that the FTC is a good piece of work. And really, over the last couple of years, we've been able to on hundreds of new employees at the FTC. Just the month launched a new office of technology. Within a week, we got 600 applications. Knowledge their data scientists, data engineers, highly qualified people come on to work at the FTC. Make sure that we're able to use their technological expertise as we can do our work to protect the American public.
Chair, I would imagine with high vacancies have been as a result of the last 2 years that you were hiring more people in addition. I think 33% budget. So I would imagine there's a drive to have people in general to fill those spots. But I think my concern is the happiness of people within the agency and why it is. Do you care to comment on that?
Yeah, I take that very seriously. And, we've engaged in a lot of conversations meetings to understand what the source of those issues were, been able to implement a set of steps, including streamlined decisioning, expand conditions around priorities, clarify what our flexibility policies would be, and that each has contributed.
And please don't comment as me attacking you or your agency to me when I read that. Of course, my colleague here have got a policy frustrated with your organization, maybe you. But when I'm reading about employee satisfaction, the FTC serves such a vital purpose in the country. It's just really alarming to see from one of the top performing agencies of employee satisfaction really with the bottom. In a 2-year period. It's just really alarming. So what do you think they've learned? I mean, you've been here for 2 years. From you've seen, all the times. Do you learn anything as a result of maybe your leadership or leadership around you on how to handle this and correct it?
So as I said, we undertook a step to make sure we were appropriate streamlining decision-making, expanding engagements with staff across the agency. In terms of learning, I have the privilege of seeing firsthand just how hard TC staff day in, day out. Oftentimes they go up against companies whose resources really dwarf ours, and it's a pure mismatch in resources, but able to toe on talent that just reflects the talent and dedication of our staff.
Well, good. And I there's a lot. I think Ms. Muggs taught an important issue about creepy debt collection going on youth all day. Then it's important, but you have to correct the type of that you form. And I think that starts with you, starts with the team. I don't want to read about toxic people in the earth or mismanaged ourselves. There has been a lot of ups and downs with the FTC, and the I'm hopeful you correct that. Thank you, Mr. Chair.
Yield back, yield 5 minutes to myself. I just want to take a little bit where big comes from Johnson, where talking about diversity, equity, inclusion, that Commissioner has evidently championed. Do you believe, and I know it's hard, but give me a yes or no answer, do you believe that should be a major and significant part of antitrust enforcement? I believe it's your job.
So our job is to enforce the antitrust laws, which prohibit unfair competition, deals with substantially less competition, to greater monopoly, win without
what does that have to do with diversity, equity, and inclusion?
I'm not really sure. I mean, could you share more about your specific concerns?
Mr. Lawyer said we have votes. That needs to be and have a major role in enforcement. That's a very major piece of that part of it. Do you agree with that? I didn't think, honestly, parties do have that job and that responsibility. I didn't believe that yours did, but I was concerned, are we going to, as it is short of resources, do things we want to do to protect the consumer? I don't know why we would divert resources, time, energy, and people power to actually go forward with that.
Yeah, look, I won't be on behalf of my colleague. I mean, what I think about is the way in which concentration of empowerment power for everybody. And we need to keep that in mind where we use these tools that ensure we're protecting all parties can help from these practices.
I agree. I'm concerned, the state of morale at the FTC again tenure. Examples such as hiring a chief staff scribes frequently create friction with an aggressive managerial style, choosing an associate director in the Bureau of Competition in 2 years of experience before joining your office as a member. Can you speak on that for just a moment?
Yeah, I'm really lucky having tested your
Sorry to interrupt you. something, and let me say this just to maybe clarify some more. On the matter of agency morale, the Bureau of Competition you're familiar with, whose mission for the antitrust laws, one of the top priorities, I believe is, saw its agent and satisfaction score drop by 33% since you began your tenure. You think all of your leadership style is a result of something else? There are other factors that are affecting FTC employees. Do a lot of great people, but the point is, a lot of people also are not happy.
And I couldn't agree more. It's important for us to understand what some of the sources of those numbers are, and has been looking to do. I should also, the Bureau in particular, over the last couple of years, been the front lines of search merger filings. I mean, year over year, 7% increase in the number of filings coming in. The numbers
But they're not. We have a lot of very hard, but they're happy.
To commend them, of course. And so we've been looking to understand what can be done.
You're working on this.
Correct.
Oh, you think it's going to get better? Okay. I want to talk about unpaid consultants for a moment. The Office of the Inspector General, not me saying this, the Inspector General says, labeled as, quote, unprecedented, end quote. Inspector General report from last year said didn't give the consultants clear guidance, or I'm not saying it, this is not a Republican or everybody else, on their work, and there was concern that these practices, quote, violate policies for agencies that still, as such agencies, these hires are not allowed to play an inherently governmental function. Can you tell us how many consultants are working at FTC, what they're doing, and how often you meet them?
There is federal or government agencies use some of these consultants, particularly in areas where we don't have using
Inspectors not run out of time. Why do you inspect them?
The Inspector report identifies certain areas with high policies and serious, make sure we're meeting. We followed very closely the IU's recommendations and moving forward to implement those recommendations.
I have items for I've worked with the American Factory Reform model. Lina Khan has something to do with as well as Con Reels that she handpicks her unpaid consultants. Thank you for your answers. I'm going to get back with that. That concludes the hearing. That is for the committee for being here. Without action, we'll have follow-up days, for witnesses, or additional materials for the record. Objection. Hearing is adjourned.
Requirements, instructions. So this new proposed rule will require submission of substantial additional documents from what is the status quo, including draft agreements sheets opposed to just the final proposal review, information about creditors, nor shareholders, officers, directors, information on labor markets, data out, of course, including geographic information about employees, and details about prior findings by the NLRB, and other things.
Yes, we issued a rule of suggestions for additional information vetting. Another key area would be foreign subsidies. Congress has again bring now their foreign merger getting subsidies from China or other countries.
But instantly, this proposed rule will substantially expand the type of volume of documentation that are being submitted as part of the pre-merger review process, correct?
That's right.
Okay, you all know that this new rule, if it would substantially affect the time and the cost associated for entities who want to participate and make submissions under the pre-merger review process, correct?
People have to comply with the new form, which is seeking additional information.
Right. And your agency has estimated that the increase by over 100 hours the time necessary to compile compliance documents to this submission, and in some cases, and in some of the complex larger cases, even more than the 100 hours, correct?
These are some estimates in the APR, yes.
Yes. And the internal estimate also identified a cost estimated $350 million impact for the change of rule. Is that right?
It's all fair, and I will say a lot will depend on complexity of the transaction. If you're a merger between fairly offer that don't have any, complex holdings around it, I actually want us.
You just raised very interesting things I want to we don't go in the time and the cost associated with pre-merger review process, time spent increase, cost increase, you won't up the businesses that are low and the most, the least able to incur those costs and time when affecting the overall margins.
But it really will depend on the complexity of the merger. If it's a simple transaction, I mentioned it will be much easier to buy. I should also know it's all about what firms to produce on the front end, and it's our belief that by more information day one, that'll allow us to more efficiently if we administer the laws in ways that could create more certainty for business on the back end.
At the conceptual level, the large corporations, the one I believe the most concerned about, the very large corporations, the ones who most people say, bring in our outside counsel and spend a couple hundred hours, or let's allocate costs through this process. They would be the one who can most easily absorb change opposed to the smaller entities, the lower in that threshold. Now, let's go here. So by expanding types of documents, the types of information you are reviewing in assessing whether a merger should be approved in an electricity, really the bases. FTC could choose to approve, seek more information, or disapprove. Are you not?
We're still sort of focused on whether the merger may substantially lessen competition or that remain our legal standard. We're seeking.
How is some of the information requesting, though, such as demographic information about employees or information about shareholders and officers, how would that really act to that information that you all have been doing right now?
So issues related to officers and make overlapping records. Those in effect, for example, State Claim Act, terms with you have interlocking records. So there's issues, they're squarely within the confines of the insurance.
So let me then, the proposed rule, it's something that you have developed as especially what's an impact on mergers, on all the economy, on business, everything that kind of thing, correct?
We're pursuing it because we think it'll allow the FTC to administer law that Congress has charged us with more actively.
So people live
Will enable FTC to
but else would made in Congress wages paid, correct?
Do that, the Renew Act allows the agencies get mission on front end, firms by law required to do so, and we're acting pursuit of that duty.
I'm the from Indiana.
I'm Commissioner Khan in here. So I want to bring to you, and I would like to respond, but first, I belong to a group of people, even though I very much agree with Mr. Tony that the majority of monopoly problems were significant because we create monopolies, incentivizes monopoly. Unfortunately, we create more companies now to fail, and all of the idea I'm conducting actually work on the members, and I work with the county, and it is bigger, and I'm going to be doing that. But I also understand there's two areas we have now that it was us to look at barriers of entry, healthcare, and then looking at what I'm going to deal now with monopolies, distorting market, using very aggressive behaviors, suppress consumer, suppress competitiveness, and believe now because they can't, and monopoly, creating have to look at that. So I think your agency has an important function, but unfortunately, I want you to really respond that we have a lot of concern from the Republican side, and the agency is politicized, and agencies been used to really, they have and not to actually predict, kind of passion to pick losers and winners. And I think, it's been the problem. If you look at the missions that you have and objectives that we need to have more, merge together to protection and competition, and your agency shapes distribution of power. I truly don't believe that is the agency. I think the agency should be, dealing with real abusers in the system that want to manipulate powers. So even this is a problem. And I think we have one common ground that seems like a lot of talks on healthcare, but when we come to the actions recently, we put on the table President Biden's administration on dealing with site mutual paying hospitals to ban Medicare, totally of power, allow them to buy private practices, allow them to put up in crazy companies like that. You have not paying taxes. Yes, billions on Wall Street, paid billions to executive subsidies that are now bankrupt on because sort of Spanish healthcare in the world, they didn't want to do with that, and I do have a because a lot of the entities in pocket really doesn't have guidance that the next business is supposed to be that again. You don't have a full jurisdiction to deal with this entity. No one has, and you would like to deal with it. But now my colleagues here have a concern with we have actually a lot more people here feel services you don't enforce and probably will use that power. You actually lose and win. So I want you to see how you can respond, with what you do in this area. Things are be public common of that. But look at 50 to 60% of this, to him is actually not it's a huge on me. How do what you do on that? And how you would address this probably because I think it has some options. But unfortunately everything's split side. And a lot of people here in the side of the aisle don't feel comfortable being more busy.
Absolutely right. Yeah, said we're streams relating to health markets. We're concerned about instances in which monopolists practice or lack competition health markets, maybe raising rate prices for consumers, maybe depriving them of access to quality health care. These have now been challenged hospital where they determine that the way the rate prices or competition based competition. We haven't gone away as talked about extensively today in PBN, the telecom structure that created the administration is issues that be created through rate keys that have in base. We all have lower directly at price, and we're in positions of pharmaceutical companies, hitting innovation, maybe lower cost alternatives, out of the medications. So that's the work that we have underway, and we're going to clean all of that.
I'm kind of sorry, but I can concern my colleagues on
Lady yields back. I recognize the June 6th.
Thank you, Chair. It's good to have you here today. I'd like to talk about the Horse Racing Integrity and Safety Act. Well, it's called the Horse Racing Integrity and Safety Authority, which Congress created and put under your commission's rulemaking. I know you didn't have this, but you got it. And I've got questions. They're not complaints directed toward your leadership. That's
like I said, I'm very disappointed in how they operated. HISA was intended to improve fairness and enforcing fall short of promises. The issues I have, I'm sure you're aware of, and I don't want to down and talk about more. The FTC allowed them to operate their rules, I believe, without or any oversight. There's also a budget of $66 million. My question is, does the FTC wonder how these funds and the recipient of the budget funds are going to?
So the statutory scheme lays a relationship between FTC and the organization. Wouldn't ask authority to be an expensive challenge directly funding it. We have to release this area. So yeah, it's not totally sure. They have authority to bring they use me.
Okay.
Back to you on that.
I believe the FTC staff investigating antitrust and needed to search a business premise. Would the FTC need a search warrant for that search?
Presumably, I do believe Section 9 of the FTC Act does give the FTC the ability to engage with that law.
Right. I'll tell you that this authority your solution and conduct without warrant. They can also impose immediate suspension of maintenance owners. There's no suspicion of voting. One reason created is because of the deaths and the rating. In the past, we've seen this deaths have happened to indicate that this authority is poorly run and operating in a way that I feel really need to. I said talk to all about that after this hearing. We'll talk about some of the mergers and the police. We'll check those. I'm specifically curious. We got a letter Senator Warren sent in January this year about some pharmaceutical mergers. How much interaction does her staff or have people these? Do they influence the direction you all go? Some investigations.
We hear routinely members of the including members of the week of that advisement. I don't understand what her concerns, but any law enforcement decisions we're making on an independent basis based on the facts of law.
Well, look at particularly the MGen and Heisenberg. I'm moving along to one. Some of these mergers that mentions in the letter, and I know we have about which one you don't. Verizon, the Irish company, it's kind of a special case because they merged it in 2014 by acquiring this Irish company, so actually left the US for tax benefits. Now MGen, as I understand it, is looking to this company. They're involved in totally different. And this would actually bring back to the United States. I believe it's a goal that we share as being industry here at home. So I would also ask, especially since it seems to Dr. Senator Warren's letter, if I could sit down with you at some point, we talk about this one as well. Can we?
We'd be happy to have a conversation.
I appreciate your work and thank you for being here.
Yields back. We are going to take a recess. We have a vote. As votes are completed, we will be back. Thank you. We get a little recess now.
Judges facing antitrust today were, quote, the result of a choice made 4 years ago to follow the policy of people. In other words, according to the failing do the last 4 years, bipartisan view. More than Congress all states their enforcement is down wrong. Consider that we're the U.S. unemployment true annual economy 25 trillion was the single greatest creation in human history. But everyone policy was decade for there was wrong. She's trying to grapple apart from the American economy to a system where her companies have been back to the country untethered from any reasonable reading of precedent or steps or law. But that's now, over the years into her tenure, lost her to any trust. Playing out, she had one of those critical entities argument. Short answer is that has been a disaster. She couldn't see third parties with big holiday without any follow through or partly for the request themselves. These tries been within her. Related pretext of due process transparency in that decision. Her process characterized reputation followed by all of this. So I'd like to when she was target harassment of Twitter. After Mr. Trust company followed her from Democrat senators, this FTC issued 350 requests for information from Twitter. These requests did asking for every information about Mr. Musk's side of the company and asking for information about Twitter's work with journalists, working with the government, government-driven practices, and still said, this week to salary effort and from there in Western disobedience. Just this morning, in a court, the situation is actually years we mentioned. It's one harassment. It was a takedown. The FTC as compact to the consent order requires return to minister. Independent legal obligation is to be truly independent and active, not for one part or another. What turns objectivity was not. What better permission is in here. Here what Fox said about the independent hired in this manner. Quote, the FTC was so adamant with conveying this absolutely what you will do is going to occur and do the court into the day that we negative observe that if Ernst & Young designed as the investor, the FTC would take exception to their withdrawal and create other challenges for Ernst & Young over time. This is not conjecture from Twitter. This is from sworn testimony. The independent in the deposition itself just last month. This is outrageous. This is unacceptable. And it's behavior that occurs in banana republics, not in the United States of America. So it's no wonder Khan had no information to the people's representatives, to the people of the committee when we asked for it. Today, the CNL replied with the single request document on the committee. And because of her management, not even her own staff with Chairman Hunt's leadership. 2020, last year, the Trump administration, 87% agreed the senior leader maintained high standards. Under Khan, that figure on 50% in 2021 is leave to be in 2022. 28% of the employees read that they have a high risk for the FTC leaves the chairman, Figma did if we print. No, before is via real. That chair, the FTC's account to yourself from a base. Should not yourself and then you have misguided Congress about taking that. Got a question to get through? Lower the response from Chairman FTC. Would yield the gentleman your thank you, man, for statement.
Thank you, Mr. Chairman. Mr. Chairman, since you brought Robert Bart, I must say that for the last 40 years, Robert, the unfortunate following Robert and the old branches of antitrust law has resulted in a terrible misinterpretation of antitrust law and is directly responsible for the concentration of industry power of the business takes on. Chairman, yesterday the FBI witnessed for nearly 6 hours. In the steady stream of facts and conspiracy theories meant to fit for our narrative, made on Fox News, but that back any basis of fact. Today, it is the chair of the Federal Trade Commission who set foot in the universe that has to be under MAGA Republican leadership. Chairman, the last time you were here, you decided to say, having green viewer skated word anti-trust, and I thank you for your service to the committee. Unfortunately, I said today, you will be the target of a right personal acts and organizations about work of FTC regulation. Focus will have the minutes wasting resources, but the FTC has returned over $430 million in consumers under your watch, and it's very important laws Congress has entrusted over. Meanwhile, the House Republicans who wasted untold congressional staff and agency staff resources and millions of dollars in pursuing a fruitless evidence at the FTC. The majority will also argue that the FTC's investigation into Twitter was politically motivated and conducted at the behest of congressional Democrats. So argument also has no basis in fact. Twitter has been trouble with failing to adequately protect privacy use for a decade. It has been subject to consent decree since as far back as 2011. It came under a second consent decree last year. Given the House of owner, it may well be subject to scrutiny today. It is duty to review complaints to these consent decrees, particularly when, as occurred last year, there are credible concerns that user data may have been compromised, chief legal engineering got fired. This has nothing to do with owning a company and his political views. Protecting user privacy is not political. Rushing to defend the company at all costs, investigating the agency that attempts to hold that company accountable merely because the owner shares your political views is another matter. Ultimately, Mr. Khan, you face the tax today because you are doing your job, and that's what the rest of Hawkins must. The Federal Trade Commission created a charge with lifting interest laws to respond to a race consolidation across the market in the early 1900s. It helped become the trust and listen power to strengthen the economy and support formation of a strong middle class. Unfortunately, in recent decades, Skid took a risk away from enforcement of the antitrust laws that kept safe and prosperous in the century. That failure led to massive consolidation across the market, gave us a handful of million companies with power to swat competition. The rise of monopolies and sales was a boon to the corporate class, but it has been devastating to consumers, workers, and small businesses. This began to change, and Biden administration now several steps to reintegrate federal antitrust laws. By faithfully interpreting the original intent of the antitrust laws and the FTC Act to ensure fair competition basis, the administration announced that the party is for a large and corporation. Although most of America's wealth has changed and the economy is booming and employment at a historic low, the commitment to enforcing these laws has raised alarm among Republican colleagues, so they take an aim at your agency in work the FTC does to protect consumers and competition. I hope that my Republican colleagues will find within themselves to the basis of personal attack on pause long enough to listen to the importance of permission. In any event, I appreciate your hearing today, and I appreciate the work of the FTC. I look forward to testimony, and I yield the time.
Gentlemen, the objective statement will include read one enters today's the Honorable Lina Khan, Federal Commission, born in June 15, between we welcome witness and thank her for appearing today. We begin by swearing you. Please rise and raise your right hand. To affirm only perjury that you're about to give is true and correct the best knowledge information will you. The record the witness in the affirmative, including you know the testimony you've seen this before. It's been back behind the chairman before, the former chairman before. So your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony. Like that, if you need a favor. Chair, again, and then we'll question.
Chairman Jordan, Ranking Member Mather, and member of the committee, thank you for inviting me to decide today. I am glad to join you to discuss the FTC work to promote fair competition, protect Americans from unfair practices. It's a particular honor to appear before this committee I had the great privilege of serving during its historic bipartisan investigation into digital markets and the power of technology. As this committee knows well, there has long been a battle in this country between monopoly power and America's democratic institutions. Congress created the FTC in 1915 against the backdrop of a revolution that had delivered significant technological success, but also enabled consolidation. The national is about the unchecked power these monopolists wield. Lawmakers task the FTC, preventing unfair competition and denying business practices through data collection and continuous able inequities. In the spirit, Congress has expanded legislation to include law aimed at protecting consumers. If these efforts, Congress has redoubled its commitment to fair competition to root out unfair business practices. The FTC earned North Stars fill an important mandate that Congress has given us, and we can faithfully force laws to safeguard America's citizens from evil interests, concentration, private power that characterize significant losses on any day. I am endlessly impressed by the talent and tenacity of the FTC teams, especially in its ongoing enforcement strength and legal warfare duties. Over the past 4 months, the FTC moved on major transactions that have rooted competition in critical sectors of the economy, including semiconductor, energy, digital markets, and pharmaceuticals. We're tackling anti-competitive practices, including those from American marketers and workers. Last year, the FTC and a bipartisan coalition of 10 state attorneys general charged 2 largest manufacturers on all states permanent farmers for having access to products costing billions of dollars. In January, the FTC's proposal would ban a barrier from imposing non-compete restrictions that auto workers collectively for which is up to $300 billion, also driving up in the employees to expand. In non-then proposed this rule, we received over 21,000 comments, including from nurses and doctors, food workers, hairdressers, all that on hurt airline hosts under my liberty. Already several forces actioned by the FTC have left from drop manufacturers and imposed workers. The FTC also continues as a tool to impact boundaries. Last June, Commission on Inquiry, the practice from its measures to on the okay operations of these government who pay and access to life-saving drugs for millions of Americans. This inquiry follows thousands of public comments the FTC explaining real life cost and follow from being certain practices. One doctor, for example, recounted how delays PEP approvals caused her patient to develop otherwise by ultimately leading to new loss of her die. In addition to these critical areas of work, we've done our to protect American privacy and combat fraud, while having additional participants. We've had actions to protect consumers from middle safe fraud, protect military families from predatory financing, and protect addiction recovery patients from deception. We are fighting to protect the of people and of personal data of obtaining record judgments, being just judgment to private. The Commission proposal to address some of the widespread brands like industry fraud, Midwest fraud, and data ones. ACC is tackling junk fees, plaguing American consumers, and scrutinizing our patterns, trick people into online charges or sensitive. Scandal proposal require companies to make it easy to cancel subscription as this designed one. FTC is all could prepare their own products. The FTC has brought several actions against these imposing on restrictions, hurting commerce and independent society. In other words, the FTC is fighting all cylinders, fight every day to protect the American people from unlawfulness. This effort reflects the extraordinary work of our agencies, who and indication are standing up. It is a deep honor to serve it all, and I am enormously proud to see how our information possible work materially helping Americans in their day-to-day lives. In the act, our world promote the open, competitive, real markets of bedrock economic success and dynamism of our history. Thank you for the opportunity to appear before you today, and I hope to answer your questions.
Thank you, Madam Chair. Now, questions are generally for you.
Like other federal agencies, FTC designated agents have sufficient ago. On 2023, you testified before committee at House and Committee. Appear in Chair Raj asked, quote, are any support will not follow the Dale's advice, quote. You shall know in by saying that, quote, having split Dale, obtain actions that are in this list they made, quote. On 2023, a Bloomberg journalist published a leaked memorandum of the FTC Dale, analyzing I believe it is judge in the FTC's view made that accidentally called then. According to the memorandum, the Dale could be recused in his party alleged concern pursuant to regulations. You believe you're completely honest and recommended Congress not work, quote, any instance where you not follow the advice, they never know. Yeah, comment. Okay. In a letter you sent to this committee yesterday, even you claim you received own world yesterday, but ever so some months after you said not to accuse yourself. First, it is unbelievable to me that you would not bring up sides on the particular topic. You would have written advice on others, but on this topic, you claim you not receive a memo, and so you must believe the long receive oral advice and not receive oral advice, and quote, understand legal. Dale give you advice that is different what was written in the memorandum.
Thanks for the question, Congressman. So before the commission focused on assessing the power of large
You didn't answer the question I asked. The question I asked was, did you receive different oral advice than was memorandum from Dale? Simple question.
So I consulted with the ethics official. The ethics official, as we cited, noted that the ultimate instance where somebody has no financial interest.
Did you give you different advice that was in the memorandum? Yes or no?
The employee determine whether they should or should not lose.
Did you have advice that was in the written, yes or no?
Congressman, as noted in the written memorandum, there's no violated by my person.
But you didn't follow the advice. Did you would have accused anytime you?
I felt determined that there was no
How would you have accused anytime you?
There was no violation under laws because it happened a penny in financial stock, not a penny financial.
Did you give advice to accuse you to be so correct?
Congressman, as noted in the memo, I would
move on since you're not listening to my question. I read your page letters was nothing more than your base integrity here, Mr. Tribune, so I will defense. I read part 2035 of the Federal Regulations, which is trash ethics standards. I want to know that the standards are actually higher than what owed by lawyers, which brings you next. Do you employees of the FTC follow federal rules?
Of course,
you as lawyers at the FTC have to member good standing for the state.
The lawyer need to be good standing.
I understand that you mentioned your last 2020, but in 2014 questionnaire, you held your spouse counsel for the Democrats on this area committee. You decided but you're not practice law. Counsel is for lawyers, licensed lawyers, and the person can manage self-practice law, which I assume is not practice law. I want this to come here yourself. How is similar? Do you believe the proof of knowledge claim the title counsel?
Congressman, I had the honor to work with this committee. I complied with all of the documents that the HR requested, including application.
I got your registration dates when you're not in stand with New York Bar. License list to make you full value by registration and means that you're not paying your committee continuing education and getting a loss on the current. Also, your referral for disciplinary situations and reflected on your
For the statement of the gentlelady from incredible. We're looking staff all accusing them from any matters right there on the committee. That's the end of their whole Chair Khan. Chair Khan, thank you for coming to our committee today. A year from here, the commission has returned over $130 million consumers proposed in a non-compete agreement would be workers earning by $100 billion a year. Consumers up to $148 billion in healthcare and would close gender wage between 0.6 and 9.9. What are other ways that could support the economy?
Thank you for the question, Congressman. So our work on the antitrust side is focused on ensuring competition that involve bloggers that we would have eroded competition, including the defense industry, including healthcare. We've got a set of lawsuits that alleging that certain types of mergers would have deprived Americans of access to quality for healthcare. We have a whole set of work underway focused on the fact that all too often prices way too expensive for American people in ways and potential unlawful practices contributing to those high prices. All here to be businesses, independent grocers, independent farmers, franchisees about ways in which they help they have robust, open opportunity to come in the marketplace and make sure they are benefit for competition.
Thank you. We have made it Antitrust Force's own agency must be more active in enforcing the law, bring high cases. Those states are unsuccessful. Can you explain this for us? Share what the County is on the beat, the essential office.
Many I've been here that my worry has been about enforcement. Unfortunately, I think we're starting to need the last few days where all too often entire sectors are allowed to consolidate. That is not great and close out to competition. Recently, the Defense Department is noting how the consolidation also directly line security, where to consolidate industrial bases harming and making it less compete globally. These are some of the harming consolidation because that you can credit for vigorously enforce the laws that Congress has written for. This includes the system of activation on informative competition, includes Clayton Act, it's the Sherman Act. They've been provision these statutes, unfortunately, had been reformed. We fully committed to reintegrating law and make sure that we're fully enforcing all the provisions that Congress charged us.
I assume you also support the Act. I know you also support actions that under executive credit from the law. Why is it?
So our view that's every matter of cases. On the antitrust side, we have seen, unfortunately, instances in certain remedies that were achieved in just unfortunately failed to lead competition and the age required to under the law. So some behavioral commitments that were made or divestitures really failed to preserve competition for safeguarding. As a result, we're experiencing and adjusting and modifying their need. In some cases, that means bringing lawsuit remedies that we don't believe will resolve the underlying competitive harms. In other instances, it means really improving and strengthening and tightening up so it depends on a case.
Thank you. Despite claims from the majority did not follow ethics, you know that under law you have no conflicts of interest that require you to recuse yourself. And indeed, designated ethics official instructed you directly that to disabuse yourself as a person what you are charged to make.
That's right.
And you also spoke with the general counsel, also stated that the conflict of interest would require you to recuse, right?
That's right.
And you own any corporation or any personal it would require you to recuse yourself, correct?
Not a penny in any individual firm stock, correct?
The federal trade plays a critical role in consumers ensuring competition is interested in. The agency has worked for over 100 years, and I appreciate that continue to do your leadership. And finally, Mr. Chairman, for you, I ask the United States Constituent to record a copy of the letter from the to the Honorable Kathy Morris Rogers himself.
I appreciate that.
Thank you.
The California is nice.
Morning,
Three of you lost a challenge to the Activision acquisition. For the District of California, by Biden, denied request for recognition. The court called a lunacy and post-traditions. The court found you are not guilty on merits. You seem to I don't say to be disrespectful, but after all taxpayer funds. You're now 0 for 4 in mergers. Average win rate for the FTC and modern antitrust era is around 75%. So I ask, why are you losing so much?
Thanks for the question, Congressman. First of all, the FTC has some of the best litigators and in very problem shows just nominal teachers. So firstly, the fact the FTC is being fully overworked by some of these really go toe in terms of legal talent scale and normally have a lot
of the taxpayer are going to delay to the legal talent scale of actions, state tax dollars, and fees. The question is, why is your track record support because it actually wings?
Congressman, we've had civic support. Both that matters being against Charlie, where the court found zone in that case, also Ben Marshall, right, of brutal injury.
You're for in mergers. I was trying to out what's going. I found an article from New York Times, Ever 2022, which was made by conference, where you said, if there's a law, and agents think the current law make it difficult to read, they're huge in it. Fine. She added quote laws with Congress. The law need to update antitrust law versus the modern economy. I'm still not thinks it says 100% correct. So this raises the question: are you losing purpose?
Congressman, the key clause in quote is if there is a law violation. We only basis in the fact before us lead us to believe that there's a law violation under the existing laws. On merger front, there are a whole set of cases where we've won, including instances where the parties been in day after.
What do you mean? You said that any court losses with Congress, the lawmakers need to update antitrust. What do you mean?
So there's an institutional dialogue, right, between enforcers, between Congress, between the courts. There's a Senate of antitrust back and forth between Congress. The very committee in 1950s determined that the agencies and bring type cases that Congress would worry about in terms of nullity power.
If you're actually bringing the cases, you're losing because you don't have the pretty young Congress. This is how you think you persuade Congress to give you is by the authority you have.
Congressman, we only bring lawsuits where we believe there are violations and facts at hand. We are when we believe there are violations, and unfortunately, we'll go away, but we make information about it.
You exclude. But you can do it. Okay, what practice is otherwise? Let's look at the act is just in an attempt to Gordon, essentially in case law, you didn't find anything actually the court provided in terms of precedent. You did your own FTC decision as precedent. But respective of the legal standard, the court probably wouldn't have honored any standard. The court said that he had risks regarding the road is like decentralizing competition. Is citizens. Court also rejected likely anti-competitive event. The opposite. The record evidence points to more consumer access. This is why in the fate instrument. This Biden is so far from the mark.
The matters in the FTC administrative case. I'm speaking in what I'm saying. Our claim lays out the status view of the administrative resistance by the violation.
But the judge rejected now last year even more active on the appeal that you're less likely to win is a deferred trial court findings of fact in this very instance of match. So why are you even more resource pursuing so?
Secondly, was staff recommendation instead of general matter. Staff always exclude had opinion and looked at whether there are certain areas in law they've worked on. There are general types of that go to their FTC discipline.
Bill's time expired. She'll recognize
Chair Khan, I think we're here to help your next FBI record set here. Continue question taking his nepotism. Judge, it was really amazing the hypocrisy shown. The issue was weapons of the FBI. And yet, every member of this family was here on January 6, 2021. Knows the government was weaponized on that day. That said, nuclearized, take over government, contradiction of the office that each of us taken. And we learned members of this committee went and met with Trump, and that they were participating in the overthrow of our government and nuclearization of our government. And yet they had put the audacity, lack of question raised judgment, and went on. And I'm sorry, I came in here today and I'm sorry. Mr. Chairman, if you ask where the shot, I'm sure it's the rule when I came back. And I heard some questions of your relationship with our association. Hey, you don't talk about robocalls remains missing. You ask about membership in the Bar Association on a judiciary where our members who never pass are and our members this meeting stand. So we need to get beyond the hypocrisy and realize we are. Chairman, let me add this. The federal rate commission issues and maintains the service on Christmas media everywhere. You can find it easy. It's hard to unsubscribe. It's difficult to spot. This is a problem. This money can't give up, trying to unsubscribe or cancel their membership. What step is the FTC taking to deal in corrects it?
The Congressman, you have the right. We have a complaint database. We hear back from consumers. Oftentimes, we hear about significant of the description that very easy enough, but extremely possible in some cases to fully cancel. We've got informed actions, including a case brought against Monday last year. We also recently proposed a rule, our click to cancel rule, or require that you take asking the subscription as a supplement. We've been legal comments or closely over in terms of how to proceed.
Thank you, Val. I had bundled Disney, Hulu, and ESPN 26, and I tried to get a bundle and two blues, and I'm both, and it's fun, and it's easy.
That's right. We've all seen our work. These times use terms. These manipulative design types that design people into either unfunded services or make it very difficult to cancel or opt out of something. So those manipulative design take over.
In the term anti-human practice robocalls, and it is somebody these robocalls you decide they're trying to speak in this is also the CMA, what the FTC helps with these.
So we work hard on this front. One thing that wouldn't be out could be most effective and fit the resources. We will stream over internet protocol providers who sometimes are the facilitator or enable the calls. We will have actions get them in order to have more deterrent impact and really protect consumers from these undead calls.
And they tried to help companies that look for any trust actions could give them more choices and better rights.
Absolutely.
Thank you for what you're doing. By the way, do you have any you checked out in the library that are overdue? Good. Public care about it. That's important.
Gentleman back to California, just 5 minutes.
Thank you, Chairman. And on behalf of the committee, with work, 1,300 plus full-time equivalent to areas like warning robocalls and referred to pro right to bear the people of the FTC. Our people with the good work you do. My wish, as you said to me, highly successful in when you litigate. Our problem here today is that you're $500 million to spend, and you used to spend it promoting healthy when you're Saturday night. You seem to be very much, I believe, you've kidded the company should be less competitive to emerge. The merger has to somehow benefit the company and the consumer. And cannot be met. I'll take for example, Luna, a situation in which they have to tell you the company that they saw but still hold assets in, that has to be required so that a true non-competitive a technology of cancer can more quickly. One has another competitor, one which is not market, and decided the company would market about 10% of the somehow facilitated a new something we do that it hoping to do forcing it off. You're failing in that, you're going to fail. Then to Microsoft. Microsoft's a big money here seems to be down the end over $1 billion market cap when you serve on key big on if we're $1 billion you need to cover you. However, they bought the other day is one in which a market Sony is in China, a company that's already larger needs efficient. The reality is we are a global market and you are thinking only of who you want for some reason. And I cannot find your logic and I believe begin to copy you want your statistics, shame on you. In fact, this run this organization and let turn came over, not to have me a moment of urban there. Now, one of the things that gets me is, and this is my question to you, can your patient tell me? Because you would learn which is informed your action when you shoot. The kids inside could have money brings it forward. Where is the consumer benefit? I know you're going to say, oh, it's heading, we're still working on it, I can't answer. Interesting, you can answer the Democrats, you can answer to us, but I'll give you an answer. If he is on the market, and of companies they want to bring something to market, where does the FTC see anti-competitiveness in briefly, if you can?
So I just note, anybody asked me on either side about ongoing.
No, please answer my question. Time is limited.
I will not be able to answer about ongoing judicial proceedings. It doesn't matter that you mentioned it was a recent commission opinion. In that opinion, we voted out unanimously about how the antitrust laws apply in these markets. There is significant law or how incredibly important to protect competition, not as well as markets, especially.
Let's go back through this. Your opinion, whether inherited or deemed to bear, is that in the future there could be a competition in a market that has not yet occurred. People have to be standard of your market because we have to future. Your ability to predict the future, so how is it you couldn't predict you're going to lose 4 out of 4 cases? How is it you can predict future markets when in fact the start into it? I intend that you have oversight companies and $500 million budget. And I, for one, will not support your $160 million increase as long as you do not stick to those things which you do well, which the FTC has a responsibility and go robocalls. In fact, we never got you back.
Jeff from Georgia.
Thank you, Mr. Chairman. I want to commend my colleagues on the other side of the aisle and the 108 Congress in diversifying the membership inside the aisle, but frankly, they haven't done enough. They have not done enough. They can't do enough at this point. And it reflects in the treatment that women such as yourself, Lina Khan, receives from this committee. When this consent, sitting solo at that table, all these interrogators to say, don't the American people can see. And when we treat witnesses who looks like you with the hooks of personal addiction, and when we only act witnesses who, like you, with allegations of incompetence and a lack of ability to lead, it's indicative of the need for me to reflect what the American people have. I want to pay you today for thanking what you had to endure thus far. But I will say this, Americans rely on regulations to protect some workers in the country. The federal treatment be as aggressive as the circumstances dictate. Today in America, only 4 large conglomerates that control the market for beef or pork country. In addition, the meatpacking industry shows up at the grocery store, resulting in food for consumers, and at the same time, coincidentally, a record high profits for the corporate conglomerates, so the for the American people. A single company controls most of the web searching, and a single company controls all e-commerce. That's too much in hands of 2 corporations, and can hike prices with little recourse. They control vast amounts of personal data, and consumers are being squeezed by sedition in almost every aspect of the marketplace, from food production to hospitals. So I'm glad to see that you are using your position to strongly enforce antitrust laws to ensure fair competition and prices. More lucky to have an FTC chair not have personal monetary conflicts of interest that would require to use this involving big tech. And it's good thing, because that John is able to lead a nature that's currently companies, Amazon, Facebook, and Twitter. And I'm glad that we do not have our coding in-house, that we say that to see that actively working to protect American consumers. I want to ask you, Chair Khan, RC managers prescription drug benefit on behalf of large insurers, large employers, and other payers. How does middlemen allow PBMs to artificially inflict the price of drugs individuals must pay for critical medications, resulting in having to pay 20% more for generic drugs? And micro PBMs is an area of the market that's highly consolidated. It's 3 PBMs. Controlling 79% market. What can the Commission do to ensure the market pharmacy benefit managers is competitive and fair for Americans and affordable interest?
This is an area we're very closely. The issue policy last year, namely, of our concern pharmacy benefit management state. It did consolidate, and you mentioned we've all vertical integrated. So this PBM also expanded into insurance, sometimes competing with very friendly or dependent. We heard the acting great contact centers, also heard these PBMs mandates in ways they deny patient access to more affordable drugs. So we might know we're looking at this to see if violations will has asked.
Have you asked consent report? Chairman, I would complete his comment. I must say, I personally felt he turned Oregon's belief in me for his hand to really found our agreeing witness, apparently because of her person, we have to so much and I asked that board in this testimony to not as appropriate and argumentative to making it clear, and myself, members of Congress, but yesterday, he did what I would call everyone of age. Pretty similar.
I I don't think I'm going to participate in how you supposed to have right to the state.
Then after I'm over, but back in.
Well, we opted out for things in part to go disparage people. So let's just keep in mind. And with that, I know we get a unanimous consent.
Chairman, I would move for the entry of a letter from small business to yourself as well as to the ranking member, Jordan Adler, into the without objection.
Objection.
And I'd take if the chair will allow me to just clarify to my friend Chair Isa that no personal affront was intended. This was the entire.
The chair recognizes the council.
Thank you, Mr. John Key. I'm Chair Confier, Land Senator, along with my colleague, and the FTC Censorship of vital social government sectors, or ESG now, in order to check the head responsibility, the FTC's petition to the further on opposition significance. These will respond. Not sure whether it would block your federal company's criteria for the ESG goals. Commit each criteria will the FTC to
Apologies. Look at the statute which helps to operate a station line competition during that look at and companies experiments out. So just Mr. East observe this.
Indicating signal for referencing up inappropriate to Antitrust policy. FTC and national press, politically, and official communication. In particular, benches if any communicating with a warrant, states are general, outsiders.
The FTC have a clear policy requiring that any business related to station acts conduct only authorized FTC stations and comply with policy.
Do you have communication with now, Ms. Aramel, Sir Blue, is that right?
Ms. Lorraine is correct.
What will enroll in the Ladies Project? Our decision to take the committee, including myself, for opposition to this proposed not committee.
But I've never done those situations.
So we're involved in the doing co-founders today.
Congressman, we're really excited about the proposal. It's a lot of public comment. Eager to hear from both Congress to many of you about the proposal. We're eager to hear your feedback on it.
It was announced last night that intended to break 30 years of precedent by challenging the court's ruling in the merger. Also, fact explaining despite 30 countries in the European Union are regulating this merger that you intend to move forward with administrative freedom.
So currently, this matter is pending permission or administrative education, so I can't comment. When we get an adverse ruling, our team will ask the opinion to determine whether there are errors in the belief warrant appeal. Those are the considerations that they take into account.
In April, the FTC's Associate Director of Litigation for the Bureau of Competition stated at a conference that, quote, merger policy and deal policy, and quote, there's a role for policy directing capital flows in project. That means at the next venture capital meeting, they're not going to say what's exit via acquisition. It will be an appeal statement.
We're not familiar with the other, look at one further. Done is true that anti-trust policy is about competition. Entrepreneurs have from that adjust with vendor that we are concerned about lack of issues involving caught up on technology companies. These are issues that we hear about.
I think the issue for myself and colleagues is that way run the FTC, that simply until use it. You're also playing small businesses still in the you want to set up this cannot go rather than acquisition, but the cost of the public market doubled. It's not easy. And your colleague, Mr. Gensler, the FTC has been playing on with roommate. So I don't know if this is what me, I have why wouldn't you start a small business administration?
We hear from small businesses on those open machines, and they're not come out with. We hear from lots of business. More often, we hear about how they face and be able to compete in open, competitive marketplace. We hear about the existing value and the existing economies versus being able to be an independent grocer, independent pharmacist. So we are eager to hear from us and we're enforcing the law in the way that is already compete in their place.
Thank you, Chairman, and thanks to our witness for being here. I have interest in several areas where it seems to me that FTC is in less than percent, which you can see that notion. First, the area of what fees actually have 1% of our share. This is, Congressman and I introduced the Competition Act 2020 to introduce competition. We are paying a higher side fee than people do other development initiatives, and I'm wondering whether the FTC having an active instrument in this area. I'm also concerned about the issue of consolidation in the grocery sector. These large companies have the power to preferential pricing and treatment from suppliers to the detriment of independent grocers. Recently, Mr. Tiffany led probation asked for $10 million specifically for FTC and for the Robinson Act. I'm interested in what you could tell us about FTC and Robinson. Also, I've been a champion right to prepare. Congress ICE and I recently introduced a limited enforcement period design patent so that monopolists cannot ban individuals from repairing their own nixing the expert was before your tenure, but I'm interested in what FTC is interested in this area going forward. Finally, I'm going to ask you on to what I think is the toughest part of the act that's ever been used in Congress. Simply prevent Congress from cold gas. They cannot use it to manipulate America. I'm interested in what action the FTC is going to take. Minimize administration, like the security, security, privacy, and also computing.
On first day, students of the FTC found in Smash and MasterCard, we realized there was a violation of Brennan, and MasterCard had made an unlawful block, competing work, real estate content, and Congress to purchase market back 20 because they not right still see fees and MasterCard won't see instead where you have work competition. Robinson and enforcement of it is a top priority. We certainly from dependent grocers about the unfortunate treatment, discriminatory practices, maybe suing them, defaming them, keep them to compete, especially parts of rural America. That's the thing that we're getting close to. We also have from the market rate, looking at the changes and the teach that book from treatment have contributed. Right to repair, the areas for us, initiative rate that appropriation evaluation policies followed up with several enforcement actions. They data, then and Weber. Since then, we've also been working with state legislators. Several of them are also considering for legislation. Just among our staffers in California to 5 days there, input and feedback on their legislative to areas. We're bringing all this, but also conservative social buyers or other legislators are working active, ensuring votes tries to for American top priority. We've been remote active in this area, especially when involved social privacy. Brought up some action against this one certain lack privacy policy that they had in place. Asia and children, we've been looking at people's sensitive health information, instances in Chinese for the purpose of providing health services, then turning it around and making it for advertising, and we're also looking at geolocation data. We have a lawsuit pending in Idaho against a group called where we alleged in our complaint that its practices people do not need to get sensitive geolocation information on consumers, whether they were going to church, whether they were seeing health services, whether they were addiction recovery facility, very sensitive data. So that lawsuit is still pending.
Thank you, Commissioner. I yield back.
Ladies practicing self.
Congressman, thanks for the questions. You may know the FTC work goes back a decade, back in 2000.
I'm not talking about a decade, I'm talking now.
Back
12 days in 10 weeks, over 350 separate requests you've made to Twitter.
Twitter has a history of lax security and privacy policies.
Just for every single communication relating to laws, not just one communications received. Anytime he's in, that's actually more, actually, that seems like almost obsession. Why is it folks?
It was found that Twitter's privacy policies allow enterprise users to cope Twitter accounts, including that of Fox News, subsequent voluntary action to consent or the FTC.
So, here's what you wrote in December. Identify all journalists and members of me who are in access to the company. Every journalist have companies too. That's still for them.
As more journalists take seriously the work and understand their fees and whatever an action is justified.
Particularly context here. It's been enough. The government asked private company about who the journalists can do. You name them and say, we put their names of opinion, communicate with that. I think, in fact, the First Amendment for the press. The in context of things that about government had suppressed speech on the platforms. That's the context. I think it's totally wrong.
Could then clearly have prohibited Twitter personal information for these. When you ran the papers like Ruby, that are access to the party, to risk information. Again, this is on me with
I'm not sure. I'm not sure who's David Rook. David Rook.
I'm not familiar
Did you post him back in 2023? Our first unions in tense with program that artist secretary. You missed in that position. No. It's very important to side. Our lawyers, those side FTC made the feel as the FTC was trying to influence the outcome of the engagement before it started. He said in the discussions that we were having with Raymond, expectations being conveyed about what the result should be before we had been done in receipts. So then the independent assessor in the decree FTC has with and who the person. He's the guy. He's supposed to give information. You're telling me on the scale, telling you what to be. He's supposed to be the independent. Why are you doing that?
I'm not familiar with those.
Because while we are a solid court and this is your position.
I'm happy to take a look at any practice. I will say, no matter, we want to make sure that the assessors and auditors that are responsible for overseeing clients doing their job.
You say Rook's line, what testified here, what's in front of court today? The person would expect the to be, they, FTC, there were suggestions of what they wanted to go fund in his independent agreement with the FTC and Twitter.
And not be able to keep out, but our staff, our climate professionals, when they conduct these investigations, they're focused on terminating.
You go after, is your attack enforcement based on all kinds of attitudes, the same something that you were dealing with distortion? That had to do with John?
We make only independent determinations about whether violations.
The same program handlers in the letter from that difference in the head on it.
Absolutely not. We look very closely at the matter.
Well, 10 letters in 10 weeks, telling them to say your skilled results. That's nothing to do with that. There has something to be held after her.
Our goals in technical process security, we're sensitive on Canadian Americans. We make really going all the way to 10. We're doing everything to make sure it's along with you.
Don't interfere on the scale and attack the First Amendment. Go back and recognize the Amendment 5.
Thank you, Chair. If you tell today, thank you for the refreshing, aggressive approach to ensure competition. Maybe we have a point that where they're in and control power. At the expense of what we challenge you face today, it's not people working. People are working. The process not get by. And if that is all, this function happens. Like we don't think we have seen our history. What they're doing. I want to ask you in particular about, as you written about the concern and innovation on large solutions for large chain. This has the potential of not only having impact on peace, but also having adverse impact from a job loss and from a creation of food debt or communities. If you're able to share your thought in terms of that particular measure, I would ask more generally what you're looking at in terms of the impact. And also vis-a-vis the narrowness of the focus on prices, that kind of looking at other criteria to the impact on communities and importers.
So we take a 360 view to fully understand how a particular merger may lessen competition in ways that are harming consumers and hurting suppliers. In the context of grocery mergers, we are taking care of we're looking at all that. As you know, there is a pending investigation occurring in the disclosure looking at their proposal. I'm curiously right, though we've seen consolidation and circulating effects of communities contributing to food deserts. One practice that's also on our radar is the way in which retain using one as restrictive covenants to try to lock out competition geographically. Would also be contributing to these deserts. So looking at that globally, we want to ensure that we're enforcing the antitrust laws that serve communities.
I agree that we're concerned about Kroger represents merger and the impact on that I represent many throughout the country in terms of impact on workers, prices, and on these. We just turn to the issue that they're interested with you. You get to elaborate on privacy, security problems at Twitter, how they can impact privacy of Americans. I'll take the opportunity because I'm concerned with the no proliferation of hate speech on Twitter, the very underneath the individual start with security, and the impact around hate, but also on the decrease in security and privacy people's data.
Again, we're focused on security events and being noted service history of the FTC goes back over a decade where serious security and privacy systems do personal information compromise As you noted, Twitter today also has this deeply sensitive information. To weird to Ross from the Twitter, fortunately, the invasion of player consider. We have key Twitter agency policy very hard, but we be to prevent any by Ross has been hired by the security driven and continue to that order being followed and observed peace by the
Well, I appreciate that. I'd also like to ask you on consent for a couple articles. One from Gizmodo, Elon can get 10 times the selling to users, and also an article, Interest Plan Government Manager Elon, which includes Twitter's video that domestic companies called the board members and shares, especially in the Rebecca and
Thank you, Chairman. Company for being here. Don't talk about Facebook or Google. Don't talk better of the company.
I know.
You know the exit, you use yourself from the activity involving Facebook on Facebook.
I got it. Yes.
Which cost by Congress? It does. It's $150 million against the bills passed out of this committee last Congress. They spent money lobbying, they spent money on advertising, money with third-party think tanks. They spent money that no other effort in recent memory certainly has been spent. And it's not just money that they spent, but on an example, and I call it Facebook, $20 million, as $19,120,000 Alphabet, $11,770,000 Apple, $5,000. But it's not the money that they spent lobbying and these. On June 18th, July 4, marking big bills to me, Paul Pelosi and Pelosi's husband bought 4,000 shares of Alphabet at auction, and she was stuck under price $4 a month later. Now, after we passed the bills, but Pelosi's secret sent the majority leader to the press to pass these bills were ready for floor. A month later, stock price rose to over $2,500, making Paul $52 million richer for that spending pen. Because the office should be statement denying all valid transaction. The fact means she refused to account for those bills. Bills resulted from an 18-month investigation. We had last year, as a result of Congressman Tribal's and some other efforts, to stop a ban that would prohibit member individual stocks. You probably don't know that 50 members of Congress stocks and pharmaceutical companies during the vote were immunized the term used for code. So immunized pharmaceutical companies, it was in problems with vaccines they did. We can't pass stop them. We can call you Congress to suggest that somehow you should be involved in involved in these companies because you lower your. I don't want to question that first. Who is lobbying for Amazon or Facebook?
No, string six on this. No.
Okay, they still are. If it was you, hired $100 to lobby them, and the same bills passed out did pass in advance. The same bills passed you did have the Senate Judiciary Committee, and there's all that day on the Senate floor either. But that's just how the game goes. You're aware of the need to update the antitrust laws concerning the new economy that we're facing. And I'd just like you, if you could, really explain why it's so difficult to apply antitrust laws written at the necessary to the new economy.
Thank you, Congressman. So there's a in the books that has embedded within it certain economic assumptions about how certain markets work, about what incentives businesses face. That doctrine, in some cases, 30 years old, before we had the advent of digital markets. Digital markets function differently, right? You have the self-reporting externalities, companies face different incentives, engage in different strategies, and sometimes there can be a gap between how doctrine is saying is right and what we're seeing. So legislative update needed to close that gap between what the theory says or what doctrine says, and we're doing in the actual market. So that's in particular where like that gap is critical.
Chairperson, welcome today. What is
I have the great honor of being the chair of the Federal Commission.
What do you role?
Manage agency protection for
consumer taxpayers.
Congress started to ban the EDX of the
That new?
Excuse me?
That's 14 you.
Authority since Act 1914 appointments in the loan case.
Total obligation fees for costs. Are you a profit center or are you an agency in charge of protecting consumers, enforcing the law, and being controlled that may protect consumer taxpayers?
We're a government agency that is doing every we have protecting people from ills and prices.
This is the government people sent here to Washington. I get skin balls every day, robocalls. Seniors rolls every day, veterans roll every day. How do you work at FTC to these something?
CFC rural jurisdiction is noted. What they're doing in going after the robocall yourself is identifying there's some factors that allow them to perforate. Sometimes these are originating from other countries in ways that can make us difficult for us to go to Latin. This is I look at providers and
That term people had inspiration that we had Interpol involved. Also originated in Mexico. The local telephone company Biden calling information and it was huge use mess. Channel very much a difficult. What can we do to help you train in these protocols?
I just update were recommend to you and your team. Generally, given the FTC also has authority over telecom carriers themselves, directly taking action at that year could also probably very good.
At the end of those scam calls, having us will get hurt really bad. You'll get that money back. This your agency doing to help consumers get their money.
We're being lawsuits where we can. A couple years ago, we suffered a back in court where the court said that to beat the FTC Act, which is a core provision that we use, go for get back money. People have been scanned out and we can use authority. I would accept back. Since then, we've been activating other legislative authorities. Sure, getting money back. There's billions of dollars evaporated and people are losing out as a result.
So do you need legislative help from Congress to do your job, protect consumers in this area?
Absolutely, legislation enable FTC to go into the sector to be in money back so that lobbyers are not profiting or lobbying.
I think that's important. There's a police officer waiting. Should the law. 10 times, my old stuff, the OP, don't do low safely, they don't know what to do. I hope you and agencies can be effective in making sure the consumers and medicine are protected. It seems especially that they're embarrassed to call me and tell me I got it off. They don't have the energy or the wherewithal to defend themselves. People protecting. I ask you a profit center, I know you're not, but nonetheless, I encourage you to continue to do a job because American taxpayers are beyond your agency and doing a good job. Thank you very much, Mr. Chair.
Back from Virginia, recognize.
Thank you. Madam Chairman, to omnibus resolutions and interest investigations. Mr. Lewin's give FTC control over FTC and they are just to action. And so mission was previously necessary investigation on the person is conduct. Foreigners will sign for this action from you. That there eliminated only liberation oversight. Would refuse some solution that my prosecution and are trying to commission to your own personal empire.
Government office resolution of the FTC or auction air standard for the on resolutions and consumer protection that and long point things we need brought contested in the area with the or to empower staff assembly.
Talk about that specifically so for someone change the AC to your 2022 the highest number of departures matter for a period staff coincidentally president campaign have list of 100 main for FTC and Andrew anyone who and me the president campaign you need to hire any individual okay and how do you hire any of these individuals?
No, I don't know, sir. I can
Let's move on to this committee and Mr. Lack thereof to this committee following but in March, your director of the Office of Congressional Relations testified before ICE Committee on Responsiveness Capability regarding a refusal to produce documents related to this committee's oversight of FTC's harassment of Elon Musk following his acquisition of Twitter. Known that the FTC frequently seeks extensive information from the parties it no party would require the FTC to conduct its investigation. The FTC seeks sanctions. In response to the city's inquiry, what has provided is predictive or otherwise find evil that the FTC policy such parties its investment. So this committee do and take from the FTC's reproduction date from the matter.
Commissioner Arch has been really responsive. We've been working after to quickly discuss. We've offered via numerous non-public briefings, including the matter that you mentioned. It's true, following long-term investigation, there are issue considerations we have taken into account during compromise law enforcement, really any of the free speech of third parties that communicate with us.
Does that include communication through non-governmental email accounts? Because in limited materials, you can see that your staff needed using Gmail accounts. In other words, employee rates using employees' email accounts. So you're talking about how you're to use government communication ads. Don't forget, there's ads not. What steps have you taken to material sources that need?
When we are to we provide continuing to make our most only provided, sometimes inadvertently or message up somewhere else to distort it or team and
did you answer don't effort in the EOJ any trust of it? 50 up to this with implementation areas Marks Act?
We have a really fantastic Office of National Affairs that I inherited was launched in 2007 as our national where we state police details.
Much office since after you.
We hold you.
Due to the bank partisanship that's come with the fact you bring request for information and wakefulness team, I know that the Brace Committee is working at Georgia as we speak, and they are seeing a 20% reduction in funding the FTC. The Brace Committee government bill. So, should happen to match her and see the consequences are impact.
Thank
Thank you very much.
Thank
you, Mr. Chairman. So that arbitration, I would just thank you for the investigations and status that protect small businesses and working here and promote competition. You have done what few before have dared to do. Few had courage to take on big issues who use their lobbying me, Americans with less transparency and higher costs. Take on big tech and the monopoly powers allow them to use our data and self out small competitors. That's something that I got a lot of different on Director Ray at the FBI around privacy. You're doing the same thing, and there should be more people like Representative Buck talk about that, talking about efforts that you are making to finally put in protecting consumers. And I'm grateful for it to you. In fact, because of your success, your courage, and your integrity, you're receiving a attack on your. So just for the record, with FTC ethics official, who won't stop in Meta, and she recommended that your hundreds herself investigating Meta's parent company. In contrast, Sherman no stock in big tech, not one penny. A federal judge ruled their stance do not constitute a conflict of interest. So I thank you for your integrity, your commitment, which is what President put to head FTC. Now I must have time talking about your implements, the FTC leadership. When words are taken people, mean that employers restrict and workers their employment contracts from freely who's filling. Particularly not banning the non-compete clause. Can you explain in plain language why your agency proposes rules in non-clauses?
And we provide each and our ex-officer for where on our ex-officer, a dedicated career professional who serves a United's best interest heart. Understand that instance she saw it in from the office of and get consistently with it. So these are that lucky that prevent from it an alternative with better time options we feed from our work because this press we're with $2-300 million. They so kill for startups, entrepreneurs, and businesses and that's why we propose it.
And so we're going to from the implementation of that rule.
At the stage would be everybody. We heard from journalists, healthcare workers, fast food workers, engineers, scientists, and these positively trade cross market and such communities are not for everybody.
So we turn to war on junk fees. You say that United members of Congress were on Hill, not pressing the track, Democrats and Republicans, because as James knows, there are quotes charges that if cost bad or little value. So tell how the threads are examples of what you're talking about, how you harm consumers.
Yeah, I'm already related to this, and there did a lot. These mystery fees show up, be it a resort fee charge on your hotel bill or an unwanted or unnecessary charge that shows somewhere else. One of the areas where we've heard most junk fees is in the auto context. Buying a car is one of the most significant financial investments people make. Unfortunately, we've heard all often consumers are saddled charges for unnecessary or unwanted redundant fees. We're moving forward there. We also read last year cancel Vonage for also including some junks when people try to cancel restrictions. So that's some of the work we currently submit on whether we should do more fees and the pretend purpose of the rule. We're reviewing and how to move forward.
And the FTC's got a long history of dealing with junk fees. Is that correct?
That's right.
Can you talk about that?
So again, auto in particular, and we've had hundreds of thousands, about 5 dozen lawsuits, invested in fees that consumers are saddled in a car, but it's really market-wide that we've seen these charges that we're looking to address.
I want you for your work. I hope that we talk more about some of the shared interests that we have across the aisle. Thank you. I
Finally, you are really one to impact how consumers are going to fit this world. For a long time, I want to get to those areas of agreement, but this is a deal. You guys putting in the names of reporters and correspondence with sole predicated based on anonymous sources.
It was based on report that.
And we agree that unsupported is not a threat here. Journalists.
Personally, those third parties, that for us, you want to not anyways just in interested in affecting journalists' privacy and security. So I really
that not good things as someone who's seen government action emerge. I'm not supporting some of that, but I'm glad it made acknowledgement. Let's on the important they're doing. Since Americans have linked camps. The OH recently said about a correspondent said, quote, during a 3-month period in 2017, a ring employee viewed thousands of videos of users in their bedrooms and bathrooms, including videos of Ring's own voice. There was also an order to the FTC, an unauthorized tunnel by a faith-based contractor to access consumer videos. An incident where an employee gave information about a customer, their ex-husband was something that you uncovered. Also state that actor took advantage of the camp's way making knowledge to harass and people whose victims. This is where a 7-year-old woman is living was surprised to a fears, kids, signatures. Got in a family who is alarmed to Bitcoin anthem. One half even communicated a feature to customer had already killed customer's mother and quote, tonight you die. What is going on at Ring?
So as you noted, we recently took enforcement action precisely because of these very serious lapses in data privacy, which endangered American day-to-day lives. Overall, looking at some of the surveillance devices and how it's used is a top area of for us. People's privacy is paramount.
That people to enhance their personal security, not to have their peaceful relative proposition, their slur at, and then to be told they were going to be able to pay Bitcoin. So thank you for that effort. Let's go to another evil company, Kochava. Kochava is the brokers that you're after, right? Young people should know that Kochava will locate where you go to church, and they sell that data to prices, right?
That's right.
That's
people with yes.
I got on the FBI director. They're creepy fight today. Now, Kochava really selling. Well, this is a Baptist. This is someone who goes to town. Are you going to get these people? Them.
We have a law last year. Dismissed it, gave the opportunity to refile. We also have an urge attack because the types of stigmatization harms that come from being able to track people's sensitive geolocation information is just critical for us.
Yeah, the FBI asked one to infiltrate Catholic churches. I don't know what I want the brokers to do. Same. And by the way, even the FBI is using the broker to do that for them. So I really want to work in Spain. I hope it's something that express. And there's criticism of loss in court, but if the lawyers know sometimes that a motion is an initial complaint, the pathway to an amendment to achieve legal law sufficient to stop data brokers selling information about constituents laws to stop Ring from these real work with us. And all of Ms. Buck's points are really simple. Congress bought off if it's to come here, be what email account you use or on here. I think missing the formal to the succeed for.
I was working with
We're
working with the lady who's here to do just that. This I think is getting wholly agreed on. I neglected this earlier. I'm sure we had this hour and a half if you need to so. If not, we'll go up hand. So you will keep on with the link for information.
Chairman, thank you and thanks for work and businesses and workers and consumers on issues from bias concerns to deceptive practices on following robocalls to fraud handle equation that senior service and prevent and doesn't confirm. Those are all the news we from our institutions regularly all of that. You don't just easier to claim against the credible works. Every day, some of us believe that people lunch side are the facts and easier. We appreciate your patience responding to fact-free questions. I want to focus my questions on hospital consolidation and the growing problem of private equity firms, hospitals, and healthcare groups. In the recent years, we've had 2 main hospitals purchased by private firms, after which those firms mismanaged the healthcare functions of the hospitals, string of assets, and then closing the hospitals for sale. It was a hospital in 2020, which was closed in the middle of the pandemic after a private equity-backed real estate developer bought it, taking hold in a frontline healthcare system in one of the poorest cities in the country. And then currently, closure system is teetering into bankruptcy, while hemorrhaging talented staff and medical practices after private equity owners risk to harm relationships, medical staff, and reduce access to medical care, particularly maternity care, services, and behavioral health care. The impact on the local healthcare system has been so extreme. We've seen local Republican politicians playing intervention in this private equity from hospital business to prevent closure participants. We're also seeing this national trend with firms embarked on buying spree to scoop up smaller healthcare groups, and we're revealing hospital study in the Washington Center for Equitable Work, telling the trend of private equity buying multiple doctor groups and then using that consolidation to raise prices. So we're really concerned about this trend. It's reducing healthcare and raising prices. So like the FTC's response to call for more regulatory scrutiny over the act and how to increase oversight and enforcement activities to ensure that preserve competitive healthcare system.
This is an important issue, and CRT has done a fantastic job really addressing hospital consolidation, particularly in markets. We had a whole set of successes really standing on hospitals emerge in ways that hurt patients. Our staff was transaction parties walk away. I correctly right, though, they were strategies, including encouraging private equity. I've seen some emergency incidents in our company who sharing the encouraging private equity is really harming quality of health care for people in material ways. So that's something that's on our radar, and if how do we update to be able to do this? Recently issued proposed updates to our heart original form. That very it's basically information that provides from their condition. Heart changes gives more insight into the type of role strategy that you're making. So you want one web of it from 3 roles to down there. So it's something we see.
Questions on the topic of safe or I yield to present all.
I was not trying to attack the ethics of your officer. I was trying to point out the hypocrisy of those on the other side who say that you have conflict of interest and don't mention the other issues that may exist there. I just want to go to evil actor because there's one more we're going to talk about, and that is tax preparation companies. For years, it's a maker of turtle tax producers ads promising free tax filing service only to drop into paying, which is why taxpayers pay $250 on average each year just for the withholding taxes. State attorney generals have run taxpayers money from into it. FTC is also taking cash. Can you speak about that?
Absolutely. So last year, you see a broad students in where regulated practice that are laid out in our claim is still paying that complaints of safety, but then ultimately not being fully heard.
Mr. Chair, and Chair Khan has been with policies related to diversity, equity, and DEI. Advanced to the FTC in here. Last month, you implemented an action plan. FTC Bureau of Competition to quote, this case based on allowing the Bureau to engage based on the more current equity and the idea that we withdraw proposals. Well, staff will article on the topic of anti-racist antitrust. Can you explain to a good thing? What does it mean?
That views, in generally, there's a lot of very concentrated on power for all communities, and that the FTC needs to make sure that work system are that if they
Anti-racism is not factoring in consumer protection policy at the FTC.
I'm going to lawsuit based on the Lions.
This anti-racism is not abused. Your watch.
There's a Congress is asking the FTC to look at a particular community or being brought by those we follow what Congress holds to do. Why just all the laws.
Okay, here for FTC recently, ended a very speech does not put any gender and senior staff or agency equity team. Replying Bendolins and the Constitutional House.
Be sorry, sure, please.
Yeah, right. Is it? Okay, is there a agency equity team? What do you hear about that?
We have a same team. There are specific FTC played that.
But it was not in your you had. There's not. You don't have a team that did direct.
Agency, I think, how to make sure that the FTC.
It's just. Okay, fine. Don't be oriented FTC from consumers protect fruits. That you want to what FTC is. Right? I mean, it's like everyone, right? Should be. I guess progressive policy initiative works with detailing ordinance and much of it, of course. Mr. Vote. FTC is the section of the FTC. What it is FTC for in November 2020 policy say that ours is clear of the competition is described as quote ungoing competition merit. And the quote here the conduct not feeling fair and may violate section 5. Following that decision, former Christian Creating also stated, which is quote, the commission has agreed to work to some them as any business that is extraordinary. Eric Cerny as fair is a amorphous phrase to term major. Are you using section 5 for the determine what's unfair and it's officially unfair?
Congress was the text of the it's the FTC Act and it's a competition. We have to go word seriously. Put together the policies and our team look closely. We saw, tried to how of course interpreted what this means and the policy reflect that.
Really quickly, recently, I believe in the process of in-compete agreements and for the competition and it's in effect.
We got any doesn't come on pro review them and determine
how we do for get and all on green. Is that position?
Proposal bands that mirror piece of the evidence on which is not considered part of the sale of business.
Have you run or worked in this business? Yeah. These reason partners is often is some aggressive but their rivals and it's unfair.
Figured here from Okan, but the things we hear from businesses is that non-competes make to compete because if they're trying to enter market compete with the guys blackball workers who not set up the business. So really heard multiple of these.
I don't know that.
Thank you, Mr. Chairman. Beware that found any of the free process please serve street competition will every person as a prosecution. Awarded by President Donald Trump and Williams today here in Brazil. The limit has been made by McCullough at FTC on the sound play, but most of them. This majority has nothing to do with ethics or integrity or everything to do with how the reality you have sued the chairman of the FTC in a way that the best interest of the consumer first. And so you approach the FTC. I want to bring that stuff through, I'll have to use Martin and probably article from June 30, 2023, which is fixed alone, that is recommend FTC chair future Medicaid. At the time, your colleagues particularly didn't vote the economy a lot of my friends about why I was very clear. Only in Washington, D.C., an individual affiliated with no interest in the merger order be accused of violation by members of Congress who have financial interests in the competition or others who have that is under review the FTC. I'll make this an opinion that was issued declaratory of expulsion for the commissioner to see considering the matter, but nonetheless, opine that there was an appearance of impropriety and that individual had financial interest in the company that was involved in the merger. I'm not a propriety of the decisions made by the individuals, but simply open on the data affairs of Washington, D.C. Because for years, we had FTCers who had real conflicts of interest. You didn't have a financial interest in Meta, right? You never worked for Meta.
That's right.
The business I did for the actions of my colleagues and others is that they knew when it was putting consumers first and issuing the monopoly power does not restrain and just unfortunate that some takes him approach. I was part of the work that was done at the department. I was for the parts of regulatory system gesture over the course of several years. We as no part of this last year was built for finding information, which I believe is going to change for ability and efforts of their hard work by paying the fees for actually see the fees for all members. Being seen personally $1 billion transaction, of course, you need to fight workers on it. However, if my particular facilitating the annual hedging towards.
Thanks for the question, and Mr. Arlene, we much do effort to update findings as you get clear for transact or hurry on back and work. We are on the speed people to monitor person, so that will be meaning.
Well, I said for the person who will take problem on the bill, the rest of the who has been mother house line on side, and we can you Madam Chair, your comment on that.
Chairman, today's contact you about mergers between companies. That's one thing of contact Apple is so in course like monopolistic business and thing. Creating box lab you asking for an update because in November 29, 2001 is 7 months ago. FTC ordered retail sales and good by detailed information if you see the cause on supply chain disruptions. And I appreciate being able to give something, but in today, like, what have you found, and are you going to help these folks explain about they can get us or this discriminatory person not based on data, nothing different sizes here today?
Yeah, this is such an important issue, and we've heard from independent folks as well, and are informed or digital today. We're going to have digitally as we can. It's going to max time firms don't have an incentive to give us all the information we need as quickly as needed, but are moving ahead full speed and happy to provide you with what we found so far, and Bill will be looking to make the public good.
Soon, 17 months, you have to give me. I understand it takes some off too. I hope we get that very soon. Because many of us pre-confirmation warning letters. On August 30, the FTC announced they would send warning letters and transactions in the whole state within the time provided by the statute before the deal closes. Now, why should people need to regulate this because it's you to your job? These so-called reconciliation letters have intent by the FTC.
The statute is only 30 days, so the deal to try to need to investigate further. As deals become more complex, that can be very, very, very high long. We run businesses if we don't act in the 30-day period, they can admit there are no issues there in concerns. We had to support on notice about the very transparency. If there's a deal, we think raise concerns, but we need to act within the days. We're doing that. Again, to make sure the market has clarity on it.
Commissioner Policy suggested within the first 6 months of the project over 50%, especially whether the U.S. investigation actually remained open and whether this approach was simply tactic error. I'm worried that whether tactic or not have a significant effect. And then one is that you never tell whether the case is closed or not. And if that's being, stop, I'm sure that would be helpful to Americans. Let me, I want to now yield back reign my touch term short.
Gentlemen, what FTC attorney Pope Rowe confirmed no one from FTC to reproduce out with program explain the contrary. There were suggestions that was out to be testified that FTC the fact find that the FTC selected and mixed with her that community all sorts of doing have the work what and this absolutely do and so to her use of debt. FTC was at that the take to roll from so on hand you're arresting her and sending council to be better you want and fighting out we're going to tell you that's right and we got weaponization government this one state said tell all the journalists to do that's what we're concerned about Ms. Khan. That's what has to change. You kind of I'm reading motion filed in court. Your lawyer's deposit. He think you said the and you didn't know who it was. Did you self need 12 listed?
We're fortunate. A lot are underway. A lot of this work is delegated to the staff that are able to move quickly and nimbly to make sure.
If today you knew you're going to question this, you don't know this. I find missing.
It sounds like it was a late break development this morning. It's something on radar. People reluctant to weigh in on it setting without looking at yet. Happy to take it to the run ending daily.
Not on radar that you told based on testimony of the side that would be retaliation to get out of the agreement.
Thank you very much. Unanimous consent. Enter into record. Mr. Hope and Exfil owned by recommending FTC Chair Committee. Thank you, Mr. Chairman. Thank you for being here for speaking on the day of the important work that the does say consumer crackdown companies that would exploit that. I perspective as a grandmother, I hear about a senior business consumers generally. In your written testimony, would like FTC work to protect the judiciary fraud, included fraud like opioid covered, and risk factors from such an example because there is some other ways. Apologize, I'm leaving table. I'm big trip plans. I would not be here with regard to climate crisis. Give you found late. I would to ask you about the opioid. What FTC doing? The FTC returns $60 million people suffering from opioid addiction, and you know the crisis, flood opioid should be safe. People die that year of overdose. At 3 people, you tell them it works. Work. Consumers may this case $16 million with rectification. Can you help in that area?
Up to it's a new area give us another open lawsuits using so we make sure that if money or seeming petroleum no doors facility are actively to prevent that deception, things for hardity, we found the ranking was affected and opioid recovery we run action also that deception go did recovery also legal jury authority. So we're working hard. People are receiving way that our legal authority and getting that.
Thank you. I'm hoping you boss way for full disclosure of his unmilitary 10 years recovery from Open. Lost too many to this spell, and the facts are so egregious. It's very upsetting. I wanted to move to have some time. Mr. Banchers, the behind consumers don't really know what they're all about. They're middlemen are to determine patients' access to medications as well as price and pay. In this role, PBMs have the power that are part of the reason consumers pay more than they should for generic. The FTC is doing around the issue of PBMs and disclosure to consumers backing down on the price hike.
Times behind the scenes, people are clearing on their decision what medicines be on to when with the formulary. And she suggest that it's between drivers and the PBMs meeting low cost generics off the formularies. What means in practice, they're low cost option go into pharmacy not be able to having paid more the brand so it's not a statement of your concern that I'm looking at.
Yeah, and when the FTC has weighing effectiveness in writing that information.
So we'll include you made by each of the FTC acts. Robinson having also paid for type facts. We receive Robinson acts we're laying out our authority making sure we're using them to arrest these critics. I'm here from patient that we have been able to life saving medicine penalty because attack. So recognize the urgency of this.
Again, on behalf of consumers and senior kids out here who work here in our team. Yeah.
Thank you. Keep it here today. I say I wrote down today. I think I quick right. Not only was it I discussed the matrix, but also privacy. If only the leadership believed and acted the same way, I'd be happy. I'll ask you first about the EU's Digital Markets Act. You commented the plain and responsible claims question. Yes, I think you said how many employees or personnel are working on the Digital Markets Act?
You is
that going to happen? Observing what's the role there? Is an implementation of a new law. So how does that impact a trust in the United States of America?
These notice are Europeans working on implementing to work there. Focus on supporting the laws, these types of details across.
That's the question I'm looking for. I'll move on because always 5 minutes is ridiculously absurd. You can't get a full answer for a question. So I'm hoping that maybe you or your team will respond more fulsomely to why some there, even observing the implication of EU law that is not here unless your team supports something like there. I'm familiar with the name of Big Law. Are you familiar with someone back yes, right there? So I from her. Interesting. Claire. She's calling equity inclusion anti-risk agenda antitrust enforcement. Yet, antitrust enforcement typically is focused on the consumer welfare. Right? So you agree with Mr. Commissioner Slaughter contribution anti-racist putting under 10-4.
Sunday, just accused of Chairman Long, Commissioner Slaughter, she thought so hard how to make sure.
Just film my evidence. I can let her turn my head to our question.
She started on these and won't for her. The way
I'm asking whether you agree that this is the appropriate approach and when it's a defective approach from the consumer.
So we thought and were charged with that description of the petition.
So not answering my question. My question is if you support and agree with this new approach, which would be the consumer fair stand to agree with call for equity inclusion races as a basis who is any anti-bias.
Again, we examine solutions.
Can you name the law did Antitrust the moral and equity and anti-racist standard?
The statute word will close the consolidation law.
Can give you a facility being the consumer standard and letting the anti-racist standard.
Constantly right there in based on the rules and was saying the developers were worried that countries not or to be.
That's right. That's from that is how the consumer standard evolved. And now if we're the inclusion based and use that standard, but move to string and try to stand. That's what I'm trying to make. And that's been responding. I guess they may whatever respond in the future. So a chance to get the bottom of that. I appreciate you being
Thank you, Stan. I want to start by thanking Congressman Doug Gates for the comments earlier. I was pleasantly surprised to hear comments with respect to the FTC bill legislation on this. All that I think important legislation could be very useful. I know we have had hearings on that. We've had a lot of hearings for weaponization issues and a lot of hearings to protect the administration. We have had hearings for legislation impact on people in the market, and how many brought up to me. And we had two hearings. We had one together that dealt with agriculture issues, meat packing, but it wasn't explicitly an antitrust hearing. It so happened that wits at the table noted the big companies running the ones that are pressing all farms and increasing prices. But I wrote the approach to try to have concern, but nothing come back yet. I would still got matters pending in the United States here for your commissioner, from some BBMs, big master blue, co-option merger, the that we have. So could be an interest that no hearings need those issues whatsoever. So I know this is an oversight hearing. Might mean we take a moment and over ourselves on what's going on the subcommittee. 2 minutes ago, it was raised about a thing that the FTC issued. I guess the comment was over. I did want to raise this the Judiciary Committee on May 25th, 2023. A document made to the process. I'm quoting, all communications between among the processes in the Revenue Service or leading to any investigations by the justice and revenue stars from May 1, 2023 to the present. Now, we'll set for effect for a moment that will include grand jury materials potentially to 40 can over based on a letter like this. But if you're a rocks, make sure we're not asked, because that is beyond or broad. I put one out there, a lot of presidents made that. The administration, not just private companies, whether inside the rocket or not. I think it'd be very where you not repent and represent everywhere. And I did want to close with this one to respect to the rest of that's a bit. And I think it's been addressed in the opinion crystal clear into yourself. And in fact, said it's a motion to found them that it wasn't necessary or even appropriate. But at the same time, maybe is ignoring one of the most obvious issues with respect to ethics, and that's with respect to court. We have members send a letter to the committee chair. These are the issues we've all heard. Justice Simon, the ability to property for his mother and taking him trips, and a lot of us had similar sort of issues. Similar to both Speaker and the committee chair, asking that we could look at code kind of the Supreme Court justice, that we should consider whether there's a rule in place with respect to refusal for a member of Congress. To my knowledge, in Justice Ladder. More importantly, no steps have been taken on issues that have been made by the conduct of us, and that's just the beginning. So I would be unanimous to have, and I bet from Ted Justice himself, and Daniel Budlaw, I think, Samuel Leo Whiteley, and William with just the EPA, and the letter from State April 18th to have a conflict Jordan, the office member, but that's all easy made Harvard.
Objection. I'm California's gentleman's objection.
She's on the FTC because the range of concern over undischarged duties. What caught my attention was the censoring of her dissent in the activities. It's severe disagreement around here. Of course, we'll go right over to this committee to demonstrate that. But we saw differences by freely exchanging our view, comment on this possible, very truthful lies, some from folly, society depends on people in different styles. And she studied drug law. Keeps from controls, and conduct with her.
So I agree with the debate is difficult. On the FTC is malversation and really internal discussions and debates.
Obviously not, because her comment was how do you say that?
The way the procedure works, I was all off from decisions. The jury of the complaints, they were a non-health permission, building staff analysis, and verified by word process that balancing quality, generate administration, said don't go that to analysis, we don't initial.
Any sessions with colleagues?
And that's what we all from reading.
What do you say is the role of government in trying to disinformation, or for that matter, hate speech?
I see that advertising, so I guess, if companies that's made in America, but some in China, that from perspective
you were discussing Twitter just an hour ago. Do you see the government have any role in determining this hate speech?
We're involved that, again, we're focused on just advertising USA fraud, and that's really what we're working on.
What's your view of capitalism?
Excuse me?
What's your view of capitalism?
The FTC's job is to promote.
What's your view of capitalism?
Could you explain what you mean by that?
That's what you said.
So I think open, competitive, resilient markets are American economic success, and the FTC has the playing a really important role in ensuring that markets are open and competitive, and positioning America to compete globally.
Of course, the capitalist system is that consumers every day, with every dollar they spend, the economy will reduce the price they're willing to pay. Do you see a role in interstate affairs?
The role of the FTC for one of referee, we know that in market, or the market silver, but outcomes, the maker, company, rules of competition, a job that comes to the FTC, and that will do.
I do hope to talk to you about this since you heard today, merger and general occur when companies are trying to improve their efficiency, productivity, and hence their ability to serve their consumers and the growth of the economy. And it helps consumers. I should be very careful, and your colleagues, very careful and very humble to your powers, because decisions harm the economy here, also harm the administration. They pursue my authority decision creation, they know how to do it in own life, and you have lots of television.
I'll appreciate you.
Thank you very much, Chair, and thank you, Chair, for bringing us today. And also thank you for mentioning your work on behalf for in your opening statement. This is a very important issue for our health industry, and as you pointed out, for the health of consumers. It's alongside with biological to address abusive and exclusionary pricing practices of bees. Access to prescription drugs is a critical issue for all Americans, and hopefully the FTC will take steps to address ways that PBMs take advantage of and product innovation. I know you got a question from Congressman Dean a little bit earlier, but it would be much more specific. FTC is working on a 6B study since June of 2022. When do you anticipate completing that study, and do you have interim conclusions or findings you share with us today?
As I noted, we require the work, but it should mean that patient access to affordable medicines and that they have to contact. So, moving case, we're dependent on companies to provide us information today. In general, strictly, some of the agencies have been 4 years, 5 years. My goal is for us to be able to mix diversity. I all know that a matter of course inquiry and identified practices. We turn our on model without being able to look on some of those levels and indeed on the practice.
Great. And also, you recently expanded the CBI investigation to include group purchasing organizations, or GPOs, have opened in recent years. How does the FDA and PBMs be using these GPOs? What kind of harm could they have in market for affordable drugs?
Entities are considered fairly central, minimal, the general because we want to make sure they're getting a full review of technical practice. And also, we all read stories about make sure we also receive full of GEO and may also attribute some of those shortages, and that's the thing that as well.
Great. And given the PBMs currently control 80% of the market, I'm interested in how consolidation in the PBM industry affects patient access and costs. In addition to PBM consolidation, the largest consoliders also own their OPMs. So a great deal of vertical competition. PBMs set out to cost to full discounted drugs, so patients don't see the discount that are made. We know some plan OPMs where patients still only effort from these providers to use access. How are you seeing consolidation and vertical integration impact patients?
Yeah, that's true. I know some use much routinely from we open technical examples, seeing about being we see thousands of public comments. Some of them could give the PI rebate. So I could instances where there's conflict between what PBM's own interests and some patients that know her out.
Final question. Do you think role comes in the area as well, not just where it should be?
Absolutely, and this should probably temporal rights for men. I get a hand on the moment.
Thank you, Mr. Chairman.
Only back to recognize.
Chairman, I'm Contact to the board of the committee. Would you commit to provide all updates with respect to the live PG or merger and Ross looking into what reserve that?
Starting to leave our partners just
The FTC is having some look into what's going on, at least the United States, but it's about the concerns about it. And I'll yield.
Thank you, gentlemen, for yielding. It's kind of earlier, and I believe gentleman from Arizona brought this people's privacy. I agree more. And as we talked earlier, I think there's bipartisan support to deal with this sweeping up of data that happens, and Sarah is FBI purchasing the data. That's very important. But I would say for the very important too. Do you agree?
Absolutely.
And John California McClock asked you, what's this information? And you said, your opinion, was that
Start of job at sea, we're focused on and fraud and sort of thing.
We wrote down law article, this is Twitter, so the years I've said information. We're talking about that, disinformation.
Happy to go look at mirror, but as part of our BI, we've seen how fraud and scams can times world free on the media website. We launched an inquiry to some of the crypto scams they were worrying on what we be making.
The process is in the piece of road, digital business such as Twitter, you still think to me. Who decide that? This is disinformation. This is about social media companies and post inform who disinformation was.
So there's some FTC or fraud inception. There's a standard about what constitutes fraud. This is about.
My concern is the staying tech on Twitter and the other day platforms to not be taken down, plus allowing sharing information, not something just a decision as a but it must hack the companies who and technically they're doing a change for doing that and particularly like robots so saying this is don't.
I'm at Bernie the so the FTC should not accompany all the files that is following the law. That's for letter post.
I'm not information. Whose side is information? Is the government?
Concentrated power, over concentrated power, the ability to who heard, doesn't heard, many types of decisions. That I consider all of us, and the SEC job to be pro.
What kind of was getting censored? Side kind of written by the way.
I'm not saying
You know what kind of speech gets censored? Court said conservative speech was all the suppression was all it's not Republican trick. This is the federal judge have these facts laid out, the facts and all the opinions, which said conservatives getting censored, and that's information.
Simon, I fully understand why, given the extreme power of these speech platforms, people will rate and word the best. I couldn't agree more that we have a handful of people making decisions about what gets seen, what doesn't get seen.
You think that for to dive information, what's not?
Because the FTC are just open shit, more people making decisions, and that could lead to the censorship period.
Just you're not going to see. It's George. So goddamn who?
Thank you, sir. Good afternoon, Chair Khan. I'd like to have you first today. Redstone, Enduring businesses have an opportunity to grow and thrive is essential for our economy. One of the most of practices of a country that is built on successful innovative ideas. The nation of people is so vital, and the opportunities of society. These reasons we must all can in our power to support competition, investment, and invite employees to crush their opportunities. But trust framework support small businesses to ensure that they are not intimidated into
Association and empower people by allowing them freedom to workplace, rest and train work to American workers against monopolistic efforts to lower wages and limit benefits. That is why I wonderful having you today. Thank you so much for being here and help FTC. You have actually championed important American trust and conditions for years, and our needs some stronger. In fact, the U.S. is the highest post-pandemic growth nation in the G7 and lowest inflation, with a total unemployment rate of 3.7%, and that's never checked. As spoken earlier, more successful fair competition in the States, conducting workers and unfair practices. Competition and growth, first competition on consumers workers and economically in the country. Over the past 20 years, you've seen consolidation across all parts of the nursing home industry, tech industry, agricultural industry. Can you please comment on how that is applied in context of large mergers that affect large mergers in the place?
Congressman, mergers between two large firms if they're competing market, that make it more difficult for more entrants to come into the market. We see entry barriers can raise independent firms, small businesses have difficult competing on a level playing field if the merger is leading to market power that allows the merged firms to get special type discriminatory benefits that are not available to us.
Thank you. Six terms. Congress has been having the role of big tech companies and their exercise of dominance, which has allowed them to profit and leverage their big power smaller companies and competitors. Can you talk about steps that you are taking to ensure smart companies, especially in the tech space, get a fair chance to compete against or entrenched companies?
The FTC has been looking closely at digital markets. Commission, one of the first sections that I joined was refiling the FTC's amendment against the FTC that Facebook position of Instagram was that for had to really maintain it on in a way that locked out didn't really hurt consumers at the end of it. We're doing so clearly mergers and accidents to make sure that if we rate the accident, we're going to comments and allow firms to maintain the knowledge for acts there.
So under the FTC had endeavored to restore meaningful access enforcement over the last years, and in the FTC has made some powerful enemies. Yeah, I agree. So it's larger and to trust bigger competition and trust enforcement to deliver innovation and better services rather than enabling entrenched gatekeepers to grow through acquisition markets.
Absolutely. Because shows that promote fair competition. That's what best use innovation and analysis.
Thank you, Matt.
Very nice gentleman with conference. Very good. If I'm mistaken, you heard some name and you say I don't have a question for what's her name off in the advice that always speaks all the way. And but nonetheless, they are interesting people. And it was so interesting to hear yesterday. And the director of the FBI was here, and he said, "They work in front can't change how they go about operating. When you have a federal agency, the FTC, calling at your front door, and they say, gosh, maybe you should do things differently. They pay attention. Now, these of the men originated, he's in a box and here that in regards to the FBI, when they come calling, you pay attention, and censorship happens from there. And I hope that you are cognizant of that as you about doing your business. Second thing that I would say is that you talk about, entrenched gatekeepers and that barriers to entry that built in Washington, D.C. for the last decades are significant. And I go back to that were a decade old. Funding Obamacare, other than being Dodd-Frank, we see probably least entrepreneurship happen in the healthcare and finance banking industries that we've seen in decades. Because barriers to entry are so high. And I'm sure you will respect that. While building relations here, while passing laws as happened over a decade old, and Dodd-Frank, it's harm America. It's harm entrepreneurs. It's harm Main Street America. When you longer have a bank being consolidated into something that's bigger. So you may say that we're going after these things. Have we created them here? And hope you won't participate in creating additional barriers so that entrepreneurs can't participate in the side of building United America for the last 150 years. I'll be back.
Of course, I just using a little bit. Jim from Georgia mentioned that you being under from the beginning of an hour ago, and so you put your fee because of color. People that
I'm focused on really.
I know, but I know that's true. Funny hearing, I was back. It's not funny hearing the other day. We gave a gentleman a pretty thorough, keynote full questions. I hope that you know us to do this in this year. I hope you feel that way. I was wondering if you do. So you know, yes.
It's just under who time is
Little bit of time to clean up for. Thanks, Vivi. Just make some future like.
Among committee issues, and I feel
one side of the change when it's said, no, that it's over. That's what they want to move on. Roll call. Have you heard about that? The real big, you went out way, you're affecting people, sophisticated, people, and probably all of them, I mean, security, bomb shares, the real big problem. I will fantasy Korea, love worth, and love worth, just about it. This one, not only for.
St. Louis Organization support of the right to consumer small business network public report read that the rights to patient easily and community as and I reach surface as staff on this committee. Your groundbreaking solution and trust law and issues any regular conferences every year. This has an important role to protecting our economy from the harm caused by greed, corporation of the profit, and power over people. Look at big pharma, big oil, and air concentrated industry. These companies, the profit upset executives behind them have abused power too long in time that they held accountable. So we absolutely love the working consumer. The FTC can is trying to help underuse it. And I appreciate that it makes a real difference in communities like mine. For example, reading your FTC lawsuits have in more than $33 million, provide to 170,000 screens. In 2020, the FTC provided $8.6 million PMC, including St. Louis. Still, for real people, hard work greed. It's food on the table is a rule overhead, is clear health. Analysis the proposed rule beyond deep agreements. Chair Khan, banning agreements estimated to raise over $200 billion each year. To also we have of 9.1%. Is that correct?
We lay out articles making those to the FTC back, yes.
Enough money in pockets of peers around people in particular. Can you explain specifically how hang on key agreements and workers will pay more?
So our staff is looking closely here at this policies. We've seen that states that have limited non-compete are able to ensure workers are moving around. One form we still see that one companies non-compete. We've also seen that being jobs, being able to move really to jobs that have better opportunities is a mechanism where people get higher wages and employment opportunities. These works in place and you them that need not go around even though the messages from better cases that works.
Thank you. And as we impact those lives. Republican diets, the days of the princess and those corporations talk big game about 5 for every 8 people in the show time and what they're doing.
That's what the tax is about. So media, there is nothing unethical about the source of business. Unethical about working about their power and companies like mine, Meta, Twitter. There is nothing unethical about putting principles in the practice. What unethical is being a part of the greed that's leasing our community. It's unethical to hypocrites and selling out. That's the real scandal here, and we need not forget it. Bottom line is that corporate monopolies are cyclical destruction. Who claims to enforce consumers must pay assignments are large private companies that care more about profit than people. We need to aggressively enforce our antitrust purposes. Congress intended. We also need to be a digital economy dominated by billionaire-owned for-profit companies. You have never tried to hide who you are or what you believe. I honor you for that. I thank you for your leadership. I look forward to working with you, agency, with these critical issues. Thank you. I go back.
Recognize the gentleman from North Carolina. Thank you, Mr. Chairman. Ms. Khan, is this working? Yeah, it's here. I just want to warn the FTC. Well, it was disclosed the FTC sent a civil investigative to OpenAI. Are you familiar with that?
Public information that was appropriate and be correct. I'm hesitant to share things on
It's on Twitter. And it seems to be asking, among other things, for whether ChatGPT or the process have generate statement about things. Can you explain this matter with the authority of justice that someone's getting
There's a lot of concern we're seeing in the AI space is that IPs with us are being huge for voting. There are no tax why that's being earned in these money and for hours where people send information showing up response to an inquiry for statements that's a type of fraud institution that we're in.
So it's probably you said on Facebook and Slender or defamation and I'll come to that exactly I understand. But is we each there about that based on what you
absolutely true. We all recognize we're most on
so like in particular your colleagues about releasing information was that also under the FTC because it's generally put you guys in charge of sensitive information.
Yes, FTC on various practices and of petition.
Okay, and that's not just the people which 5. You guys think you dare and come to the rule that you might suggest under the competition or for sex rights or everybody in law for line. So it's not really actually remember non-compete because this position coming on in the process then once the comments or you guys decide that you will decide whether to buy a resource basically. And so that gets contracts law for years and in North Carolina have rules different inventions laws and statutory some over time and 6 over the country. And they're long time. So what you would do with all that contract law in one swoop, it would
increase.
It would create what?
It would be creating a provision that would be meant that these competes are ruled unlawful.
So and it would be sales. I know some of your proposal so it would be, the here or product of unqualified power, but rule would be per se, except for capital. Majority would be even the people involved in those contracts.
That proposal, we did get part of our notice of proposal about their adjustments.
And I don't get them just if you take an maybe a target, you're going to turn out conservation of not based on contract legal power. 30,000 judges of rules, 550 state legislators out there in the country, global chambers. You know, as the majority on the FTC make such ruling that some should about how you.
So we examinations pursuing what we're taking us when people for when the mission for a whole set of procedural practices that go to like the hundreds we have to use public input. There's so many tracks that need regular activities be engaging.
But you did what right?
Certainly, contracting staff in debate is actually fine. Should step is actually what should be fair. And determined, this is available ways to do more money to split. Key to their key state that parts are evolving, and are evolving. They can make sure there's actually very pace. So this was determination and decision that constitute that which be the act of law.
Recognize the gentleman from. You may begin my question. Noticing our comment a few times today on the third-party auditor who deposed as part of your lawsuit. I think it's really important to point out of the different this shit felt last night. And here today, I think this really but after appeal that the evidence supposedly can say was at least a time manner. So important main of that. Thank you for being here to the Twitter and I really appreciate this morning. I'd like to touch on a extremely timely and controversial issue with artificial intelligence, and specifically, I think thoughts on generative AI and competition. It's tough to imagine online platforms gaining more power. It's that big tech to control their own AI systems and access to cloud data are positioned and I don't have a constituent back and from. So what I ask you is, how could AI technology lead to an even more consolidated internet landscape with fewer choices for consumers?
So first of all, these moments of technological disruption, when you have to change the these moments often provide the opportunity for disruption, for displacing the existing incumbent. And so there's always a chance that will be the effects. I think, right, that these technologies we see inputs or wider that really favor permanence and scale. So need to keep a huge amount of data. The models are recently published closely, but it absolutely right. We all need to be very vigilant. I'm sure this informative technology further consolidating get power and could really accomplish.
And how would a firm use AI and cloud access to illegally extend their power? What would that look like?
So, I want to get a little bit of like traditionally the type of concern that you might have is if firms market power conditioning access to one's technologies on firms being also by other services, those types of time agreements, especially where including or effect can be constrained or dangerous.
And are you concerned about similar to the news?
We're particular opportunity.
Okay, last time here, I almost on other shift patterns. One of the nice where it's actually impossible to avoid. TCC games like using series of digital tricks or all people trying with that and that to prevent people from this is the thing I hear a lot from Mike's with shady report that more confusing digital tricks people who might like their personal fame. How kind is it on to see our patterns?
Actually, we're working that is that we can use tricks after report going into the star how to see which tracks and training or people in ways they're not risking to make. And so we make sure we're wrapping how to working, we've been bringing on knowledge that will tend to deep or the figure out the gossip. It's continue to be an area of stress.
something that's really struck me. It is essentially about taking away people's choice. When you're not transparent about the ways in which consumers are being trapped into saying never being able to cancel them, away their ability to vote $1, which is something we've heard about, is here today. What effect does that have on competition, privacy, and innovation? Just briefly.
We want to make sure that companies are competing honestly. We don't want honest businesses lose out to firms that are engaged in patterns of these types of deceptive practices. So the consumer protection dimension, as you also competition dimension.
Really appreciate it.
Thank you. I recognize the gentleman, Mark.
Mr. Chair, and you, Dave Faith, I just very fails to do the entire conversation is interesting. Appreciate your thoughts. I'm this up. Do you agree with Member Wilson, the side expertise, some of the jurisdiction to pursue these goals, not energy can. For example, on health safety prices, only that was a part of the focus of FTC. Because I'm just the FTC told, or maybe I'm wrong.
So you said warranted safety, health, and privacy, right?
I think these folks on the scene and again, confidential to the public, including on under also or health prices.